Good morning, everyone. Welcome to the third virtual meeting of the Zoning Board of Appeals. First, as many of you may know, the governor has signed Public Act 101-0640, making certain amendments to the Open Meetings Act so that we, along with other boards and commissions, can continue to host virtual meetings during this COVID-19 public health emergency, provided that certain conditions are met. Therefore, I am making a determination pursuant to the newly created Section 7E2 of the Open Meetings Act that an in-person meeting of this board is not practical or prudent. Similarly, I am also making a determination pursuant to the newly created Section 7E5 that because of the disaster declared by the governor, it is unfeasible for at least one member of the Zoning Board of Appeals or its chief administrative officer or its chief legal officer to be physically present at the meeting place, inasmuch as there is no physical meeting place. Second, and as I mentioned last month, I, as chairman of the Zoning Board of Appeals and pursuant to an ordinance adopted by the City Council in response to the COVID-19 public health emergency, issued emergency rules governing the conduct of remote public board meetings and provisions for remote public participation, which are posted on our board's website. I encourage everyone who frequently appears before the board to familiarize yourselves with these emergency rules, as we do not know how long the COVID-19 public health emergency will last. In line with these emergency rules, today's meeting of the Zoning Board of Appeals is a virtual meeting that is being simulcast to the general public via live streaming. It is also being recorded. We've established these virtual hearings in keeping with the mayor and city council's goal to continue government functions while maintaining transparency and public safety. But there are technical limitations to this format that we must collectively manage, particularly with respect to the presentation of new evidence during a hearing, the ability for applicants and objectors to resolve objections or amend proposals during the hearing, and the participation of large numbers of people. As a result, any material to be presented to the board, whether by applicants or members of the public, was required to be submitted in advance of today's meeting. And in addition, everyone wishing to testify at today's hearing, whether on behalf of an applicant or in opposition, was required to register before today's meeting. Since this is only our third virtual meeting, I will go over a few things for those who will be participating. Number one, we are operating under the emergency rules. So for all applicants and their attorneys, if you did not send us your exhibits by the cutoff date and time, you will not be able to reference them in today's hearing. Number two, all participants will be listed as attendees within the Zoom meeting until your matter is called. At that time, we will transfer you to a panelist. There will be a short switchover where you will potentially lose that feed, so don't be surprised by that. Number three, once you're set in as a panelist, please present your case. Board staff will be presenting the PowerPoint exhibits for everyone as we normally do, so you will not need to manage sharing your screen. Number four, please be mindful of background noise and please mute yourself when you are not speaking. Five, in addition, please note that we have a court reporter preparing our record, so it is important that two people not speak at the same time. You might see me muting you or somebody else just to sort of help manage that. Six, if you are an active participant in this meeting, please do not watch the live stream. This will cause audio interference. I will repeat that. If you are an active participant in this meeting, please do not watch the live stream in tandem. Seven, please make sure you identify yourself whenever you are speaking. This goes for attorneys, applicants, and board commissioners. Since all of us are remote, we and our court reporters cannot always see who is talking at any given time. I will also be administering oaths for each witness individually to accommodate for this. 8, if an applicant or anyone in opposition to the application has any technical issues presenting their case and is unable to proceed, we will attempt to continue the matter until the end of the call to create time to resolve those issues. If that is unsuccessful, we will have to continue the matter until a subsequent meeting. Now, I'd like to call this virtual meeting of the Zoning Board of Appeals to order. First, I am designating alternate member Timothy Knudsen to fill the position of regular board member Zurich Esposito. Next, I will take a roll call vote to establish quorum. Commissioners, after I call your name and you state that you are present, please verify that you can hear and see me. Commissioner Saul.
Yep, present.
Commissioner Knudsen.
Present.
Commissioner Toya.
Here.
I am present and quorum is established. The minutes of our March 20th, 2020 meeting, as such meeting was rescheduled for May 15th, 2020, and our June 5th, 2020 meeting have been distributed. Unless there are corrections, I move that we approve the minutes as distributed. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
I vote aye, that motion is approved. I move that we approve today's agenda. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
I vote aye, that matter is approved as well. I'm going to skip my regular general announcements and trust that the attorneys who frequently represent applicants before the board have internalized the revisions we made last year to our rules and what we expect of findings of fact forms. Instead, I'm going to discuss the proposed amendments to the board's rules of procedure that are on today's agenda. Some of the amendments are minor. We've added the board's website and a new email address, for example. We've also made some adjustments in language for consistency and clarity. If adopted, the reissued rules will be posted to the city's rules webpage, and there will be a link to that from the board's webpage, just as there is now. However, there are 3 proposed amendments that I want to address in detail. First, findings of fact forms for variations will now require that applicants provide pictures of the block. So please be aware of that. There will be new forms up on the board's website next week. The new forms for variations will also require that all reasonable rate of return data, such as cost of land, cost of construction, sales price, and anticipated profit margin, must be attached as a document to Exhibit D. Please be aware of that as well, although that's just a change in the form itself and not a change in the rules. Second, and we have that slide up with the exact language, the rules of procedure will authorize me as board chair to promulgate emergency rules. For our record, the proposed amendment reads as follows. When, due to public disasters or other emergencies, the state of Illinois and or the city of Chicago have, by executive proclamation or order, legislation or otherwise, limited where, when, and or how many people may publicly gather, and or the state of Illinois has suspended or modified portions of the Open Meetings Act for the public health, safety, and welfare of the citizens of the state of Illinois, and or the city of Chicago, the chairman shall have the power to promulgate emergency rules, including regarding public attendance and participation, not inconsistent with such directives from the state of Illinois and or the city of Chicago. The secretary shall ensure that such emergency rules are posted on the board's website, and such emergency rules shall last until the state of Illinois and or the city of Chicago rescind such directives. Both the Chicago Plan Commission and the Chicago Landmarks Commission have passed similar amendments to their own rules. The purpose is so we can establish and maintain emergency rules in the future without holding an in-person special meeting for the board to adopt them at a time when such a meeting could violate social distancing orders. This was the situation we faced in late March and early April. If we adopt this amendment, please keep a lookout on the board's webpage for updated emergency rules, as again, our current emergency rules will expire next week. Third, and we should also have a slide up with that exact language, the rules of procedure are going to clarify that the board may, from time to time, adopt supplemental rules for certain issues. Again, I'm going to read the proposed amendment for our record. From time to time, the board may issue supplemental rules to these rules of procedure. These supplemental rules shall have the same force and effect as these rules of procedure, but will address a more discrete practical problem or issue. If the board finds that the problem or issue no longer exists, the board shall rescind such supplemental rule. For instance, the board may decide to promulgate supplemental rules not inconsistent with the zoning ordinance with respect to what the board expects of applicants for cannabis business establishments, including but not limited to the community meeting required by section 1713-0905G of the zoning ordinance. The secretary shall keep copies of all supplemental rules issued by the board and shall ensure that all current, i.e. non-rescinded supplemental rules are posted to the board's website. The purpose of this proposed amendment is so that the board can provide guidance not inconsistent with the zoning ordinance of what it expects of applicants in certain situations. That naturally leads me to another item on the agenda that I'm going to discuss now. If the board does adopt the proposed amendments to its rules of procedures, the board will then take up a motion to issue its first supplemental rule, which is now on a slide for you. The supplemental rule will set out what the board will require of all community meetings for cannabis business establishments. As many of you know, section 1713-0905G of the zoning ordinance requires that all applicants for special uses for cannabis business establishments hold at least one community meeting in the ward in which the cannabis business establishment is proposed to be located. Due to the COVID-19 public health emergency, many applicants have been asking board staff if the board can waive this requirement. As it is a requirement of the zoning ordinance, the board does not have the authority to waive it. However, by issuing our first supplemental rule, we hope to provide clarity as to what we will consider an in-ward community meeting during the public health emergency. We also are using the supplemental rule to reiterate portions of section 1713-0905G that applicants are apparently finding unclear. So if adopted, the supplemental rule will, 1, remind that the in-ward community meeting pursuant to section 1713-0905G can only occur after there is an application on file with the board for the proposed cannabis business establishment. 2, remind when and how section 1713-0905G requires notice to be given for the in-ward community meeting. 3, require that the in-ward community meeting have at least 3 physical sessions so that the maximum amount of persons who wish to attend physically can have that opportunity. 4, it will require that each session of the in-ward community meeting have a virtual component so that those who wish to attend and participate but do not want to physically attend can virtually do so. 5, it will require that all notice of the in-ward community meeting provide not only the time and place of each physical session, but also how to access and participate in each virtual session. And 6, require that as part of an applicant's proposed findings of fact, the applicant include information as to how many people physically participated in each session of the community meeting and how many people virtually participated in each session of the community meeting. With respect to that last bit, that means we will have updated findings of fact forms for cannabis business establishment special uses up on the website that everyone will need to use going forward. So please be on the lookout for that. Note that this supplemental rule will apply to all community meetings pursuant to section 1713-0905G held on or after March 20th of 2020. Also, please note that I, as the chair, will have the power to modify or amend this supplemental rule in accordance with further directives for public gatherings issued by the state of Illinois or the city. However, as this proposed supplemental rule is written to apply to both phases 3 and 4 of the governor's Restore Illinois plan, this probably will not be for some time, if at all. If adopted, the supplemental rule will also be posted to the board's webpage. Next, we will start with the continuances for today's call. I believe we have our first requests are for 192 and 197. Is that Mr. Fatikas? Are you making that request?
Nick, you should be able to talk.
I don't know why.
Are you able to hear me? Sure.
Yep. We are.
Okay. So yeah, I actually have 3 continuance requests on the bottom of page 3, 192, 20, and the top of page 4, 193, 20Z, 1909 North Howell. We received a letter of objection from Alderman Smith's office last night. We just wanted to continue to see if we can further the community review process with her office as well as the local community organization.
Are you anticipating August 21st? Is that the request?
If it's possible, we'd like the July date. But it's of course at your discretion.
Okay. So this is 19220Z and 19320Z for 1909 North Howell. Is anybody else here on the continuance request that wants to speak?
We have Joanna Zayden, who was signed in from Alderman Smith's office.
Joanna, you have anything you want to add on that request or for July 17th?
I have to promote her, Chairman. Hold
Sure.
on one second. Go ahead, Joanna. You should be able to speak.
This is Joanna Zayden from Alderman Smith's office. Can you hear me?
We can. Good morning.
Yes, we agree with the continuance for July 17th.
Okay. Then 19220Z and 19320Z will both be continued until July 17th. No further notice will be given. That's 1909 North House Street, July 17th, and no further notice will be given. Thank you. And Counselor, did you have others?
Yeah, I do have others, sir. On the bottom of page 4, 19720S, relating to 1341 through 53 East 72nd Street. There's actually an issue with the parking determination letter. So if we can have another month, again, if we can get into the July date, we should have that issue resolved. We just wanted to make sure we have a letter back from DPD and have our parking count situated.
Okay, and Mr. Risa, anybody else on our radar that would want to speak on that one?
No.
Okay, so 19720S, 1341 to 53 East 72nd Street, we will continue until July 17th. No further notice will be given. And Counselor, that was it for you?
No, I have one more matter, 2 cases. It's actually the first case of the continuance call on page 10, 14420Z. and 14520Z, 1443 West Summerdale. This matter was continued one time by the alderman. We're now asking for a continuance. It's our understanding that there are a number of objectors that have signed in. We just want to be able to take a look at our project, and we'll be prepared to go in July if it's possible.
And I believe we have Mr. Luna perhaps wants to address that continuance.
Yeah, let me promote him real fast. Go ahead, Dan, you can speak.
Thank you. My name is Dan Luna, Chief of Staff for Alderman Harry Osterman here in the 48th Ward. And we have no objections to the continuance asked for by the owner of the property at 1443 West Summerdale.
Okay, so that's July 17th. So 14420Z and 14520Z, 1443 West Summerdale Avenue will be continued until July 17th. No further notice will be given.
Thank you, sir.
Thank you. And I believe next we have 199.
Correct. That's on behalf of Alderman Thompson.
And is there a representative from the Alderman's office that we're aware of?
No, there is not.
Okay. So who is our counselor on that one?
Paul Kolpak is the attorney.
Let me just have him confirm that he's aware of that request and see if he has an objection to it.
He is not signed in.
Okay. Then 19920Z at 2716 South Emerald Avenue, we will also continue until July 17th. Again, 19920Z, 2716 South Emerald Avenue until July 17th, and no further notice will be given.
That should be it, Chairman.
That's it. Okay. Let's start in with our call. We have first up is 12120A for 2737 and 2767 North Cicero Avenue.
This is Michael Addison. I want to make sure that David Samuels and Scott Addison are also been promoted.
I see Scott Addison.
Scott Addison here in St. Louis. Can you hear me?
We can.
Good.
So we're waiting on David Samuels. While we're waiting on that, let me go ahead and swear the two of you in. So Scott, you swear to tell the truth in these proceedings?
Yes, sir, I do.
Michael Addison, do you swear to tell the truth in these proceedings?
Yes, sir, I do.
And I believe we're having Mr. Valenziano and Mr. Ali also.
Matthew Ali is here from BACP.
Matthew, do you swear to tell the truth in these proceedings?
I do.
And Steve, are you online?
Yes, I'm here.
And you swear to tell the truth in these proceedings as well?
Yes, I do.
Okay. Then Mr. Samuels.
Yes, hi, Dave Samuels here. Thank you.
And you swear to tell the truth in these proceedings?
I sure do. Yes.
Perfect. Okay, then, gentlemen, we have your material. We've reviewed it. Why don't you kind of walk us through the timeline and present your case for the appeal?
Oh, good morning, ladies and gentlemen. My name is Michael Addison. I'm here on behalf of the 2737 Company LLC that owns the property at 2737 North Cicero, which is the southern piece. I'm joined by my brother Scott, who is also an owner of 2737, and David Samuels, who owns the 2767 North Cicero, the northern property. None of us are very experienced with this Zoom methodology, so we hope we can present our case clearly. We are here to request these two properties be restored to the zoning status that they had been in place for many decades, a grandfathered use in the automobile trades. You have before you a large number of documents which indicate the great efforts that we have devoted to working with the zoning administrator, Mr. Patrick Murphy, and Business Affairs and Consumer Protection Representative, Mr. Matthew Ali, to resolve this matter. In this meeting, we wish to summarize the more salient aspects of our appeal. I will lead with a general introduction. David Samuels will follow and provide the perspective of the longtime operator of the business at these locations. Scott, my brother, has done an extensive amount of investigation regarding the legal and subtle aspects of this appeal and will provide you with some insight into the most important ones. I will follow with a conclusion. First of all, I'd like to provide some history. These properties have been in my family since the late 30s. I recall as a young boy in the 40s going to 2737 North Cicero and visiting my dad's business there, Columbia Motors. There was a ramshackle building that served as an office for him and his salespeople. In the back, there were a bunch of detailers who were fixing up cars and a Polish mechanic who fixed everything. Fast forward to the summer of 1957, I was worked during the summer with David's father, Howard, at 2767. And in fact, that's where I sold my first car. When my father went into the leasing business, the 2737 parcel became one of the Cicero Avenue lots owned by my grandmother, who passed it on to my father when she passed away, and then to his sons when he passed away. The 2767 parcel was purchased by Howard Samuels and became part of Value Auto Mart, whose main office was across the street. He leased 2737 from my father and operated the 3 lots under the Value Auto Mart banner to sell automobiles. David can tell you more about his involvement. When David closed Value Auto Mart, the entire complex was taken over by Car Outlet in May of 2016. David wrote a lease for his two parcels and negotiated with Car Outlet to assume the lease on 2737. We assumed that Car Outlet would operate the business much as David had operated Value Auto Mart for many years. They paid their rent on time and seemed to be committed to the success of the business. On or about March 31st, 2019, we were informed that Car Outlet had declared bankruptcy and that they had petitioned the court to void the leases. This came as a complete surprise to us. As owners, we proceeded to seek new owners or tenants for these properties. By June, David was negotiating a new lease on his 2 properties, and the Addisons were negotiating the sale of 2737 to an existing automobile dealer in the area. Both deals broke down in close sequence. David's prospective lessee was first to learn that the non-conforming use for automobile trade had been rescinded. This was confirmed shortly thereafter by our prospective buyer and our real estate agent. Until that time, we were unaware of the statutes requiring continued occupancy and business licensing, and that Car Outlet had not gotten business licenses for 2737 and for 2767. I've gone through this background and wish to underscore 2 issues. The Addisons and Mr. Samuels have been involved with these properties for their entire lives and operated as responsible landowners and business owners, adding to the community. The properties were in continuing use and compliance as car lots for the entire period until vacated by Car Outlet on March 31st, 2019, and thus met the intent of the zoning ordinance. We think the following points are critical for you making a fair decision. The Addisons and Mr. Samuels have been damaged through no fault of our own. Viable leases and sales have been derailed, and subsequent attempts to lease or sell the properties have not gotten any comparable offers. The value of these properties have been adversely affected by the loss of non-conforming use. We are the victims of some unusual circumstances and will incur significant damages if use is constrained. Car Outlet followed the law. They got business license on their main office across the street and were informed that a separate license was not necessary for 2737 and 2767. since no sales took place on either parcel. These adjunct addresses were not listed on their valid license, only due to an expediter's clerical filing error. They have now petitioned to correct the record and amend their license to support of our quest to retain grandfather status. This was not accepted by the zoning or licensing officials. There was no notice of licensing problems affecting the zoning status of these properties. As owners, we found out long after remediation was possible. Had we known of these statutes, we would have incorporated the requirement into leases and instituted procedures to ensure compliance. Had we been apprised of the non-compliance in a timely way, we would have acted promptly to correct it and assure car outlets compliance. Cicero Avenue is still an active auto market corridor. Denying this request will not noticeably affect the character of the street. Granting this request will not set an unwanted precedent. We are before the board because we have exhausted alternatives. Despite a compelling amount of evidence and proposals, neither the zoning nor business affairs officials felt it was within their power to grant relief. My brother Scott will go over some of the more salient issues. These are trying economic times. One would expect that Chicago officials be doing all within their power to encourage business to operate and flourish. Granting this request would align with this goal. I would like to now turn over the presentation to David Samuels.
Hello, gentlemen. My name is David Samuels, and I am the owner of 2767 North Cicero. My father and his partner started Value Automart in 1969 and owned the property at 2734 North Cicero and 2767 North Cicero. I purchased the business from my father in the year 2000 and continued to lease the property from the Addises up until the business closed in 2016. Up until that time, I always maintained business licenses for the property, all three properties. And city inspectors came once a year to make sure that I had those licenses in place. I sold cars from all of those locations. In 2016, after my business closed, I made a lease agreement along with the Addisons to the company Car Outlet. Subsequently, Car Outlet filed bankruptcy and the property became vacant for a very short period of time. During the vacancy, and the Addisons and myself put the property up for lease and were able to lease to a car dealership. During due diligence, we found out that the property was no longer grandfathered in due to the fact that Car Outlet did not maintain proper licenses. And at that point, I didn't know anything about that, and I didn't realize that they decided to use that lot for display only. And when I visited them numerous times to check out to make sure my property is in proper shape, I saw that the area across the street at 2737 North Cicero looked like it was in total operation of car sales, but I didn't know at that point. So during that period, Car Outlet was in operation. They sold vehicles, I thought they did at least at that point. And the city never notified me at all that there was, that the licensing had changed. And we had no idea that the property was now considered non-continuous use with no car sales allowed. In turn, that caused us to lose the lease agreement with our new, the new dealership. Car Outlet made all their payments to me on time and was in business on all the properties selling cars. There was no way for us to know that the status had changed. Since the properties are set up to sell cars and are used to design and the use is designed for car dealerships, we had no offers of any kind except the original offer on this property, and the value of the property has dropped considerably. So basically, there was no indication from anybody at that point until we found out when we tried to get licensing that the non-continuous use was over and if the grandfather clause was no longer enacted. And at that point, I'm going to turn it over to Scott, and he's going to give a little more detail. But thank you, guys. Scott?
Good morning. Am I live?
Yep.
Great. Well, I'd like to open on a lighter note on the fun paradox that this grandfather issue literally goes back to our grandpa, Alex Addison, who started on Cicero Avenue over 100 years ago, fixing and selling cars when people were just starting to use cars. I wanted to display one thing. I have his ball peen hammers. If you can see these, I had to put a new handle on one because it was so old. But this goes back to the beginnings of our family on Cicero Avenue and the continuity from my grandfather to our father.
Mr. Addison, we only have you on audio. If you're trying to present video, I think you need to turn it on.
There he is.
And then you need to unmute yourself as well. You're on mute, Mr. Addison. Mr. Addison, you're on mute. You need to unmute yourself. We can't hear what you're saying.
It's doing it, not me. I'm sorry.
No worries. Why don't you go from ball peen hammers? I think is where we interrupted you.
From ball peen hammers. From that light note, I want to get to some heavier points of fact and law to clarify the need for this appeal upon key errors in administrative proceedings and then highlight some defining issues in this case. First of all, from the outset, the core problem was the narrow construction of ordinance number 17-15-0304A and how it was applied to this leasehold situation after the fact. And I've run through kind of the stages we had to go through in trying to get a remedy once we found out the first time around July 1st last year that there was a problem. I was on the way back from a camping trip in Wisconsin, and I went to City Hall on July 18 to do some fact finding. We had been told that Car Outlet had failed to get a business license, but I went to Business Affairs to check the current data on these addresses. In fact, nothing was listed for 2737 and 2767 properties, but Car Outlet had obtained and renewed a valid license under their main 2734 business address across the street, and it was still in effect. So I then went to the zoning desk to solve the problem. I explained that the properties in question had been under lease to this licensed business, and we could produce the leases and prove continuing use throughout this time frame. In response, I was told that it didn't matter, licensing on these properties had lapsed, and we should take our dispute to the license expediter for the tenant. So at that juncture, the zoning department refused to consider the facts or any routine staff remedy in accord, and we had to request a formal review by the zoning administrator. That request was filed on September 13. Our sense at that point was that once we presented kind of evidence showing substantive compliance in accord with the intent of the ordinance, the matter should have been easily resolved, but unfortunately that was not the case. What wound up happening is, in very short order, the zoning administrator issued a rather cursory determination that basically recited the ordinance and really did not address the facts at all. And he also referred the matter to Business Affairs for a license remedy, in effect disclaiming jurisdiction over the zoning ordinance. My brother Michael tried to cooperate with the zoning administrator and prepared a letter to Mr. Alley, who was the deputy commissioner at Business Affairs, and that letter was prepared under the direction of Mr. Murphy. I was concerned about this move because as property owners, we're kind of third parties to the licensing of the business. And I was then very concerned to find out that the action requested at that juncture basically requested that a new license be invented with these addresses on it. And I recognize that we are asking for something that no public official could do. We're a creation of a fictional license with and falsification of public records. And I realigned that initiative, and I kind of changed the direction of it. And I said, look, let's try to amend the existing valid license to and correct it with these addresses, which was the oversight from the beginning. And when we then engaged the support of Car Outlet, which was then in bankruptcy proceedings, we managed to engage them through their trustee attorney, and the acting chief operating officer issued a letter authorizing an amendment adding these two addresses at 2737 and 2767 to their existing license as adjunct locations, part of that business headquartered across the street. And that basically was designed to correct the record and correct the license data. At that juncture, basically the requirements of this kind of sidebar solution were met. And however, the deputy commissioner basically refused to enact that amendment. And the difficult thing here is that when a business is required under ordinance 4.4.050, which addresses unlicensed, well, the requirements of a business to maintain accurate records on its license, that amendment is an amendment of right. If you require a business to maintain accurate records, you can't prevent them from making the correction. And so ironically, I was concerned over any requirement that an official act outside of their authorities in this. And in effect, I believe the deputy commissioner had no authority to deny this amendment. But at that juncture, we then had to go back to the zoning administrator for a final determination. And basically he doubled down on his prior opinion. And there was really no consideration of Car Outlet's license amendment or the corroboration of the facts we had presented. And when we tried to press for a firm determination, we were told we should pay $150 again and go around another time. That juncture, we were concerned that the process had taken so long that we were in a position of at risk of being out of time for appeal, and we had to make sure that we established the final decision date. So the process basically, in those progressive stages, kind of denied a simple remedy that could have been implemented at any time, we felt, and that brought us to the Zoning Board of Appeals. These, I think, are the decisive issues in what has to be considered. First of all, we noted the problem from the outset. The construction of this ordinance and how it was applied, and how this ordinance makes a property owner liable for a business license violation. Well, you have another ordinance for that. Ordinance number 4-4-112 addresses unlicensed businesses and the liability of a property owner. And it makes it clear that it's a responsibility of an owner to make sure that it's a tenant business is property licensed, and we did so through the terms of the lease and had every reason to believe that they were in compliance. And it also requires under paragraph B that any property owner who violates subsection A of this section shall be notified in writing by the department of the fact of such violation and of the property's duty to correct such violation of this section. Short answer, no notice of violation was ever issued by the city. So that is the ordinance that makes the other ordinance applicable, and it was never implemented. Point two, there was no violation in fact. No license is required for vehicle display. And we addressed this in our request for review to the zoning administrator in paragraph 15 and in the findings of fact, paragraphs A5 and D8. We looked also closely at city standards, and I literally went through the inventory on the website and made sure I understood how the categories were set up. We established that there are only two categories applicable to the car trade, either sales or repair, and then determined that pursuant to ordinance 4.4020D, basically this kind of activity of display and storage of inventory is an incidental business activity that does not require a separate license in addition to the primary business license that they held. So this is pretty defining. In general, the case law on non-conforming use is pretty compelling. First of all, the zoning department has jurisdiction over zoning ordinances, and that's pretty well established in the city code and in law. And then it also makes a distinction between the standing of an property owner and a business operator and the regulatory purposes respectively of business affairs and zoning affecting the position of each. And by legal standards that we found, and we did pretty exhaustive look at the case law, the ordinance is vague in conflating business obligations with property rights. And this gets back to the core question we raised at the outset and about how we were made liable for a third-party error after the fact. It's also, the case law is also clear that establishing a commercial lease confirms the intent of the owners to maintain a grandfathered use, and the grandfathered use cannot be arbitrarily denied without some showing of intent on the part of owner to terminate that use. Finally, there are elements of the Illinois Constitution that are pretty clear that grandfathered rights cannot be extinguished arbitrarily or by ex post facto restriction, and that's very much the effect of these events in the last year, and that subjected to vicarious liability for third-party actions is kind of a violation of due process. So in quick sum, we had no opportunity to correct any license defect. Had we been notified, we would have done so diligently. And we found ourselves in this difficult position, and we're now a year down the pike. Thanks very much. I yield.
Ladies and gentlemen, we appreciate your listening and considering our appeal. I hope we succeeded in summarizing a very long and complicated issue. As you review this request, please refer to the findings of fact in our documentation. I think you'll find this document to be complete and a compelling presentation of our position and an accurate referencing to the supporting documents and the law. We are not asking you to do anything unreasonable. We are only requesting that you reinstate a status that existed for decades. It is a just thing to do. It's a fair thing to do. Ask yourselves if Chicago's interests are better served by granting this request or better served by denying it. Please grant us this request and restart the 18-month clock to allow us to find that tenants and buyers will be able to add economic vitality of the neighborhood and Chicago. Jobs and taxes will result. Again, we thank you for your time and we look forward to your favorable decision.
Thank you. I am going to ask the zoning and business affairs representatives to present their response in a moment, but I do have a couple questions. I think maybe for Mr. Scott Addison, I'm going to guess. I want to just make sure we are on the same page about the specific bounds of this body's jurisdiction and what you're requesting. So our ability to hold appeals is really on the basis of whether the zoning administrator made an error in interpreting or enforcing the zoning code, obviously. And so I want to just the part of the code that deals with loss of non-conforming uses essentially requires that both the operations are continued and also that a valid business license is maintained. And I understand your argument on the licensing. I just want to, specific to that point, I want to make sure I've teased out your argument that I think structurally probably has to be that you have maintained a valid business license. Well, let me just ask you to first, if you agree that the question is whether you both continued your operations and also continued to maintain a valid business license.
That's what the ordinance says. And the operating verb there is maintain, the property maintain. And the construction of that term is up for grabs right now. And this is what we're trying to determine, because essentially, if it were not a grandfathered site and it were an ancillary use or incidental business activity as defined in the code, it would not otherwise require a license, and that wouldn't affect property rights in that way. In this instance, in the presence of the ordinance 1715-0304, which defines, basically predicates the non-conforming use on licensing, all of a sudden this becomes a critical factor. So maintain, I believe, is fair to include a property in an ancillary use that is at least part of a licensed business. And this is a common thing along Cicero Avenue and in the car trade generally. You license the business, not its parking lot, okay? And it's an unusual distinction in the configuration of these sites that the primary business location has always been across the street since 1974. That's when Howard Samuels purchased 2734 and then operated across the street. And that's part of the grandfathered configuration that is unique, but that's what the grandfather clause is for. So in our view, there was absolutely continuous operation through the closure of Car Outlet at the end of March 2019, and there was a valid business license for their business. And all that went down was that there was an clerical oversight in the application. I neglected to mention that he did a Freedom of Information request right after I went to Chicago last year, Business Affairs, to find out what was in the application. They had left those addresses out in the license application. That's all there was. The expediter blew it. And essentially we had no notice of that until the hammer came down, and we found that after 3 years had elapsed, all of a sudden we no longer had non-conforming use status as a result of a clerical glitch. So I believe we've met the intent of the ordinance, and it needs to be interpreted in a manner that accounts for the fact that a property as part of another operation may not require a separate license.
So to crystallize it, I'm going to assume that Mr. Ali is going to say that you do not have a valid business license. And so your argument is that the interpretation is that you can not fail to maintain a valid business license, even though the department that regulates that will say you don't have a valid business license. Is that fair?
No, I don't think so. Actually, like we've established, Car Outlet did get a valid business license, and that property and those properties on the east side, 2737 and 2767, given that they were not operating a sales office on that site anymore, they had the same configuration as David Samuels had operated as Value Auto, but they did not operate a sales office over there. And their position in their authorization, and consistent with the facts we found, was that they were told, and they were correctly told, that they did not require a license per se to park cars over there and display them. And that would be normally the case anywhere else. And so in my view, actually, being that they were under lease to a licensed business, they did maintain a business license, and it was those addresses were simply not listed with that business license as they normally would be in an address range on other licenses. That makes sense?
Let me ask other commissioners if you have any questions at this stage. Otherwise, we will hear from the departments.
Yeah, Farzan, I have a question. This is Tim. Can you hear me?
Yeah, go ahead.
Okay, good. Yeah, so you said that they were told, I'm just clarifying a fact. You said that they were told that a license wouldn't be needed for that lot because no business or sales office would be functioning on that lot. What was the party that told them that? Was it the city, or?
I can answer that. They hired an expediter.
Yeah, Mike.
They hired an expediter who came and told them that it wasn't necessary. They, in other words, when they got into the licensing business, they hired someone who was supposedly privy and knows all about all the licensing. And he came back to them and said it wasn't necessary, and so they didn't pursue it.
And I would like to support that with the fact that this was a critical point in our research. We had no idea what had gone on prior to the breakdown of our non-conforming use status. So I had to investigate this. And, you know, that's why I got deep into the city standards on this and, you know, determined, first of all, that, you know, there are only a couple of kinds of licenses, categories of license for business activities related to the car trade. This was not included there. So I don't dispute that they were told accurately that if they didn't operate a sales office there, they wouldn't require a license. Okay. And absent all the other contingencies, that would have been a valid determination. There would have been no problem. And then essentially, as I noted, the city code does provide for incidental business activities and does, allow that this kind of activity in conjunction with the main business address did not require a separate license. So I don't think they were told something erroneous, but the expediter should have included these addresses with their license application for the main address at 2734. That was the clerical oversight.
Can you also just talk through the, you've obviously been engaged in this conversation for quite some time. The underlying zoning was changed in what, the 2000s?
2004. There was the zoning revision from C1 to B1 was 2004, but the issue never arose. And at that point, these properties became non-conforming, but the issue never arose because David Samuels had always operated Value Auto with a sales office on the east side, and he had a separate license for that address. So the issue never arose. And the general appearance of the site wasn't particularly different when Car Outlet took over, but they weren't selling cars there. And the issue never arose. And as I pointed out, the city code, the ordinance requires that if there is an issue about licensing that makes the property owners responsible, notice is required. Nothing happened. And that was part of the point of my Freedom of Information request, because I wanted to see what the application, the license application showed. And indeed, Car Outlet's original license application did not mention these addresses. That was the first oversight. And then we certainly got no notice of any issue. And that's another thing that my Freedom of Information request established. I asked what notice of violation had ever been issued. Nothing came up.
So was there never a conversation about actually just changing the zoning, either in an application or with a local alderman?
No, not to my knowledge. I mean, essentially, we had no dispute with the B1 zoning or our non-conforming use status. The issue never arose, and we understood that we had to maintain the grandfathered use in general, and there was no breach of continuity.
What about during the course of this whole dispute that's resulting in this appeal? Are you under the impression that you would not be able to get a zoning change?
My view is that, well, that discussion arose initially, and I felt that going for a zoning change would kick loose a hornet's nest and was unnecessary.
Well, it really never came up as far as getting a zoning change. Our real estate agent got involved with it right at the outset, and doing a zoning change, as I recall, I think there was some conversation with the alderman, and based on what the real estate agent told us, the alderman would not even begin to consider a zoning change.
Okay.
And I would add to that, I'm a planner by training. I had no dispute with the intentions of a neighborhood business zoning. I understand the nature of a zoning change and how it's prospective and trying to lean the district in that direction. But we didn't break the law, and auto business remains viable in that district. We had no reason to believe otherwise.
Okay, let me ask Mr. Ali to just talk through a little bit about your interpretation on the licensing, and I don't know if you have anything prepared you'd want to start. Otherwise, I do have some questions for you on the letter that is part of our record.
Sure. Yeah. So again, Matthew Ali with BACP. Good morning, everyone. I think the letter largely embodies BACP's position on this. I guess I just want to highlight a couple of points that had been made throughout the course of what's been said thus far. First, I guess I would state that the previous business entity, Value Auto Mart, who operated on both sides of the street at 2734 as well as 2737, held licensing on both sides. They had a motor vehicle services license at 2734 because they had a garage that conducted some repairs and therefore requiring a more intensive license. They then also had what is called a limited business license for the east side, 2737 North Cicero, for auto storage and sales. So I think the historical precedent is Value Auto Mart held licensing on both. And then Car Outlet came in 2016. And initially, when you come to BACP for licensing, they came through what we call a licensing inquiry process, where they met with one of our business consultants to talk through what the licensing process would look like. And at that point, they were told that Car Outlet would have been told that an LBL was needed for the 2737 property. And then they were similarly given additional documentation that would have been necessary in order for that application to move ahead. Even though it's merely an LBL, the additional documentation would have been a CDOT issued driveway permit because there is a curb cut at the property, as well as a determination from CDOT as to whether an alley access letter would similarly be required, whether or not that the business was going to be using the alley off of the back. And we also indicated that they would have needed to submit a site plan as well, so we know what exactly is happening at the premises. So during the inquiry phase, they were told that licensing was needed at 2737, and we're told the documents needed. And then Car Outlet came back and simply moved ahead with the application for 2734, which was then ultimately issued. And then I do want to address the issue of a limited business license not being needed if incidental to the primary business activities. I would agree with that statement as to the extent that it is relevant to the same premises. And here seems the argument is that 2734 was licensed, and so therefore 2737, which is separated by Cicero Avenue itself, would not need to be licensed because it's incidental. BACP views those as distinct premises, distinct parcels, and with that requires distinct licensing. Last thing I would add is that BACP treats vehicle storage or vehicle sales as needing to be licensed, and here and then that license would be a limited business license for that storage or sales. And here we have a lot which is showing vehicles, which I presume customers access and look at vehicles, and therefore BACP views that as business activity taking place that would need to be licensed. Lastly, I guess to the issue of notice or inspections, we looked and saw that BACP's license inspection division largely we have annual inspections for more highly regulated business types that public place of amusement or hotels, restaurants, things of that nature that require an annual inspection to ensure that health and safety are being maintained. We don't have the capacity to annually inspect all 60,000 businesses every year. And even in this instance, the last time BACP inspectors were at either of these premises was back in 2011, based on our records. And so, the issue of, from BACP's perspective, when Car Outlet came back and moved ahead with only the one application for 2734, the 2730 application in our view has essentially stalled out.
And can you,
Chairman, this is Steve Valenziano with the Department of Planning and Development. Just to also be clear, the zoning code defines a principal use, section 17-1702-126, as an activity or combination of activities of chief importance on the lot, meaning the zoning lot. The zoning lot is a defined term. There is no other, you can say this is ancillary to the business across the street, but it is the principal use on this property, and that's the way the zoning code sees it, and the zoning administrator would have seen it.
Okay. On the, can you talk a little bit about the transition? This is for Mr. Alley, from your records, between the Value Auto Mart and the Car Outlet. Was that an expiration of the original license and then an entirely new application, or were they attempting to do some sort of a transfer?
It was not a transfer. They were two separate entities. Right. Value Auto Mart was the predecessor. They were licensed back. Our records show activity going back to at least 1995. I think the appellant team has suggested it goes back even further. Our records only go back to 95, but that's not to suggest that that's incorrect. But we then had that license. It's a 2-year license, renewed every 2 years. And they renewed in January of 15, and then it expired in January of 2017, which tracks with then Car Outlet coming in January of 2016. So typically, when a business closes or goes out of business, they sometimes will come back to BACP and formally cancel out that license. That doesn't always happen. It's probably not top of mind for a lot of folks when they're shutting down operations. Rather, merely the license will run its term and then naturally go into lapse and expired status, which happened with Value Auto Mart, and then with Car Outlet coming in 2016.
For the Value Auto Mart, was there, you mentioned that they had the LBL on the properties across the street. Was that also an entirely separate, I want to just clarify this point of, can you have a adjacent address associated with one license, or it was itself a separate license?
So we have license accounts, and then we have various sites. So, you'll have a restaurant that has, 10 locations. It'll be the same license account with site 1 through 10. And each of those sites are for different premises, and each site has its own package of licensing, whatever would be needed. Here, Value Automart had a single account for its entity, and then had multiple sites within it for both sides of Cicero.
And the reason I'm asking is, it sounds like the request that was made to BACP by the applicants is that they, amend the existing license that Car Outlet had by adding in those other addresses. And if I'm understanding you correctly, you don't extend licenses in that way across addresses. You still would have, they might have been under the same, maybe account profile, but it still would have had to have been a separate license. Is that correct?
That's correct. And certainly when, the request was to extend it across a vehicular thoroughfare, that would be treated as a separate site requiring separate licensing. Yes.
Okay.
Do you have, is that ever not the case if they are not across the street? If you have two lots just adjoining each other?
I think the scenario where I could see that coming into play is, if the application was submitted with a clerical error that didn't identify the full address range, I think we would drill down to that and see where, in fact, the property lines fall, and if the address range if the request were to extend the address range beyond the property line, that would bring with it a separate site.
Meaning a separate license still?
Yes.
I would like to respond to that, please.
Mr. Addison, I want to finish with
Okay.
you guys, and then we'll come back to you. You guys.
Fine. Thank you.
Okay. So, Mr. Valenziano, do you have anything else you want to add in general?
No, just that, we looked at the last valid license at the location and did the 18-month calculation. The 18 months would have expired on July 15th, 2018. The new application was after that date. Therefore, the zoning ordinance is clear that if you discontinue the use, which is failing to maintain a valid business license, is considered to be part of that discontinuation. If it's discontinued for a period of more than 18 months, then the non-conforming status goes away and is lost, and reestablishment of the non-conforming use is prohibited.
Any questions from the rest of the board so far?
Yeah, I have one. I think this is for Mr. Ali. Did you say that Car Outlet was notified that they needed a license for the sites across the street and decided not to get that?
Yeah, so Car Outlet came to BACP on January 12th of 2016 and had what's called an inquiry or a consultation where they filled out our initial what's called a business information sheet. And at that point in time, they were told that for both 2734 as well as 2737, that distinct licensing would be needed for both. And then they were told the documentation that would be needed in order to move those ahead. They left and then came back and moved ahead with licensing only at 2734, which was then issued on May 2nd of 2016.
Okay, thank you.
And Mr. Lee, you don't have a record specifically of them being provided that information. That's just part of the standard process. And your record is that they had come in for the inquiry, presumably.
standard process, and yes, that's correct. That we don't retain any images, or we don't retain the documentation moving it into our imaging process until they move farther along in the process. We do have record of the inquiry having taken place under the Car Outlet AC LLC business entity, but the documentation would not be captured because it's a form that they fill out. It's given notes back as to what's needed to move it ahead, and that's documentation that they take away with them.
Got it. Okay. Mr. Addison, would you like
Thank
to
you.
respond? And you can ask some questions if you like of Mr. Ali or Mr. Valenziano.
Thank you very much. Actually, we went through some of this stuff. Mr. Alley provided me with that particular early inquiry in January 2016. And it should be noted that Car Outlet had numerous locations in Chicago. They had something like 10 different business licenses in Chicago alone. And I also, on the way down there last July, I found they had another facility shut down in Park City near Waukegan, and I don't know where else they were operating. They were pretty overextended. But the inquiry they made in January 2016 was in the name of Ultimo Precio, which is their other trade name, and they had some number of locations under that trade name, location a couple blocks away on Cicero Avenue, for example. And essentially they made an inquiry about the property. We had no knowledge of this. They didn't really enter negotiations with David until the following month, and they wound up looking at the whole facility aligned with the original configuration of Value Auto. So they made this inquiry about possibly setting up a full business on that northeast corner at Cicero Avenue on the east side, and they basically jettisoned that, decided it was a better idea to set up a larger Car Outlet facility in the same configuration as David had operated in for many, many years. I would point out that, yeah, it's common. First, I want to be clear that it's common. I did a lot of research on how these licenses are configured. Very common to show an address range associated with the license that would include adjacent lots and under the primary business address. And that was the way it was set up for 2734 across the street. And I only submit that, having operated in this configuration with these ancillary lots across the street, it was part of the grandfather status of these sites. It's with the unique attribute. This is why this really represents no precedent, because it was grandfathered. And where, the nature of a grandfathered use is that at some point in the future it will expire, and it's not precedential at all. The other thing I would like to point out was that licensing, I did a lot of research on the actual licensing of Value Auto and Car Outlet. And the license for Value Auto was in effect, and it basically overlapped the initial application by Car Outlet. This is not uncommon, as was noted. And then Car Outlet renewed, and that license was still in effect a year ago. It didn't expire for a couple more months, but that had been obtained in May 2018, and it ran. Basically their 2-year license had been in effect through the termination of their lease at the end of March. So there was no lapse in licensing through the point that they vacated the site. And then we found out that non-conforming use had been withdrawn.
Will you clarify for me
pardon me?
Will you clarify the license? You're saying that Value Mart's license was extended past the time in which.
Well, it ran a 2-year course that overlapped the beginning of the lease with Car Outlet, and this is not uncommon. And
the expiration of that lease was a year ago, you said, or that license was a year ago?
I actually have this information and before I get to that, while I'm looking at it, I want to refer you to exhibit A.89, which is correspondence with Mr. Alley, which addresses this stuff. And at that point, I was asking for him to reconsider his findings and this argument about basically this incidental inquiry by Ultimo Precio, before they commence the lease for the whole set of facilities is kind of incidental to the issue here. Any business can walk into the city and say, what would happen if we went to this site, and decide what they want to do after that. So what's germane is the fact that they did engage a lease for 2734 and the 2 East Side properties in May 2016, and were properly licensed to run their business out of 2734. So essentially, they were operating in accord with the law. And as noted before, the notion of this being the sites across the street having to be a separate business location simply doesn't hold water in light of the fact that, number one, the activity did not require a license per se. And number two, this configuration had been going since 1974, with the 2 lots across the street operated in conjunction with the main facility at 2734.
So I need you to just clarify, and perhaps it's just a question of repeating your comment about the timeframes, because we actually have, I'm looking through your list of exhibits, and we have multiple exhibits that are marked as Exhibit A. So tell me specifically what you were referring to just then. What exhibit? Yeah, what is it? What is these? I have a lot of things that are Exhibit A for you. I don't know why.
Yeah, there are subdivisions of, well, you have Exhibit A as everything that goes with in support of the appeal. Okay, I'm gonna have to look and identify that exhibit.
I have a quick question, if I can intercede for a minute.
Sure.
So my question is, and obviously you guys know I've been dealing with the city of Chicago for 40 plus years, and it seems surprising to me that that Car Outlet would come to the city and the city requested them to have a license for 2737. And they did not do that. And it's very unlikely to me. It seems surprising to me the city did not follow up on that and say, hey, Car Outlet, you guys can't operate your business with only 1 license. You need licensing for both sides. And I have to beg to differ. I was visited by the City of Chicago inspectors every single year, and numerous times, not just for zoning, but for business license, but numerous other things. Regardless of that, it seems very surprising to me that did the city just let it go and say, okay, well, you know what, they didn't apply, so I guess they're not going to do business on that property. I mean, I don't know. I'm kind of a layman in this. It just seems very surprising to me. The city just decided, oh, okay, you know what, we'll just do 1 license, and the other side, we'll just not worry about that. Is that the way it went down, or?
Are you directing that to Mr. Ali? Mr. Samuels, who is that question for?
Whoever can answer it. I obviously don't know. Was it Mr. Ali?
From Business Affairs, yes.
Yeah, that would be great. I mean, yeah, I mean, if that was the case, I'd be very surprised, like I said, because I spent numerous hours down at the city of Chicago applying for licenses and doing parking driveway permits, and the city was, very thorough, and they didn't let anything slip.
Well, I
So,
think,
yes,
so this is Matthew Alley, and I guess my response to that would be, similar to what Scott Addison said earlier. We get inquiries often coming in on various parcels that come in simply to explore what may be possible, and that's what happened here. And they were instructed what would be needed in order to move that ahead. When Car Outlet came back in May to finalize the licensing for 2734, I can't say as to whether or not that the consultation would have identified the inquiry that took place across the street. I don't know if that was ever discussed or not, but simply it was merely an inquiry. They were told what was needed, and then the entity came back and had the documentation and finalized the application for only one of the two parcels here.
So you're saying, Matt, you're saying that there's a number of businesses out there right now that don't have licenses on them? Is that what we're saying here?
I don't think I made that statement at all. What
Well, I
I
mean,
think
that's what happened.
the statement that I made was that we get a lot of inquiries. People will come in and see, at this property, can we do this? And so, we will tell them, based on this activity, this is the documentation that's needed. This is the type of license that's necessary. Maybe there's going to be off-street parking requirements. Maybe the underlying zoning will come into play as to whether or not it's permissive at all. So we get inquiries all the time that don't end up moving ahead. We then shift to the department being largely complaint based. And when we get complaints about unlicensed businesses, we certainly respond to those, and we'll go out and take proper enforcement, whether that's citations or notices to correct, to communicate to the business the need to become licensed. Had we gotten a complaint about 2737 operating unlicensed, that's probably what would have happened. We would have had inspectors go out and reviewed and noticed that no license was there, and then provided a notice to correct to the entity to come into compliance. We don't have the capacity to be monitoring the entirety of the city for any and all unlicensed business activity taking place. And this is an instance where that took place on the east side here.
I understand that. That makes sense to me. I get that point.
I'm going to move us on from this topic too, because it's a little bit irrelevant.
Could I add one thing? You asked one question about the history of these licenses. I want to refer you to Exhibit A.86, which was correspondence with Mr. Ali dated November 5th, 2019. And this actually included information about the business licenses of the past of Car Outlet and Value Auto. What's defining here is that to relieve this point of confusion, the last renewal by Car Outlet was on May 15, 2018, so that their license should have been continuous through May 2020. So that simply corroborates the fact that their license was still in effect after they closed down, and there shouldn't be any confusion about the fact that licensing was continuous throughout this period.
So what I want to confirm is that's for Car Outlet, which
Correct.
is licensed for the original, that does not include the two parcels across the street.
Well, our contention is that it was supposed to, and they, by virtue of a clerical error in the application, which I confirmed by Freedom of Information request, they simply failed to include those adjunct addresses with their main business location on that license.
And so your argument was not that, what I thought I heard you saying, which is, this is what I want to clarify. You're not saying that the Value Auto, which had the licenses explicit for the two properties across the street, that their license overlapped and was those licenses did not expire a year ago. It's not.
No, they were in effect through the commencement of the Car Outlet lease in May 2016, and that was simply, again, as Mr. Ali noted, it's common for these, when there's a change of tenure on the property, it's not uncommon for licenses to overlap and they forget to terminate them, but that I had that data in that exhibit as well.
Got it. Okay. Mr. Poliziano or Mr. Ali, any questions from you to the appellants?
I have no questions. I just want to make clear that the zoning board is supposed to determine whether the zoning administrator made an error in his decision. the code based on his reading of the ordinance, the zoning ordinance. And in there, it says that if the license is not maintained in the zoning ordinance, section 17-15-0304A sub 3, if a non-conforming use fails to maintain a valid business license, the use will be considered to have been discontinued. Sub 1, if a non-conforming use is discontinued for 18 continuous months or more, all non-conforming use rights are lost and reestablishment of the non-conforming use is prohibited. The last valid business license, an auto license, this has been an auto sales lot for years. It was rezoned by the alderman in 2007. This whole section of Cicero Avenue was zoned from C21, which allowed auto sales, to B11, which prohibits auto sales and prohibits vehicle storage and any outdoor uses in the B1 district. So at that time, all of these uses along here became non-conforming. They had non-conforming use rights. This one held its non-conforming use rights until July 15th of 2018, 18 months after the last valid business license on this lot. That's the determination that was made by the zoning administrator. That's why the zoning administrator denied the application. That's all that's supposed to be being considered here. You've heard from the deputy commissioner from Department of Business Affairs saying that each separate site needs to be licensed individually. This was licensed individually for years. It was licensed individually. It's the principal use of the lot. It's the only use on the lot. So therefore, I say that the zoning administrator did not make an error, that the department did what it does on a daily basis with these types of decisions, based on the zoning ordinance, nothing else.
Thank you, Mr. Valenziano. So Mr. Addison, I'll let you do a closing comment and then we'll do any last questions from the board.
One fast thing, and I'll defer to my brother. No, it's not true that that license had lapsed. The license was for Car Outlet was in effect on renewal until May 2020, which was after this flap came on last year. And so there was continuous licensing there. And again, you cannot require a business license for an activity that has no corresponding business category, business activity category in the license code.
It does.
And essentially, our simple position is that to our knowledge, the use was supported by the existing license of Car Outlet throughout the term, and there was no lapse in continuing use at all, in fact, or in their licensing as an operating business through last March.
Let me try to just put a quick wrap on it. And we got ourselves really in the weeds on this thing. When we leased these properties to Car Outlet, we assumed they were going to be operated as Mr. Samuels had operated Value Auto Mart. And in point of fact, they got the physical plant, but they substantially altered the way they operated. And by virtue of doing that, and in fact not selling cars, somehow their consultants said they didn't need one, and they didn't pursue that. It was really a matter of them substantially changing within the same physical plant how they operated, and therefore changed what the perception was for licensing.
Got it. Any questions from the board? Okay, thank you very much. We'll take it under consideration.
Thank you.
Thank you for your time.
Thank you.
Next up, we're going to do 18120Z, 18220Z, and 18320Z at 2434 South Albany.
Victor? Victor?
Yes, can I help you?
Victor, it's Nick. I need to join the meeting because I have no audio. I'm sorry, I have no video. I can't see who's talking.
Okay, let me, you're gonna sign in and sign back out?
Yeah, and I have a minute to do that.
Yeah, go ahead. That's our court reporter, Chairman.
Sure.
Okay,
I
Nick,
really
go
need
ahead.
to. Okay, thanks. I'll be right back. Okay, I'm back and thank you.
Great. Okay. Counselor, why don't you identify your witnesses? I'll swear everybody in, and then let's do the short version on this one.
Okay. Good morning, Chairman and members of the board. My name is Jimena Castro, an attorney at Acosta Esgar, and an attorney for the applicant for the rear yard setback variation matter before you today. So I'll introduce really quickly the applicant manager, Tio. Can you please state your name for the record?
Tio.
And you are the manager for the applicant?
Sorry, I have inadvertently muted you, so can you unmute yourself? There we go. So before we go forward, do you swear to tell the truth in these proceedings?
Yes.
Yes.
I meant Mr. Scorte.
Yes.
Okay, go ahead, Counselor.
Okay. Tio, can you please state your name for the record?
Tio Scorte.
Are you the manager for the applicant?
Yes.
And if you were to testify today, would your testimony be consistent with the affidavit that we supported, that we provided to the board?
Yes.
Thank you. Oscar, can you please state your name for the record?
Oscar Alba, ALBA.
Thank you. And you are the architect for the applicant?
Yes, I am.
And you're the
Mr. Alba, do you swear to tell the truth in these proceedings?
I do.
Go ahead, Counselor.
And if you were to testify today, would your testimony be consistent to the affidavit we provided to the board?
Yes.
All right, so may I proceed?
Please.
Okay. Really quickly, the subject property is improved with a vacant 2-story building that sits virtually on the property's lot lines, as you see right now. The property, the building previously housed a church on the first floor and a dwelling unit on the second floor. The building is also orange rated and is currently vacant and dilapidated and not safe for living. The applicant previously rezoned this property to allow for rehabilitation of the building into a 4-dwelling unit building. As you saw from the plans, the building has a 2-story portion in the front, a 1-story portion in the middle, and a rear 2-story portion in the rear. That rear 2nd-story addition, the ceiling height is currently lower than the ceiling height for the front 2nd-story addition. And as part of the rehab, the applicant wants to reconstruct that rear 2nd story and also add a partial second floor connection that will connect the second floor into one continuous second floor layout. Due to the reconstruction, the rear yard setback was triggered, and we are seeking a variation to reduce it to the existing rear yard setback of 0.92 feet. And the hardships in this case are the existing building on the property that is lot line to lot line and already encroaches on the rear yard setback. And without the variation, the applicant would be required to demolish the rear of the building or significantly alter the interior layouts or lose a unit. And it would result in a less than reasonable return of, as you can see in the pro forma, of negative 45% profit and approximately $223 loss net profit.
Any questions from the board?
And we have a letter of support for all three variations from the alderman who canvassed the area, and we're happy to answer any other questions.
Okay. Thank you very much. Unless you have anything else you want to add, we will take it under consideration.
Thank you.
Let's do 18420Z at 2454 South Spalding, and then we're going to take a short 10-minute break.
And then just really quickly, I didn't go through the other two variations for this property for the last one. Did you want me to?
You're talking about the rear yard open space and the parking?
So for Albany, we have the variation to reduce the parking and to reduce the rear yard open space.
Yep, and the hardship is the same argument in both cases. Essentially, you're using the existing property and you don't have any space.
Correct. Yeah.
Yep. Yep. We will take that into consideration. I'm now noticing that you also have 184 and 185.
Yes.
So why don't you do both of those and then take a 10-minute break.
Okay.
So for 184, is it the same witnesses?
Yes.
All perfect. So then everybody's still under oath. Why don't we go ahead with 184?
Okay. Again, my name is Jimena Castro, an attorney at Acosta Asgar, an attorney for the applicant for the variation before you today. The subject property is improved with a vacant, two-story vacant building with one residential unit and a vacant commercial space and rear surface parking for 3 vehicles. The applicant previously rezoned the property to allow for the rehabilitation of the building into a 4-dwelling unit building. As a vacant commercial space there today is not characteristic of the block. The applicant proposes to remodel the existing building to allow for a 4-dwelling unit building. No exterior additions are proposed and the 3 parking spaces will remain. And the applicant seeks a variation to reduce the parking from 4 to 3. Absent the variation, the applicant would have a negative return of negative 6% approximately, as you'll see from the pro forma, and a return of about $29,000 compared to an 8.3 positive return and a $52,000 profit. And we have a letter of support from the alderman who canvassed the area again. If you have any questions, I'd be happy to answer.
Just for the record, Mr. Scorte and Mr. Alba, if you were to provide any more testimony, would it be consistent with your affidavits on these two matters?
Yes.
Yes.
Okay. Any questions from the board on 184? Okay, we'll take that one under consideration. Let's go to 185.
All right. Again, my name is Jimena Castro, attorney at Acosta Asgar, attorney for the applicants for this parking variation. Really quickly, the subject property is located on 23rd Place and is improved with a 3-story vacant building that was rezoned in 2016 to allow for a 7-dwelling unit, 7 indoor parking space rehab. At the time, the applicant designated a portion of the first floor of the building as storage, but due to the extensive rehabilitation and unforeseen costs, because the building was in worse shape than we anticipated, we filed a variation, we filed a rezoning in January of 2019 to modify the existing type 1 to allow for an 8-unit building to offset the construction costs. The applicant is now seeking a variation to reduce the 8th required parking space. And one important thing to note is that, as you'll see on the exhibits, this is a TOD location. And had we not filed in January 2019, had we filed later in the year, we would have qualified to reduce parking through a special use. But at the time that we filed, the CTA TOD had not been passed. Another important thing to note is that this scenario fits the proposed AUD ordinance, which would allow us to increase a unit and not provide additional parking. The hardship in this case is the existing building, which limits what can be built inside, And it's a hardship that the applicant has tried to overcome since 2016, but due to the unforeseen costs and the existing building, we now respectfully seek this variation. And we hope it is approved, as the rate of return would be unreasonable. It would be approximately about 0.07% return without the variation, and compared to 7.05 rate of return. We also have a letter of support from the alderman, who approved the rezoning and variation together back in January of 2019.
And Mr. Scorte, if you were to continue testifying on this matter, would it be consistent with your affidavit?
Yes.
And Mr. Alba, same question to you.
Yes.
Any questions from the board?
I have one question. I was letting it go, but it seems like every one of your cases, you went to the alderman, which is great, but you mentioned nothing about trying to go to the black clubs or the neighborhood groups. 12th ward, I was kind of okay with that, but I know the 25th ward's a very active ward. Did you reach out to anyone on the black club or in the neighborhood groups?
So we met with the Alderman's Zoning Advisory Council when we rezoned the property in 2019. And we met with them, we went through their process. It was an extensive process, and they decided to support the rezoning then, which they knew would be attached to the variation, which is why the letter of support that you guys have has the rezoning and variation approved together in one letter.
Again, correct me if I'm wrong, but that zoning advisory council were all appointed by the alderman, right?
So the Zoning Advisory Council is made up of community people that are involved in the community. So he takes people that are active in the community from all different age groups, elderly members, young members, business owners, and I think it's a great group.
Okay, let me ask my question again. That group is appointed by the alderman, yes or no? That's what I'm looking for.
Yes.
Okay, so we really didn't reach out to anyone out to anyone on the block. So the block club or any neighborhood group that is not appointed, let me repeat myself, not appointed by the alderman, yes or no?
We sent the notice, and the alderman did not ask us to reach out to anybody else.
Again, the alderman doesn't vote on this board, okay? Just, again, let me reiterate myself. I like to hear what the aldermen have to say, but once council brings up alderman, I want to know what the neighborhood says. Again, aldermen don't vote on this board. It's great that you go and get the alderman's opinion. I love that, but I also love to hear what the block clubs say and what the neighborhood groups say, not advisory councils that are appointed by the alderman.
Mr. Toya, if I may, it's Rolando Acosta, co-counsel.
You know I was going to ask this question, so I'm surprised. She said it once, she said it twice, she said it third time. You know I was going to come back and say this. I know you did.
So this has been going, the rehabilitation of this building has been going on for over 3 years. There is really no block club down here. But after 3 years of being in the community and noticing neighbors and even Teal talking to immediate neighbors, there's really been no complaints from anybody. Actually, it's been very favorably received by the residents, which is why there was really no meeting, because there was nothing to talk about.
Do you have a letter in that support? I mean, your partner kept saying alderman. So do you have a letter of support of neighbors on each side?
We do not have letters of support from neighbors on each side.
Okay, so this is hearsay to what you're saying to me right now.
Yes, it's anecdotal.
Again, anecdotal. Again, I like to hear what the aldermen have to say. But counselor, if you're going to bring up the alderman, I also want to know what people on the block club, neighborhood groups, or even if they don't have it, maybe they don't have it, but I know that this is a pretty active area. 25th Ward's very active. I'm sure there's, people that are active on 23rd Place. However, you do not have letters from neighbors on each side. It's just you telling me that it's okay.
Correct. And the alderman's validation of that, and he does reach out to the neighborhood, by the way. We're in this case, talking about two different aldermen. We've gone through it under both the current and the prior.
I get that. You did. Now that you say that, because you said 2019, so the sitting alderman that's there right now has been there since 2019. But now that you say it goes back 3 years ago, I get that. There was another alderman 3 years ago. But again, when you're going to bring up aldermen, I want to know what, like I said, lot clubs, neighborhood groups, and if neither one exists, then what neighbors on each side think.
We understand. We'll try to do that in the
I
future.
thought you understood that before, but okay, I guess I made my point. Thank you.
Thank you.
Any other questions from the board? Okay, we will take it under consideration. Thank you
Thank
very
you
much.
very much.
We're going to take a 9-minute break. We are going to reconvene at 11 a.m. and we will start in with 186, 187, 188, and 189. Commissioner Toya seconds. Commissioner Saul?
Yep.
Commissioner Smithson?
Aye.
Commissioner Toya?
Aye.
Okay, we are going to be in a short recess.
Rebecca Kistler, can you unmute yourself for a second, please?
Yes.
Which case are you here for?
203-20-Z.
So you're Rebecca.
204.
You're Rebecca
Yes.
Fitz?
Yes, Rebecca Fitz. I'm sorry, that's my maiden name.
Okay, thank you. That's all I need to know. Thank you.
Thank you.
With the person whose phone number ends in 2829, can you identify yourself?
Michael Yeagle.
Oh, okay. You signed back out?
I got disconnected, so I signed back in.
Okay. That's all I need to know. Thank you.
Thank you.
Will the person identified as Janus, can you identify yourself, please? First and last name? Januz?
It's me, John Pekarsky.
Oh, okay, John. That's all I needed to know. Thank you, sir.
Hey, Victor, it's Nick.
Yeah, Nick.
Is there an afternoon session or are we going straight through?
We're going straight through.
Okay, I'm gonna call, great, that's what I need to know. I'll just call Katie to see if she can relieve me and we'll let you know when that happens, okay?
Okay, not a problem.
Thank you.
Yep. Julie Walsh?
Yes, Victor, I'm here.
Okay, you know that case was continued, correct?
I did.
Okay, so you don't, I mean, if you want to stay, you can watch the hearing, but it won't go forward today.
I
So there's-
understand.
Okay,
I understand that it was at this time rescheduled until July 17th,
correct,
your third Friday in July.
correct.
And can you tell me at this time, Victor, if the Zoom contact information that I used today will be the same or will it change?
It may change, the password may change, but you can reach out to me before the hearing.
Well, I have, Victor, and I know you're very busy, and the way I got the information today was via other sources that you had emailed. But I had reached out to you and Steve and Jeanette, and I know you're all very busy and you're all working from remote, and I've got a problem with my email, so I had to rely on voicemail. But we got there and we got it, and it's been very educational to listen. And hopefully I'll be able to join when this case finally is considered on the merits on the agenda. But I will need that contact information. So perhaps in the future, I think you'll probably follow up and email our registrants like Leslie Ames, who was registering for me. She registered me and herself. But if someone, you or Jeanette, could just let me know that contact information, that password, and so on, closer to the 17th, because I did leave you a message both on the 19th and the 25th of this month.
Okay, yeah, just we'll make sure that we get you the information
I appreciate that,
for
Victor.
the
Thank you.
17th. Okay, yep, not a
Yeah,
problem.
and as I said, my compliments to this whole procedure. This is a learning curve for me.
Thank you.
And I am picking up other information that I do research a lot, Victor, as Steve Valenziano will tell you, and this is research for me to focus
Sure,
in
by,
on.
by all means, you're more than
So I'll
welcome
listen, but
to stay in.
I'll listen and I may sign off because it sounds like you've got a very, very full agenda today. How long do you think you'll be going to? What time will you quit if you don't get through everything?
We get through everything, so I couldn't tell you what time we're going to be done.
8 p.m. tonight, huh?
Quite possible.
Well, best of luck, and I don't know if you want. You can just put me on mute if you want, because I don't intend to
Yeah,
speak up. But
that's
I
fine.
will listen in. Thank you very
Okay.
much.
Okay, thank you. Bye.
Bye.
Mr. Bowen, are you back and ready to go?
Yes.
Perfect. Sorry, I meant Nick Bowen, our court reporter. I think you referenced that he was going to make a call, so I just want to make sure he's back and ready to proceed. Nick, will you let me know when you're ready?
Ready? Can you hear me?
Yeah.
Thank you.
You're good to go?
Yes.
Perfect. Okay. And then Commissioner Knudsen, I saw you're here. You've got Commissioner Saul. Okay. I move we reconvene this meeting of the Zoning Board of Appeals. Commissioner Saul seconds. Commissioner Saul?
Yes.
Commissioner Knudsen?
Yes.
Commissioner Toya?
Yes.
Perfect. We are reconvened. We are on matters 18620Z, 18720Z, 188, and 18920Z for 2668 North Burling and 2670 North Burling. So Counselor, why don't you identify your witnesses? I'll swear them in and we'll go from there.
Sure. Good morning, Mr. Chairman, Fred Augustin. I have two witnesses, Mr. Michael Yeagle and Mr. Christopher Baum, and they should be on this call.
Mr. Baum, do you swear to tell the truth in these proceedings?
I do.
And Mr. Yeagle, are you with us?
Yes, I am.
Do you swear to tell the truth in these proceedings?
Yes, I do.
Okay, Counselor, why don't you go ahead?
Excuse me, Chairman. It's Nick again. I lost video. I'll be right back. Sorry.
We will hang out a minute.
Thank you so much. I can see you now. Thank you.
Perfect. Okay, Counselor, go ahead.
All right. Mr. Chairman, again, Fred Augustin. I'm here on behalf of the applicant, 2668 to 70 North Burling Street LLC. Applicant owns the properties at 2668 to 70 North Burling. Both lots, which we are talking about, are substandard. They only measure 25 feet wide, but only 105 feet deep. Both properties are currently improved with a 2-unit building. What the applicant would like to do is erect a 2-car garage with a rooftop deck at the rear of each property. Given the hardship with the substandard lot, it was difficult to erect 2 separate stairways, one serving the garage deck, as well as one serving the building. As a result of the short lots, it would be more efficient to essentially have one stairway that connects both the garage deck and the residential building, both serving ingress and egresses for both properties, both buildings. And because of the connected stairway, it forces us to seek these variations to the rear setback and rear yard open space, specifically reducing the rear setback from 31.68 feet to 21.5 feet, reduce the rear yard open space from 171.69 square feet to 140 square feet, as well as the minimum measurement on any side of the rear yard open space from 12 feet to 11.33 feet. Let me get Mr. Yeagle on the record. Mr. Yeagle, please state your name and address for the record.
Michael Yeagle,
Can you please state your address for the board?
2317 West North Avenue, Chicago, Illinois, 60647.
Thank you. You are the member of the applicant 2668 to 70 North Burling Street LLC, is that correct?
Yes,
Which owns the properties at 2668 to 70 North Burling, is that correct?
yes,
And on your behalf, my office did submit an affidavit that you executed, is that correct?
yes,
And if we continue today, would your testimony here today be consistent with the facts presented in your affidavit? Is that correct? Mr. Yeagle?
yes.
Okay, thank you. Now I'd like to go to Mr. Baum, Christopher Baum. So, Mr. Baum, please state your name and address for the record.
2453 South Archer Avenue, Chicago.
And you are a licensed architect in the state of Illinois?
Yes, I am.
And you've testified before this board on numerous occasions as an expert witness in architecture, is that correct?
That's correct.
Mr. Chairman, I'd like to recognize Mr. Baum as an expert witness.
Sure, we recognize him.
All right. On your behalf, we executed an affidavit and we submitted to the board, is that correct?
That's correct.
And if we continue today with your testimony, would they be consistent with the facts presented in your affidavit?
Yes, they would.
All right. Mr. Chairman, I have no further questions. We're here to answer any questions the board may have.
I have one question for you. For your rate of return, it looks like with the variation, it's about 13%.
Yeah.
What is it without the variation?
Mr. Yeagle,
The units.
Yeah.
Yeah, the units are not marketable without the variation at this location.
Okay. Any questions from the board? Okay, we will take it under consideration. Thank you.
Thank you.
Thank you.
So next up, we're going to do 19020Z. This is for 1504 North Elk Grove Avenue. And Counselor, when you're ready, if you can go ahead and start introducing your witnesses, I'll swear them in and then we can go from there.
Great. Good morning, Mr. Chairman and members of the board. For the record, my name is Sarah Barnes and I'm an attorney with the law offices of Sam Banks, located at 221 North LaSalle Street. I have here with us today the owners of the subject property, Megan and Christian Hermans, as well as our project architect, Stephen Besh. So if you may please swear them in for the record, Mr. Chairman.
Ms. Hermans, do you swear to tell the truth in these proceedings?
Yes.
And Mr. Hermans, do you swear to tell the truth in this proceeding?
Yes.
And then Mr. Besh, do you swear to tell the truth in this proceeding?
Yes.
Okay, Counselor, take it away.
Thank you so much. Mr. Chairman and members of the board, we are here this morning on behalf of Megan and Christian, seeking certain variations that are related to certain rear improvements for a new single-family home, wherein Megan and Christian will reside and continue to grow their family, which consists of 5 young sons. The property is generally located in the Wicker Park Historic District. It consists of a double wide lot, which measures 50 feet in width, but only 118 feet in depth. Therefore, the subject property is slightly substandard with regard to its depth by about 7 feet, thereby making the site overall approximately 350 square feet smaller than a standard size lot of similar consistency. Another kind of unique typographical condition affecting this site is that it's recessed 3 feet below street level. It's our understanding, based on our research, that back in the 1800s, the city went through and actually elevated the sidewalks and streets in this district, thereby creating, as you can see from this photograph, evidenced quite well, the actual property itself is 3 feet lower than the street and sidewalks, which creates an arbitrary grading denominator. The reason that why that's relevant is the city and the Department of Planning and Development base their calculations with regard to height on the grading of the property rather than the street level. So in this case, we have certain improvements at the rear of the property, such as the raised terrace that you see there, that although if you go based on the grading of our property itself is only about 4 feet above grade, if you, if you take the street grading, the patio is about 4 feet above grade. But with the added 3 feet that we are recessed, it arbitrarily inflates that to 7 feet. So, but for the grading of our site, which is very unique, we would not even require variations for those improvements. And that's with regard to setbacks. The other variation is related to an underground connection that connects the basement to the garage. It will be located below that terrace. It is not at all visible from the street, from either of the neighboring properties, from the alley. You can't see it. It is completely below grade, even though, again, the denial that you have before you here today, which brings us here, references it as a partially below grade. Again, that's created by the uneven grading of the site. So again, we likely would not be here, but for the grading of the site. And that's the real hardship around which we've been working. And Mr. Besh had to work towards this end. The Hermans and Mr. Besh spent several months attempting to redesign and modify, and went through hundreds of iterations for their new home in every which way, backwards, forwards, sideways, up and down, to see if there was any way to proceed with a functional home, still embrace the character of the neighborhood. And another important attribute to this particular programming is they are going to be maintaining a very large side yard, which is totally pervious open space and landscaping, which is another feature that we find with some of the other homes in this neighborhood. So Mr. Besh had to work with the grading, but as well, we were trying to adapt the home to meet the pattern of development in the area and also have the least impact on the adjacent properties. Towards this end, both of the immediately adjacent properties are currently improved with 3- and 4-story multi-unit apartment buildings, one of which to the south spans the entirety of that subject property, and the one to the north, which has a principal building and a 2-story coach house at the rear, again, which such improvements basically span the entirety of the lot. As well, the existing improvements on the site today currently have 0 side setbacks. So we'll actually be improving all of the conditions that have been at this property for over 100 years by increasing the side setbacks. The principal building, to which is actually going to be set back approximately 4 feet off of the north property line. The garage itself is 2 feet, which is pretty standard. Garages generally actually span the entire width of the lot. So again, we'll be improving those conditions for the adjacent properties. So with that, if there's no immediate questions regarding kind of my summation of the project, I'd be happy to introduce my witnesses.
Yeah,
I have one question.
go ahead, Commissioner.
Hi.
How are you? Sarah, you mentioned it's a substandard lot by 7 feet. Are most lots in this area substandard, or is it just this lot?
It's again, because Sam, you're very familiar, or sorry, Commissioner Toya, you're quite familiar with the Wicker Park Historic District. So similar to the grading that affects this property kind of differently, most of the lots, I would say at least the 2 adjacent lots are similar, but as you see from this diagram, because it's kind of on this triangular side where we abut Milwaukee, the size of the lots actually varies as you go down the street because they kind of cut off at an angle.
Right. So most of them are substandard. Yes? No?
Yes.
It's probably 50-50.
50-50. All right. Thank you.
Yeah, of course.
Any other questions from the board so far? Let's get your witnesses on the record.
Christian and Megan, I don't know if you drew straws before the hearing, but if one of you wants to testify on behalf of both of you, I'd be happy to continue in that way for efficiency.
It doesn't happen often, but Megan insisted that I talk today. So.
Oh, well, look at you. Thank you. Mr. Hermans, may you please state your name and address for the record?
Christian Hermans, 1924 North Hermitage in Chicago, Illinois.
Thank you. And Mr. Hermans, as I've already indicated, you and Megan own the subject property, correct?
That's correct.
You actually purchased the property several years ago with the intent of making it your forever home for your family, but due to some cost limitations, you guys weren't able to begin construction right away. Is that right?
That's correct.
So you guys have actually been renting a temporary home wherein you've been living with your 3 sons. Is that correct?
Yes.
And you've expended quite a bit of finances doing just that. Is that right?
That's right.
And another reason for the delay in time was because you and Mr. Besh, your project architect, have been working on several different iterations of this home in an effort to not only, again, have it embrace the character of the neighborhood, but if there was any way possible to get it permitted without having to seek relief or variations, you were attempting to do so. Is that correct?
That is correct, yes.
Thank you. Towards these ends, you were given a copy of findings of fact as well as an affidavit prior to this hearing. If you were to continue to testify, would your testimony be consistent with the statements that you made in those documents or that were made in those documents?
Yes, absolutely.
Thank you. Chairman, members of the board, any questions for the Hermans?
No, let's keep going.
Okay. Mr. Besh, may you please state your name and address for the record?
My name is Steve Besh. I'm a licensed architect in the state of Illinois. P.O. Box 46260, Chicago, Illinois, 60646.
Mr. Besh, you've been an architect here in the city of Chicago in particular for many years, and you've been, your programming in general is has to do with single family homes. That's kind of your expertise. Is that true?
Yes.
And towards that end, you've constructed and built and permitted several homes in the Wicker Park Historic District. Is that right?
Yes.
And it's kind of your pattern and practice before you begin the programming for a new home is to go out into the neighborhood and to actually physically evaluate all of the other improvements in the area so that when doing your programming, you can ensure that you are developing a program that is very consistent with the character of the other improvements in the area, as well as has the least amount of incidental impact on the adjacent properties. Is that correct?
Yes.
And in this instance, as I've already mentioned, you did have a couple of very practical hardships around which to work. Is that true?
Yes.
And the grading in particular, as well as the substandard depth, are two of those hardships. Is that right?
Correct. Yes.
And although several of the other properties on this block are also substandard in depth, as we see from a survey of the neighborhood, over half of the improvements in the existing block are also non-conforming with regard to, in particular, their setbacks. Is that true?
Yes.
And that's probably, again, partially due to the fact that these lots are substandard. Is that right?
Yes.
Thank you. And with that, Mr. Bosch, is it your professional opinion that the proposed variations meet all of the standards and requirements for a variation as set forth in the current zoning ordinance?
Yes.
And if you were to continue to testify here today, would your testimony be consistent with the statements that were made in the applicant's findings of fact, as well as your affidavit that was submitted therewith?
Yes.
Thank you so much. We'd be happy to answer any other questions.
Any questions from the board? Okay, thank you. We will take this one under consideration.
Thank you.
Thank you. If we jump to 224, 5, and 6, are you ready for that one?
I am.
Perfect. So we're gonna skip ahead to 224, 20Z, 225, 20Z, and 226, 20Z. This is for 2643 North Lakewood.
Everyone is in, Chairman.
Great. Counselor, you want to go ahead and introduce your witnesses and I'll swear them in?
Absolutely. Good morning again, Mr. Chairman and members of the board. For the record, once more, my name is Sarah Barnes and I'm an attorney with the law offices of Sam Banks, located at 221 North LaSalle Street. Here with me today, I have the owners of the subject property, Kelly and Justin Palmer. They may or may not be joined by 1, 2, 3, or all 5 of their young children, since they are still sheltering in home with all of their children. As well, we have our project architect, Ramil Kanoon.
Great. Mr. and Mrs. Palmer, do you swear to tell the truth in these proceedings?
Yes.
And for Mr. Kanoon, do you swear to tell the truth in these proceedings?
I do.
Okay, Counselor, take it away. And for this one, will you walk through sort of on a variation by variation basis, specifically why they're necessary and how they fit into the whole plans?
Yeah. There's a bit, I think the programming for this one's a little bit special and unique. So I will probably take just a tad more time explaining this one. Again, it's been kind of a long process, so I want the board to understand it. So with that, the subject property is situated just inside the southeast corner of Lakewood Avenue and Schubert Street, with all of its frontage on Lakewood, amid a row of single family and low density multifamily residences, many of which are situated on a double wide or larger than standard parcels. To wit, there are at least 10 properties within the immediate area that required relief from this board in order to permit construction of the corresponding improvements, and several others that are simply non-conforming under the current building and zoning codes. The applicants purchased the subject property, which consists of 4 vacant and completely paved lots of record, just over 2 years ago, with the intent of redeveloping the site with a new single-family home wherein they can reside and continue to grow with their family, which again consists of 5 children, including two-year-old twins, ranging again from 2 years up until 9 years old. And as a matter of background, after a little more research on this particular area, we learned that the existing property previously served as an accessory parking lot to the old sugar and confection factories that once lined the new wholly residential neighborhood. Since that time, all of the old factory sites have been redeveloped into new single family and multi-family homes to better match the evolution of development in this vibrant residential neighborhood. Those new residences in particular can be found on the west side of Lakewood Avenue across the street from the subject property, as well as on both sides of us. Towards this end, although the property has never seemed to have been improved structurally beyond the concrete paving, it did not come without its own obstacles. For example, when the Palmers purchased the property, it was one of the only sites in the entire neighborhood that was still zoned for manufacturing use only, even though it is located in the heart of a residential corridor in Lincoln Park. Hence an explanation behind why it stayed idle for so long. As such, and as a preliminary matter, the applicants had to undertake a zoning map amendment by and through City Council in order to cure the non-conforming use conditions that have plagued the property for many years and to make the property viable given the current character of the neighborhood. This is the same process that was followed by almost all of the other properties that line this particular block of Lakewood, which again used to be improved with factories. Therefore, the applicants began the process for permitting of their proposed new home over 2 years ago. The process was started with a few sketches and a meeting with the local alderman, Michelle Smith, who directed the applicants to reach out to the local community organization, the Wrightwood Neighbors Association, as well as other residents of the neighborhood to discuss their proposal for a new home for the site. Understanding and appreciating the unique character and charm of this particular neighborhood, the applicants hit the drawing board with their design team, and after many, many months of evolving iterations, came up with the plans that you have before you here today for consideration. During this time, however, although not yet able to physically plant their foundation at the site, the Palmers were an ongoing vested presence in the neighborhood, inviting and allowing other residents on the block to utilize their property for secure outdoor play space for their children and a makeshift dog run for their 4-legged family members, as well as for communal socializing, especially in light of the last 3 months that we've all endured with the COVID-19 pandemic, which kind of changed social norms. All of this was offered in an effort to truly get to know and bond with the community within which they would hopefully one day call home. Back to the programming for the new home, as previously indicated, the existing site is currently paved in non-permeable concrete from lot line to lot line, so that you have over 12,000 square feet of completely impervious and unusable land in the middle of a densely improved residential neighborhood, which is notoriously fraught with flooding issues, a concern that the Palmers did not take lightly when designing their programming for the site. Towards this end, instead of subdividing the site into 4 independent parcels, on each of which could have been built 4 distinct 3-story, and that's on the diagram you see here, Mr. Chairman and members of the board. That's an as of right project that you have in front of you, which would again consist of 4 distinct 3-story multifamily buildings with garages at the rear setback and a rear yard that would be hidden behind the principal building and the garages. Towards this end, if this programming was utilized for the site, the required side setbacks on the north and south would be only 2 feet as opposed to the 5 feet for the single family home. So it would also, those improvements would also cover 90% of the site. So again, making it almost completely impervious. Another option at which the Palmer's considered in, again, doing their iterations and plans and programming for the site was to do one unified 3-story facade that spans at least 90 feet of frontage. So you'd have a front building wall that's about 90 feet wide, and with a modest rear yard, which would be about 800 square feet hidden behind the facade of the building. And then you would once again have your detached garages at the rear property line, at that 0 property line. So that would be another kind of as of right alternative. However, that one would be far less compatible with the character of the other improvements in the area. And again, cover the site in almost 90% impervious materials. And as well, it wouldn't be as inviting to the streetscape because all of the open space would be hidden behind the principal building and the garage. You can see some of these other types of buildings along Lakewood Avenue. They kind of look like fortresses to me. No offense to anyone who owns them. I did submit photographs of these other improvements. I'm not sure if they're part of our screen share or not, but I believe the board members may have access to them, but they're just ideas of kind of what the Palmers were looking to avoid, is that kind of blank, windowless and non-communal facade, a hidden rear yard, and again, a row of garages that span the 0 property line at the back. So instead of those as of right options, the Palmers took great efforts with their design team to create a plan that maximizes the amount of community observable and enjoyable open space, maintaining over 3,300 square feet of side yard, as you see in the image in front of you, thereby softening the facade so that the new home is more welcoming and harmonious addition to the streetscape, as opposed to, again, one of those imposing fortress-like improvements that otherwise you find throughout the neighborhood. Towards this end, the Palmer's plan, which you have before you here today, and which was previously approved by the city's Committee on Zoning pursuant to a Type 1 zoning change application and contingent on these variations, calls for the construction of a new 3-story single-family residence, which will feature 2 attached garages and certain internal recreational spaces, along with, again, that over 3,300 square feet of landscaped open space, which spans over a quarter of the actual site. The programming for the new home, conscientiously so, and mimicking the features of many of the other residents on Lakewood Avenue, in particular, has the principal building situated toward the north end of the site, allowing for a large yard to occupy the south end of the site, rather, again, than being hidden behind the rear. This same design accommodation is found on at least 4 of the other properties on this block alone, all of which are situated on double lots, where the building is situated on one side of the parcel, with a large side yard and garage occupying the other side of the site. To wit, this pattern of development is present at the Palmer's immediate neighbor to the south, as well as the 2 properties immediately across the street on Lakewood to the west, both of which were granted variations by this board in order to build the improvements thereon. And each of those other buildings also spans the entire depth of their respective parcel, and therefore also enjoys a 0 rear setback. In order to further break up the facade of the proposed new home so that it does not seem optically imposing, the design team used a diverse mix of materials and levels of undulation throughout the programming. By example, the core of the new home will be 2 stories, just over 28 feet in height, which is 10 feet shorter than is permitted as of right under the current RT4 zoning, and which is even shorter than allowed in an RS3 zoning district. There is a small penthouse above the 2nd floor, which will contain offices for Justin and Kelly, both of whom work from home even without the COVID restrictions. The penthouse is set back 40 feet from the rear and 24 feet from the front building walls, respectively, thereby mitigating any incidental visual interference for the adjacent properties and further enhancing the streetscape. Towards those ends, almost every single home on Lakewood and Magnolia and Schubert, which are kind of the bordering streets, are at least 3 stories in height. So again, we're trying to stay just below that. Along these same lines, the proposal features 2 attached garages, which create the need for the 2 variations being sought here today with regard to the south side back, Mr. Chairman, as well as the front property line setback. That front property line setback's a little bit unique. It's not something you see every day, and that's because you oftentimes don't also see front driveways in residential areas. Again, as you'll see from a survey of Lakewood Avenue, almost all of the homes and buildings on Lakewood have driveways off the front, even though they do have access to an alley. Again, that's probably created by the prior manufacturing and factory uses in the neighborhood. So the Palmers wanted to embrace that and continue that, also due to the fact that they have 5 young children who are only going to grow and one day drive, since the Palmers do intend on making this kind of their forever home and keeping this residence, if approved, in the family for longevity and generations to come. There will eventually be 7 drivers in the Palmer family, and therefore probably up to 7 vehicles. As well, one of the Palmer's children does have special needs, so they have an in-home therapist that lives with them who also has a vehicle. So the 2 garages are actually necessary for the Palmer family. The front garage, which again triggers that front property line variation, and only by 4 feet, Mr. Chairman. If we were to meet the 20-foot strict requirement, it would completely shrink the garage so that it would be non-functional, because we wouldn't meet the interior requirements for the size width of a parking space. The front garage, which will be in the lower level, is intended for use mainly by Mrs. Palmer and her children. Unfortunately, the Palmers have been victims of quite a bit of crime in their current location, which has taken place in the public alley. I don't know if any of you board members hopefully have been fortunate enough to avoid that. I know myself, I have also been the victim of criminal activity in my own alleyway. So as a safety precaution, especially in light of all of the current influxes in crime, that front garage again is intended for use by primarily Mrs. Palmer and the kids. The rear garage, which will be accessed by the alley, the public alley, which is shared by the properties on Magnolia, that's located here on the south side of the building. It's 1 story in height, so very common to the other garages in the neighborhood. Mr. Chairman, you were asking about what triggers certain variations. The garage is what triggers the south side variation, and that's because it is attached. If the garage were detached, then it would not be considered an encroachment. But again, due to trying to maintain some balance on the property, we did have to attach it. And there's also utility poles that created kind of the function of how we oriented the garage. That garage is intended for Mr. Palmer and for likely his sons and their vehicles as they continue to grow. As you may have gleaned from this discussion on design for the new proposed home, the Palmers went to exceptional lengths in order to create an inviting and humble environment for their family, while also meeting some unique familial needs and to advancing a design that would enhance and be compatible with the character of the neighborhood and not to detract from it. The orientation of the home on the subject site, therefore, really drove the programming for the proposed improvements. So that in this instance, it is not the scale or size of the actual building and improvements that triggers the various forms of belief, but rather the way in which we are situating and orienting the building on the lot. To which it is extremely important to note that the Palmer's proposed new home is 3,000 square feet smaller than an as-of-right building and almost 10 feet shorter in height at its core. As well, again, the Palmer's will be providing 400% or over 2,500 square feet more open space than is otherwise required as of right. So that the size, scale, and bulk of the new home with all of its structural features meets all of the requirements and limitations of the zoning code as is. It is merely the orientation of the otherwise as of right home that necessitates the proposed variations. Moreover, and towards these same ends, all of the residential buildings on Magnolia Avenue to the east and Schubert Avenue to the north, as well as each of the buildings that adorn the west side of Lakewood Avenue, are similar to the Palmer's new home in terms of scale with regard to their respective sites. And almost every single one of them has a garage and or other improvements that sit at their respective rear property lines, or in other words, with a zero setback. So again, in order for the principal building wall to meet the front setback requirements, Mr. Chairman, we actually pushed the building back all the way to the rear, so that the two-story portion of the new home will be along the property line. That again allows us to maintain the predominant front setback that is enjoyed by the other improvements on the block, while also kind of remaining consistent with the properties on Magnolia that also have structures on their rear property lines. The Palmers and the design team believe this to be the least obtrusive design for all of the adjacent properties. This particular and precise positioning was very carefully crafted again, so to ensure the proposed new home was not just functional for the Palmer family and their distinct needs, but that more importantly, the new home was compatible with the character and pattern of the existing improvements in this neighborhood, and also beneficial to public welfare and in the very best interest of the other properties in the neighborhood. It was difficult, not merely inconvenient, therefore, for the Palmers and their design team to mimic the existing improvements in the area while also carefully situating their home on the site, so to be consistent with the pattern of development on the block and moderating any residual impact on the properties that created this neighborhood. So that in order to overcome these obstacles, the Palmers must respectfully petition this board for the subject variations, which again are wholly related to the orientation of the new home on an otherwise completely non-viable site, as opposed to for its size and scale, which again meet all of the strict requirements of the zoning code. It is in these instances that sometimes coming up with the programming for construction of a completely new building in consideration of the existing pattern of development and character of improvements in a particular area actually necessarily creates or further frustrates the practical difficulties around which a design team must work. As already established, therefore, the proposal for the Palmer's new home provides the least amount of burden and discord for the adjacent properties, while also still sustaining the character of the neighborhood and honoring the pattern of development of this particular block of Lakewood. So based on that and what, again, has been provided in the findings of fact, I think that's a pretty descriptive summation of the proposal, and I believe I touched on what triggers each of the variations, but I would like to get my witnesses on, so if there are any questions, we can.
Let's do witnesses first, yeah.
Okay, great. Again, Mr. and Mrs. Palmer and children, hi. I don't know which of you wants to speak for the family.
I can do it.
Justin, okay. Lucky again. Sticking with him then. Mr. Palmer, may you please state your name and address for the record?
Justin Palmer, 2661 North Lincoln Avenue, Chicago, Illinois.
Thank you. And Mr. Palmer, as we can see from our Zoom feed, you and your wife have 5 children between the ages of 2 through 9. Is that correct?
Yes.
And your oldest son does have some certain special needs around which you actually had to consider when developing the programming for your new home. Is that right?
Yeah.
And the 7 of you are currently residing temporarily in a condominium in downtown Chicago. Is that true?
Yes.
And that condominium, which you've been confined to for the last 2 years, has a little bit more limited access to meaningful recreational and outdoor space, as well as it just doesn't really have a sense of community. Is that right?
Right.
Towards this end, you and your family canvassed the neighborhood wherein the subject property is located for many, many months in an effort to find your new home. Is that true?
Yes.
You came across the subject property, which, although fraught with sometimes seemingly overwhelming obstacles and risks, would allow for you to create a new home for your family, quite literally from the ground up. Is that right?
Yes.
And you were drawn to this particular property and neighborhood because of the sense of community that you and your family experienced, even just walking through the streets. Is that right?
Yes.
And actually, over the last 2 years, even despite not having a shovel in the ground, you and your wife have been blessed to form some pretty incredible new friendships and relationships with the residents in the area. Is that correct?
Yes, it is.
Many of which of these new friends and neighbors have written letters of support for your proposal. Is that correct?
Yes.
Mr. Chairman and members of the board, I would like to note for the record that we have submitted prior to this hearing at least 7 letters of support from neighbors on this block of Lakewood, Magnolia, and Schubert, along with a letter of support from the local community organization, the Wrightwood Neighbors Association.
We have those.
Thank you. Towards this end, again, Mr. Palmer, over the last 2 years, instead of enclosing the currently vacant site with a fence, you actually kept it open to and for your neighbors to use with their children and pets. And it became increasingly meaningful during the last 3 months of the COVID restriction when the parks and other play areas were closed. Is that right? Thanks. And another meaningful community moment came for you and your family when you and your wife commissioned a mural to be painted on the existing northern face that fence that borders your property. Is that right?
Yes.
Which such mural brought together you and your neighbors and your respective families in quite a profound and a beautiful way in a time when so much of the city seemed divided. Is that right?
Very much so.
Thanks. And again, Mr. Chairman and members of the board, we, along with some of the letters of support and as well the Palmers, we did submit some photographs of this mural and the different family members and neighbors standing in front of it. It's beautiful. If you have a moment to drive by, I recommend it. It's truly breathtaking reminder of how thankful we all are for each other. And towards that end, they were also featured on WGN News. So it was a very good community bonding experience.
Council, notwithstanding that, can we stick a little bit more specifically to
yes, of course. I'm just tempting towards what Mr. Toyo was saying earlier. They, the Palmers have made a very vested effort to gain the support and also build relationships with the other neighbors in this area. So towards that end, Mr. Palmer, your programming again was really focused on your open space and then kind of your orientation of the building so that what So that it would not seem just like a blank facade covering all of Lakewood, is that right?
Yes.
Okay. I think then, Mr. Palmer, you so aptly retained Mr. Canoon to help you with your programming for the new proposed single-family home. So unless any of the board members have specific questions for the Palmers, I can turn it over to the architect for more of their technical testimony.
Let's do that.
Oh, just lastly, Mr. Palmer, as well, you were given findings of fact as well as an affidavit prior to this hearing. If you were to continue to testify, would your testimony be consistent with the statements that were made in those documents? Thank you. Mr. Canoon, may you please state your name and address for the record?
Ramil Canoun, 1050 West Hubbard Street, Chicago, Illinois, 60642.
Licensed architect in the state of Illinois. You just said
That's
that, and you've been actually doing work here in the city of Chicago for over 14 years. Is that correct?
That's correct.
And in particular, you've designed a lot of the homes and improvements in this particular neighborhood. Is that true?
That is true.
And so towards that end, Mr. Canoon, you're intimately familiar with the immediate area, the subject site, and all of the improvements surrounding it. Is that right?
That is correct.
And again, it's kind of your pattern and practice before you ever put a pencil to paper, so to speak, to go out and to actually personally survey a neighborhood and the site to look for any typographical conditions, patterns of development, character features around which you will begin your programming for all of your improvements. Is that true?
That is true.
And you actually did that in this case as well. Is that right?
Correct.
And you drew a lot of your creativity from the buildings on the west side of Lakewood Avenue, which have a very similar history to the Palmer site. Is that correct?
Correct.
And as well, you were also working around the very special needs of the Palmer family with regard to some of the additional recreational and open space that they require for their children. Is that right?
Correct.
And so as already described to the board, it's not the size of the Palmer's new home, which actually is quite a bit smaller in comparison to the other, or in comparison to the scale of the other homes and improvements in the area. It's not the size of the building that triggers these variations, but rather the way in which you oriented it on the site. Is that right?
Correct.
Mr. Canoun, can you just briefly, because I'm sure I've bored the board to death, explain to the board why you chose to situate the property towards the north end of the site instead of, again, centralizing it right there in the middle with kind of a longer wall?
Yeah, I mean, as mentioned before, our clients were looking to create a home that didn't have a very imposing facade along Lakewood. So the idea wasn't to create a 90-foot wide 3-story structure. The idea here was to create a more visual connection between open space and the street, which is a really critical program element for them in this design process. Now, in terms of orientation and where the house is located on the site, there were 2 main factors. One of them was basically capturing the majority of sunlight as the house kind of takes this U shape. As another important factor was to try and create a visual connection between a lot of the spaces within the house. So that inner shape or that inner perimeter of that U that you see right now up on the screen is where a majority of that natural light is obtained from. So in order to maximize that, the house is oriented to the south. Also, as you'd mentioned before, open space was a huge factor in this overall design. It's kind of a unique situation on Lakewood here where there's actually no east-west alley running across our north property line. So there are existing utility poles and power lines that run along that area or along that section of the north side. So for us to situate that open space for the kids, directly adjacent to or beneath those power lines, just didn't seem to make sense in this instance. So that was a lot of the drive as to the orientation and positioning of the house on the property.
And even still, with this programming, you will be maintaining the required 5-foot side setback to the north, as well as the front principal building wall will be meeting the predominant setback for Lakewood Avenue. Is that correct?
That is correct.
And again, our north building wall, which is only 2 stories in height since our penthouse is inset, is essentially abutting the rear of the properties that have frontage on Schubert. Is that right?
Correct.
And all of which buildings, except for one, have rear accessory structures that sit on the 0 property line. Is that right?
Correct.
And as well, one of those properties actually has an encroachment onto the Palmer's property. Is that right?
That is accurate.
So it's another unique typographical condition around which you had to work. As well, and towards these ends, one of the adversities which you had to overcome in creating the programming for the Palmer's new home was finding a way to keep it compatible with the pattern of existing improvements in the area, while also, again, maximizing that meaningful grade level open space and functional floor plates to meet the needs of the Palmer's, right?
Correct.
And again, you kind of looked to the improvements across the street on Lakewood in coming up with the programming for this. Towards that end, several of those improvements and buildings across the street, which again have similar histories to ours, have accessory structures and or entire principal buildings that span the entire depth of the lot. Is that right?
That's correct as well.
And again, at least 2 of those on this block of Lakewood alone had to come before this board for variations in order to permit their construction. Is that right?
Correct.
Thank you. So thereby, so your design is really a counterbalance of basically all of the standards and criteria for a variation. You had these adversities and these particular difficulties, but they were also kind of counterbalanced and or created by the fact that you also had to try and program the home so that it was consistent with the character of the immediate area. It did not have an adverse impact on the adjacent properties, and it was truly in the best interest for the other residents in this neighborhood. Is that right?
That is correct.
Then Mr. Canown, if you can just briefly confirm for me, in your professional opinion, whether you believe that the proposed variations being sought here today meet all of the standards and requirements for a variation as set forth in the current zoning code?
Yes.
Thank you. And if you were to continue to testify here today, would your testimony be consistent with the statements that were made in the findings of fact in your corresponding affidavit?
Yes.
Thank you so much. Mr. Chairman, I don't have any other questions. I have one other thing to note, which I believe it's in the findings of fact, but may also just be common knowledge. Because this property was previously zoned manufacturing, and because the underlying zoning change that was required to even convert the use from manufacturing to residential was effectuated pursuant to a type 1 zoning change application. The zoning change itself is tied not only to these variations, but to the underlying zoning change. As a result, if the variations are denied, unfortunately, the plans will be null and void, and the zoning will revert back to manufacturing, thereby making the property unviable for residential use and causing the Palmers to have to either dispose of the property at a complete loss or restart the process all over again. Just a consideration based on the history of our process.
Any questions from the board?
Yes, this is Jolene. Can you concisely just restate the hardship here?
Yeah, so, and Ramil or Mr. Canown, if you want to, you can as well. But again, the hardship, although we don't have what you generally see as a textbook hardship, there were certain particular difficulties, practical difficulties and adversities that we had to overcome, again, in order to build a new home that fit in with the existing pattern of the neighborhood. So Mr. Canown, if you can maybe expound on that for Commissioner Saul.
Yeah, I mean, really, typically what you find in the city of Chicago is when you're working with a 25 by 20, 125-foot lot, program and design of the house is fairly direct. With this being a larger lot and having the issue of utility poles and ComEd lines kind of situated to the north, that really drove a lot of the design decisions as to how it's situated on the lot, and also kind of capturing a little bit of that open space and being able to integrate that and have that visual connection to the street also was a drive in the overall design. So again, as Sarah mentioned before, the variances aren't really based on size or height. They're really more so based on the way the house is situated on the lot.
Any other questions from the board?
Yeah, this is Tim. So I guess you spoke a lot about the neighborhood association support and also the alderman support. I guess my question is, just with such a big residential development, if there was any pushback from neighbors in the immediate couple block radius.
No, as mentioned, so the community organization, the Wrightwood Neighbors Association, actually has an underlying planning and development or zoning committee. So we met with both. It was fully embraced by all of the members unanimously, which is quite shocking. I'm sure Commissioner Toya can expand. They're a pretty savvy group, and they're generally pretty skeptical of anything that requires relief. They were very supportive of it. Towards that end, Mr. Booth, Fenton Booth, who is the president of that organization, actually lives on this block. And he went above and beyond and also issued a letter of support for the project. And he is an architect and designer by trade. And then with regard to opposition, not much vocally, not really any vocal opposition to the proposal. We have been working with the north neighbors. The Palmers have been working with the neighbors that have their properties on Schubert because of those utility lines that Mr. Canown was referencing and that I referenced throughout. They're trying to find a communal or work together on maybe having those buried or changed because they are they have plagued that side of the property for quite some time. And when you have a vacant parking lot, they're not as imposing, but when you have families obviously residing therein, then it becomes a little bit more critical as well. Again, the one neighbor to the north does have that kind of encroachment in our property. So we've been working with him on an ongoing basis as well to kind of make sure to accommodate that.
Okay.
Any other questions from the board? Okay, thank you. We'll take it under consideration.
Thanks, everyone. Really appreciate it.
Thank you.
We're going to go back to regular order. This is 19120S for 3725 North Talman. And while we're getting everybody queued up, I'm going to read the department's recommendation. The Department of Planning and Development recommends approval of the proposed non-required accessory off-site parking lot to serve an existing recreational use located at 3626 North Talman Avenue, provided the special use is issued solely to the applicant, Chicago Fire Soccer Holdings, LLC, and the development is consistent with the design and layout of the site landscape plans dated June 11th, 2020, prepared by Terra Engineering Limited.
Everyone is in, Chairman.
Perfect. Counselor, will you identify your witnesses?
Sure. Thank you, Mr. Chairman and members of the board. My name is Liz Butler from the law firm of DLA Piper, located at 444 West Lake Street in Chicago. I, along with my colleague Mariah Debrino, represent the applicant in this matter, the Chicago Fire Soccer Holdings, LLC, also known as Chicago Fire Football Holdings, LLC. The applicant is requesting approval of a special use to establish an off-site parking lot to be located at 3725 North Talman Avenue, which will serve as non-required accessory parking for an existing recreational use known as the Fire Pitch, which is located at 3626 North Talman. I'm joined today by Jeff Wagner, who is the vice president of the applicant and the general manager of the fire pitch, and Jason Jarrett, a land use expert with the firm of Okrent Kissel Associates.
So, Mr. Kissel, do you swear to tell the truth in this proceeding?
It's actually Mr. Kissel's associate, Jason Jarrett, that's joining us today.
Got it. So, Mr. Jarrett, do you swear to tell the truth in these proceedings?
I do.
And we recognize your expertise.
Thank you.
Mr. Wagner, do you swear to tell the truth in these proceedings?
I do.
Okay. Counselor, let's do the short version on this one.
Sure. I'll just start with an overview of the proposal, and then I'll get my witnesses onto the record if that is okay.
Yep.
So again, the applicant is the operator of the Fire Pitch, which is an indoor and outdoor recreational facility that provides practice and gameplay fields for youth and adult soccer. During its outdoor season, which takes place from April to November, the Fire Pitch offers 2 full-size outdoor athletic fields. And during its winter season, the applicant operates a temperature-controlled indoor recreational facility. So it converts its existing outdoor into an indoor facility. The indoor facility has 5 turf fields and a smaller field for smaller games and training. The facility provides for over 100,000 square feet of indoor play space and bleacher seating for parents and fans. Youth leagues use the Fire Pitch for practice and competition. The Chicago Fire Rec Soccer League also uses the Fire Pitch to host adult recreational leagues, tournaments, and skills classes. The Fire Pitch is also available for rent. So the Fire Pitch site provides 50 vehicular parking spaces, which fully meets its zoning requirement on site. However, in order to accommodate overflow parking during the larger events that the Fire Pitch hosts, the applicant is proposing to establish this overflow parking lot at the subject property, which is located immediately across the street to the west of the immediately across the street from the Fire Pitch. So the parking lot that we're proposing would provide parking beyond what is required for the zoning ordinance requirements for the Fire Pitch. Here you see the subject property and aerial. It's bounded by a surface parking lot on the north, a business park on the east, and an existing commercial building on the south, and finally North Talman on the west. It's roughly 34,901 square feet in size, and today it's improved with an existing vacant commercial building and surface parking. The applicant is proposing to demolish the existing building and to redevelop the site with the proposed surface parking lot as shown on the site plan and landscape plan that we submitted ahead of this hearing. The parking lot will contain 87 vehicular parking spaces. The subject property is zoned M2-2 Light Industry District, which authorizes non-required accessory off-site parking when approved as a special use. Consequently, the overflow parking lot is permitted at the subject property if approved by the ZBA as a special use. The proposed parking lot is designed to promote pedestrian safety and comfort. It will be accessed by a single driveway off of Talman that you see at the north of the site. The addition of landscape peninsulas, perimeter landscaping, and ornamental fencing soften the pedestrian experience and permit a visual connection to the parking lot from the street, enhancing the users and pedestrians' sense of safety and comfort. The proposed parking lot complies with all of the applicable standards of the landscape ordinance, the stormwater ordinance, and the zoning ordinance. Today, 0 trees exist at the property, and as part of this proposal, the applicant will install 16 trees internal to the site, 3 parkway trees, and 4 perimeter trees for a total of 23 new trees. A total of 2,842 square feet of internal landscaped area is provided, which exceeds the requirements of the landscape ordinance. Granting the requested special use will allow for the use of the property in a manner that is compatible with surrounding land use and development, and that will result in no adverse impact on the general welfare of the neighborhood or community, and will be a benefit to the community. The applicant has discussed the proposal with its immediate neighbors and has met with the alderman's office. We understand that the alderman has issued a letter of support, which should be in your file. So unless there are any questions on these remarks, I can introduce my witnesses and get their testimony on the record.
Yeah, let's just get them briefly on the record.
Thank you. Mr. Wagner, could you please state your name and address for the record?
Yeah, my name is Jeff Wagner. My address is 419 North Oak Park Avenue, Oak Park, Illinois, 60302.
And you are the vice president of the applicant and you're the general manager of the fire pitch, right?
That's correct.
And DLA Piper, as counsel for the applicant, submitted proposed findings of fact and an affidavit signed by you in connection with this matter, right?
Correct.
And if you were to continue to testify today, your testimony would be consistent with your affidavit and the findings of fact, correct?
Yes, absolutely.
Thank you, Mr. Wagner. Unless there are any questions from the board for this witness, I can abbreviate my direct examination of Mr. Wagner and turn to Mr. Jarrett.
Let's do the abbreviated and then we'll do questions at the end.
Okay, thank you. Mr. Jarrett, could you please state your name and your address, and your business or profession for the record?
Yes, Jason Jarrett. I'm a certified planner with Oakert Kissel Associates. We have offices at 122 South Michigan Avenue in Chicago.
Thank you. And you were retained by the applicant to conduct an urban planning analysis of the proposed special use, correct?
That is correct.
And is it correct that you have, is it correct that you've prepared a report detailing your analysis and findings and conclusions? And that was submitted to the board ahead of this hearing?
Yes, that is correct.
And if you were asked to testify further, your testimony would be consistent with those findings and conclusions in your report, specifically that the proposed development is consistent with the standards for approval of a special use.
Yes.
Right?
Yes.
Thank you. We only have two witnesses and we're available to either continue with testimony and direct examination of either of the witnesses or to respond to questions from the board.
Are there any questions from the board? Okay, we will take it under consideration.
Thank you.
Thank you. Next up, we are going to move to 19420Z. This is for 1301 South California. Counselor, why don't you introduce your witness? I'll swear him in and we'll go from there. You're on mute.
I'm sorry.
Yes. You muted yourself again.
Okay, can you hear me now?
Yep, we can.
Okay, after the calls began, we actually received a phone call from Alderman Irvin's office asking that the matter be deferred for a month. We have no, it's the first time the case is up. We have no objection to the matter being deferred to the July date if it's still open or available.
So 19420Z request is for continuance until July 17th. Anybody else want to speak on that continuance request? Okay, so 1301 South California Boulevard, we will continue that until July 17th and no further notice will be given. Let's move next to 19520Z for 4630 North Malden. Let's see, Counselor, I understand we have a witness speaking in opposition on this one.
Yes.
Great. And have you already communicated with the objector?
We have not communicated directly with the objector. We have communicated with the community organization. And we do have a letter of non-opposition, which is on file. Unfortunately, with the virtual format, we haven't been able to discuss the matter with the objecting witness.
Okay. And is that something you would like to do or you'd rather proceed?
Possible. I'm not sure how to, I'm not sure how to do that virtually.
Sorry, you cut out in the beginning. You would like to, if possible?
Possible, yeah. I just don't know how to do it other than maybe a phone call, how to do it virtually.
Sure. Do you know, Mr. Risa, do we have the phone number for Mr. Schaefer? Or Schaffner, is it?
I do not.
Why don't we attempt this? Is Mr. Schaffner, right? Mr. Schaffner, are you present?
I am present.
It was fine.
Are
He
you
called me
willing?
and I told him like,
Are you willing to discuss this with the counselor for the applicant?
Yes, I am.
Okay, so then what, why don't we do it this way? If you will send Mr. Risa, who I'm hoping you have his email already from some communication, your phone number, he can share it with the counselor, and we'll continue this one until the end of the call today.
Okay. Oh my God, the only address I have is the ZBA at cityofchicago.org.
That one will work.
If you, okay. I'll be happy to, I'll send an email. Shortly.
Okay. And then counselor will go through 19620 since that one is yours as well. And then after that, you can take a few minutes and discuss and see if you can resolve the issue. And then we'll come back to it at a later point in this meeting.
Thank you.
Okay. So then we're going to skip ahead to 19620Z. And this is for 3942 North Hoyne Avenue.
Everyone is in for 196.
Thank you very much. Okay, so then counselor, if you'll introduce your witnesses, I'll swear them in, and then let's do the short version for this.
No problem. I have two witnesses testifying. One of the owners, Mr. James Lloyd, and then our project architect, Mrs. Lisa Rizzolo.
So Mr. Lloyd, do you swear to tell the truth in this proceeding?
Yes, I do.
And Ms. Rizzolo, do you swear to tell the truth in this proceeding?
I do. Yes.
Okay. So counselor, it looks like you're attempting to essentially do a replace a porch, and you're following the same footprint of a currently existing non-conforming property. Is that correct?
That's exactly right. As you can see from the photo, the house favors the north side property line. There already is a frame porch, and we're proposing to replace it. And the hardship in this case is in that in order for the addition to line up with the rest of the home, and again, be fully integrated into the home, we need to follow that building wall line. So the variation is required.
Okay. Can you get your witnesses on the record?
Sure. Mr. Lloyd, can you state your name and address for the record?
Name is James Lloyd. I live at 3942 North Hoyne, Chicago 60618.
You and your wife own the subject property that you live at?
Yes, we do.
And you're seeking the variation to permit the addition that we just described with the chairman. Is that right?
That is correct.
And you're not selling this property or have any plan in the immediate future to sell the property. You're doing this project for you and your family to use and enjoy. Is that right?
Absolutely, yes.
And is it your understanding that my office filed witness statements on your behalf in this case?
It is, yes.
And if you were to continue to testify, would that testimony be consistent with the statements we've provided?
Yes, it would.
Great. Lisa, are you available?
You just cut out there a bit. I'm not sure if that was for me.
Lisa, are you there?
I am.
Just getting you on the record. Can you please state your name and address for the record?
Sure. Lisa Rizzolo at 225.5 Greenwood Street in Evanston, Illinois. I'm a licensed architect in Illinois.
And you prepared the program for the proposed porch at the rear of the property?
I did.
And again, it's your position or professional opinion that the existing non-conforming building condition is the hardship the variation is directed to overcome.
I do.
And it's your understanding that my office filed witness statements on your behalf in this case?
Yes, I do.
And if you were to continue to testify, that testimony would be consistent with the statements we've already provided. Is that right?
That is correct.
Great. Chairman, again, we make our team available for questions if any of the board members have questions.
Any questions from the board? Okay, thank you. We'll take it under consideration. And then Counselor, if you'll let Mr. Risa know when you've had a chance to convene with Mr. Schaffner on 195, we'll try and get you back in before the end of the call.
Great. I really appreciate it. Thank you.
Okay.
Thank you.
Thank you. We are going to move ahead to 220S and 220S. This is for 2368 North Elston and 2356 North Elston. While everyone's getting settled for that one, I will read the department's 2 recommendations for those matters. For 220S, the Department of Planning and Development recommends approval of the residential use below the 2nd floor to convert the mixed-use development with commercial space and 5 dwelling units to a multi-unit residential with 7 dwelling units and 2 parking spaces, provided the special use is issued solely to the applicant 2368 North Elston LLC, and the development is consistent with the design and layout of the site plan dated July 3rd, 2019, multi-unit residential plan dated November 8, 2018, and coach house plan dated June 23rd, 2020, prepared by Aiello Architecture Design. And for 20120S, the Department of Planning and Development recommends approval to utilize 7 of the 36 parking stalls to serve the conversion of 2368 North Elston Avenue from mixed use to multi-unit residential with a total of 7 dwelling units, provided the special use is issued solely to the applicant 2368 North Elston LLC, and the parking garage and lot are maintained consistent with the design and layout of the site plan dated July 3rd, 2019, prepared by Aiello Architecture Design. Counselor, if you're on the line, why don't you identify your witnesses for me? I'll swear them in and we'll go from there.
Chairman, this is tech support. Did you say 220?
220S and 20120S.
Oh, 200. Okay, sorry. Let me bring them in. Okay, they're in.
Okay, Counselor, why don't you introduce your witnesses?
Yes, Mr. Chairman, members of the board, my name is Mark Kupiak. I'm an attorney with offices at 77 West Washington, and I represent the applicant. And I have with me today on the call, I have my associate Agnes Pleckham. I also have Bruce Wallenberg on behalf of the applicant, Mike Aiello, the project architect, and Joe Ryan, our expert witness.
Mr. Wallenberg, do you swear to tell the truth in this proceeding? Mr. Wallenberg, you're on mute. Still on mute. While you're figuring that out, Mr. Aiello, do you swear to tell the truth in this proceeding?
Yes, I do.
And Mr. Ryan, you swear to tell the truth in this proceeding?
I do. Sorry.
And we recognize your expertise, Mr. Ryan. Mr. Wallenberg, you swear to tell the truth in this proceeding?
Yes, I do.
Okay, Counselor, go ahead.
Thank you, Mr. Chairman. And Mr. Chairman, as you mentioned, we have 2 cases, 2 related cases. The first one is a request for special use to allow dwelling units below the 2nd floor. And the second case related, there's a building next door at 2356. That is an existing condominium building. The applicant owns 7 parking spaces in that building. And the second case is a request for a special use to allow the applicant to count those spaces as accessory spaces for this conversion at 2368. And I think with that, I call my first witness, Bruce. Bruce, are you on?
Yes, I am.
Bruce, state your name and your address.
My name is Bruce Wallenberg. My address is 405 South Ojibwa Trail in Mount Prospect.
Bruce, is it true that your LLC owns the subject property at 2368?
Yes,
And that this property is improved with an existing building that contains commercial space on the ground floor?
yes,
And that commercial space is currently vacant?
correct.
Any idea how long it's been vacant?
At least 5 years.
Good. The plan is to convert that space to 2 additional residential units for a total of 7 on that site. Correct?
Yes,
Any idea who would live in those 2 additional units?
yes, my wife and I would live in the front, and our adult children would be living in the rear.
Okay. And Bruce, obviously you talked to the condominium association next door and they have consented to these applications.
Yes, they have.
and talk to your neighbor on the other side also, correct? And Bruce, you signed an affidavit in connection with this case today,
Yes, I did.
and we filed that application on your behalf. And if I were to continue questioning you, would your testimony be consistent with that affidavit?
Yes, it would.
Thank you. No questions, I'd go to Mike Aiello. Mike, are you on?
I am.
Mike, would you state your name and your address?
Yes, Michael Aiello, 1800 Glenview Road, Glenview, Illinois.
And Mike, you're the project architect?
Correct.
And Mike, you had signed an affidavit in connection with your testimony here today,
Yes, sir.
and we submitted that affidavit on your behalf. If I were to question you, Mike, would your answers be consistent with the information in that affidavit?
Yes, they would.
Good. With that, I think we'd attempt to rest on the affidavit unless there were questions.
Any questions from the board?
I've also got Joe Ryan too, special use.
Sure. Why don't we go to Mr. Ryan as well? Actually, Commissioner Saul, do you want to ask your question?
Yeah, just quickly, you said that the commercial space has been vacant for 5 years. Any insight into why it's been difficult to lease that space?
Is that question for me?
If you're the best person to answer.
Yeah, Bruce, I think you're best. Could you answer?
Okay, well, the previous owner said they tried to rent it for 3 years before we purchased the property, and had no success in doing that. Then we purchased the property trying to make it a space where we could live in. Part of the reason is also my brother's in a wheelchair and that it has ground floor access.
So it was marketed essentially for 3 years, it sounds like.
Pardon?
It was marketed then for 3 years unsuccessfully when you had,
Correct.
you were not continuing to market it as a commercial space.
Correct.
Sorry, Commissioner Saul.
No, that's what I was going to ask. Thanks.
Okay. Why don't we get Mr. Ryan on the record, and then Mr. Ryan, I would like you to just talk a little bit about the commercial in the area.
Joe, would you state your name and your address?
Joseph M. Ryan, MAI, President, LaSalle Appraisal Group with offices at 9455 South Point Avenue in Chicago.
And Joe, did you prepare a report in connection with your testimony here today?
I did.
And that contains your credentials along with materials supporting your opinions. Is that correct?
That's correct.
So Joe, you're familiar with the subject property and the surrounding neighborhood?
I am.
And also aware of the proposed use?
Yes.
Joe, is it true that this use complies with all the applicable standards of the zoning ordinance?
It does.
And again, Joe, I'm asking these questions directed to both the cases, the special use for residential on the ground floor and the parking in the condo building next door. Understood?
Yes.
Joe, also true that these uses will not have a significant adverse impact on the general welfare of the neighborhood?
No, they will not.
And Joe, if I were to continue to question you, is it true your answers would be consistent with the report that we filed on your behalf?
Correct.
And Joe, would you specifically respond to the chairman's question about the other business uses in the neighborhood?
Yes, there's a significant amount of first floor commercial retail spaces that are vacant, primarily due to the fact that street parking is not desirable for consumers and they would prefer to shop in strip centers and or shopping centers. So that probably answers the other commissioner's question about why this retail was vacant for so long.
Any other questions from the board? Okay, we will take it under consideration. Thank you.
Thank you very much.
Next up is 20220Z for 613 West 47th Street. Okay, Counselor, why don't you introduce your witnesses when you're ready?
Thank you, Mr. Chairman. My name is Mark Kupiak. I'm an attorney with offices at 77 West Washington. and I represent the applicant. And I have with me today on behalf of the applicant, I've got Kelly Chang, and we also have Ron Very of Very Architects, the project architect. And also my associate Agnes Pleka, also on this call.
Ms. Chang, do you swear to tell the truth in these proceedings?
Yes, sir, I do.
And Mr. Very, you swear to tell the truth in this proceeding? Mr. Very, you are on mute. If you could unmute yourself.
Is that okay?
Perfect. Do you swear to tell the truth in this proceeding?
Yes.
Okay. Counselor, take it away.
Thank you, Mr. Chairman. And one case, and this is a variation, it's a variation for the rear setback. And our situation is the property is improved with an existing building, and the existing building currently houses an existing ongoing business. And as Ms. Chang would shortly testify, business reasons, she needs to buy some additional modern equipment and needs additional floor space to accommodate that equipment. Our unique circumstance that causes our particular hardship in this case is we're dealing with an existing building. And actually, the existing building itself has a zero rear setback. The other unique feature is that even though the property is zone manufacturing, which generally would not have a rear setback requirement, in this particular case, though, we do have a residential district across the alley to the south. And the code does provide that if you've got a residential district across the alley, then that does trigger a 30-foot rear setback. So as the architect would testify, his particular problem in designing this is to, number one, provide the square footage necessary to house the new equipment, and of course, a floor plan that would be consistent to access this addition from the main building, so it could be used as part of the existing business. So that's where we are. First witness, Kelly Chang. Kelly, you're there. Can you state your name and your address?
My name is Kelly, Kelly, last name Cheng, Cheng, from 613 West 47th Street.
Kelly, is it true that you are a member and a manager of the applicant LLC?
Yes.
And Kelly, you also noticed that the owner of this property is Eric Chang. Are you any relation to Eric?
That's my father.
All right, very good. Kelly, is it true that the property is improved with an existing building?
Yes,
And you've got an existing business in that
we
building?
do. We do.
Is it a tofu processing facility?
Correct. Our plant is actually separated into two parts. One part is a bean sprout growing room, and that's on the dock side of the building, so that's not in question right now. The addition is for the tofu room, which is next to the vacant lot right now that we want to build upon. We are trying to purchase a new tofu machine. The current one we've had about 8 years, and we wanted to add to that line so that we could be more efficient in producing tofu that isn't handled as much with hands, and this new machine will do that.
Good. And Kelly, about how long has the business operated at this location?
At this location, we've been there about 8 years now.
Good. And Kelly, is it true that these new machines are necessary for the conduct of the business?
Yes, it is, because we are finding that there are a lot of new competitors in this industry now. Most of them are giant factories that are slowly edging out smaller places like us.
Kelly, any idea about how much you're going to invest in the new equipment?
Just on the machine alone, we're probably looking at around $2 million when we're done.
Good. Kelly, also true, you need additional square footage and additional building to house this new equipment?
Correct, because this new machine is kind of an all-in-one, and we didn't want to take down the old one so that we can still do more artisanal types of products. The square footage of the new machine would not fit even if we took out the old machine. So the only solution left for us was we build into the vacant lot next door.
Good. And Kelly, this addition is going on the eastern side of the building, correct?
Yes, I'm very bad with cardinal directions, but that, if you put it that way, that would be correct.
Okay. And then the larger parking lot on the west is going to remain?
Yes, because we have a dock there, and that's where all the deliveries come in from. So we want to make sure that that is not touched.
Good. Kelly, do you have an opportunity, either you or your father, to talk to some of the nearby neighbors about this case?
Yes, my dad is pretty friendly with the neighbor on the east side. That's the building on the corner there. His name is Marco. I've never caught his last name, but we've been discussing with him on and off the last 2 or 3 years what his thoughts were if we put something up. He currently actually has a pod in our vacant lot right now as a part of a rental, and he's okay with removing it. He just needed this temporary storage, and he doesn't oppose it. He's actually thinks it's a good idea. The neighbor to the west of us was recently sold, and my dad also happens to know the new owner because he's in Chinatown. Apparently they're friends from long enough that they knew each other, and so he doesn't have any objections either. It doesn't affect him as much simply because he's on our west side and not our east side.
Correct. And also you reached out to the Alderman Thompson?
We have.
And Mr. Chairman, please note, I believe Alderman Thompson did send a letter on this case. If you have it or if not, but we did reach out to his office also to explain the case. And I believe you also have a letter of support from the Flag Club across the street, who had no objection to this application and sent a letter to that effect.
I believe we have them, yes.
Okay.
We have the Flag Club. While you're proceeding, I'll just confirm on the Alderman's letter. Was that the end of your?
Kelly, is it true that you signed an affidavit in connection with this case today?
Yes, I did.
And we filed that application on your behalf. And if I continue to ask you questions, would your answers be consistent with that affidavit?
Yes, they would.
That's all I have of Kelly.
Great, let's keep going.
Ron Berry, Ron, are you on?
Yes.
Would you state your name and your address?
Ronald A. Very, 824 North Racine, Chicago, Illinois.
And Ron, you're the project architect?
Yes.
And your plans we filed with this application?
Yes.
And Ron, was my description of the case fairly accurate?
Yes.
Obviously, your commission was to provide additional floor area for the new equipment.
Correct.
Makes sense to put it on the eastern side of the building, the addition?
That's the only way it should go because the operation of the existing business is at that end of the building already. So the expansion naturally has to go that way.
Good. Ron, also true that the existing building extends pretty much close to the rear lot line without a rear setback?
That is correct.
So the variation we're asking for the addition is really not out of character considering the location of the existing building.
No, in fact, it's a little bit of an improvement in that we set it back by 6 feet.
Exactly. So actually be set back more than the existing building.
Yes.
Good. Ron, true you signed an affidavit in connection with your testimony here today?
Yes.
And we filed that affidavit for you. And if I was to continue questioning you, would your answers be consistent with that affidavit?
Yes.
With that, we'd rest on his affidavit unless there were questions.
Any questions from the board? Okay, we will take it under consideration. I don't see, so Counselor, I don't see a letter in our file from the Alderman on this one, but we'll confirm. And if it was submitted on time, we'll take a look at it before our consideration.
That's fine. I was just trying to represent that we did reach out and testify that he's aware of the case.
Yep, I got it. Okay, thank you. We will take this one under consideration. Next up, we will do 203-20Z and 204-20Z for 1453 West Grand Avenue. Counselor, I will note we have a witness who's registered in opposition, or Rebecca Fitz. Is that somebody that you or the applicant have discussed this case with?
Well, Mr. Chairman, I only became aware of her interest earlier this week, and I tried to contact her both by email and telephone. She did respond to my email and suggested that she didn't have any questions about the case. I responded back to her that actually the board's direction is that if someone has objections, that they should reach out to the applicant before the hearing. So I made her aware of that. And then because we were not able to connect I voluntarily, even though not asked, we voluntarily sent her a copy of the plans to look at, because I was actually hopeful if she understood the plans, there might not be a question. So we have not talked.
Ms. Fitz, are you on the line? And if you are, you have to unmute yourself.
Okay, there you are.
Is the nature of your opposition something that is worth discussing with the applicant and attempting to resolve?
Yes.
Okay, so why don't we do this? Counselor, I'm assuming then that you and the applicant are open to attempting that discussion?
Sure.
Okay, so do you have, it sounds like already Ms. Fitz information?
I'm sorry, say again?
It sounds like you already have her phone number?
I have her phone number, yes.
Okay, so then why don't we, I believe this is the last one we have for you on our call, so why don't we, we'll continue on this one until a little bit later in today's session. Why don't you two see if you can discuss this and come up with some sort of arrangement? And then when you're ready, if you'll let Mr. Risa know, we will bring you back up today.
Okay.
That make sense, Ms.
Sure,
Fitz?
sure does. Thank you.
I guess so, yeah.
Okay, why don't we see if we can, we like everybody always to at least attempt to work it out. And one way or the other, then we'll have everybody back today. Okay, thank you.
Thank you.
We will next jump to 205 20S, 206 20S, and 207 20S, all for 309 to 319 North Justine Avenue. And while we are getting everybody set up, I will read the department's recommendations. So for 205 20S, the Department of Planning and Development recommends approval of the proposed cannabis infuser facility, provided one, that the special use is issued solely to the applicant Growen LLC, two, the proposed shared cannabis craft growing and processing uses as per applications 206 20S and 207 20S have been approved by the Zoning Board of Appeals. 3, no retail sales, samples, or physical product displays or stock are allowed at this facility. And 4, the development is consistent with the design and layout of the plan dated February 27th, 2020, prepared by Crosby and Associates. For 206 20S, the Department of Planning and Development recommends approval of the proposed cannabis craft grower facility, provided 1, the special use is issued solely to the applicant Growen LLC. 2, the proposed shared cannabis infusing and processing uses as per applications 205 20S and 207 20S have been approved by the Zoning Board of Appeals. 3, no retail sales, samples, or physical product displays or stock are allowed at this facility. And 4, the development is consistent with the design and layout of the plan dated February 27, 2020, prepared by Crosby and Associates. Finally, for 207 20S, the Department of Planning and Development recommends approval of the proposed cannabis processor facility, provided 1, the special use is issued solely to the applicant Growen LLC. 2, the proposed shared cannabis infusing and craft growing uses as per applications 205 20S and 206 20S have been approved by the Zoning Board of Appeals. 3, no retail sales, samples, or physical product displays or stock are allowed at this facility. And 4, the development is consistent with the design and layout of the plan dated February 27th, 2020, prepared by Crosby and Associates. So this one, I believe, is the pro se. Am I correct on that?
That's correct. I'm an attorney as well, but it is pro se on behalf of Growen LLC. I'm a member of Growen LLC as well.
Okay, why don't you identify yourself for me, and if you'll go ahead and identify the rest of the witnesses in the case, I'll swear everybody in, and then you can present your application.
Excellent, thank you. My name is Paul Montez with offices at 1740 West 99th Street, Chicago, Illinois. With me, I have Steve Hamilton, who is a member of Growen LLC. And on the phone should be Peggy Montez, who is a member of Growen LLC, also Weir, who is our land planner.
Got it. And we recognize Mr. Musawir's expertise. So, Mr. Montez, do you swear to tell the truth in these proceedings?
I do.
And Mr. Hamilton, do you swear to tell the truth in this proceeding?
I do.
And Ms. Montez, do you swear to tell the truth in this proceeding? You broke up a little bit. Will you repeat that?
Yes, I do.
Great. Are you listening to the live stream?
Hello?
Are you using two different maybe mics?
Am I using what?
You have two different microphones, perhaps? Or you on the phone, maybe you have a computer on at the same time?
Okay, you can't hear me, is that it?
There's an echo I'm hearing.
An echo? Okay, hold on. Hello?
Yes?
Can you hear me now?
Yes, we can.
All right then, okay. I was on speakerphone.
Got it. Okay. Why don't you go ahead then and proceed with the case, Mr. Montez?
So my name is Paul Montez and I am representing Groen LLC. Groen LLC is a two-family LLC. It's a partnership between the Montez family and the Hamilton family. With us, we have our land planner, Kareem Sarwir, who I believe has joined us online. And our joint venture is for a specific use as a craft grower, a processor, as well as an infuser. Groen LLC has actually applied for its license as a craft grower, which includes 3 activities with the Illinois Department of Agriculture. It should be noted that this location will not be used as a cannabis dispensary, nor will it have any retail operations. Pursuant to the special use requirements, we sent out notices, proof of affidavits, all of which have been submitted to the board. Additionally, we have mailed out notices to the surrounding neighboring properties within 250 feet, as well as delivered notice to the alderman of the 27th Ward, Walter Burnett, the chairman, as well as published in the Tribune newspaper information about our public community meeting that was held on March 19th, 2020 at 7 p.m. That meeting was held at 1520 West Fulton, which is located within the 27th Ward and is adjacent to the property. All notices and affidavits, as well as photos of our sign-in sheet, were submitted with our application. Shortly before the meeting that evening, we were informed by the alderman's office that he would not be able to attend. However, that meeting was attended by approximately 10 people. I believe only 5 people actually signed in. We have a photograph of people at that meeting that was submitted with our proposal as well. There were no objections from anyone present at that time, but there were questions regarding operations, traffic, security, as well as smell. So those issues were addressed with no oppositions. Again, as I stated initially, Groen LLC is a partnership between the Montez and Hamilton families. The Montez family controls approximately 56% of Groen LLC, with Peggy Montez being its CEO, myself, Paul Montez, being CFO, and Steve Hamilton has a 44% stake in the company, and he will operate as our COO. All 3 members are lifelong members of the Chicagoland area, and we are outstanding business community and philanthropic members of the community. Groen LLC is also applied as and will qualify as a social equity applicant under the craft grower license with the Department of Agriculture. Groen does not have any other parties affiliated with the business. There will be no other business entities involved with the business. Merely the 3 members of Groen LLC are the owners and will be the operators. I'm going to discuss the building at this point in time. The building that we're looking at having our special uses in is 309 to 319 North Justine. That building is a single story brick building of approximately 12,500 square feet with an enclosed loading dock. The building is located within Planned Manufacturing District 4B. The owner of the building is a single member LLC, 309 Justine, of which Steve Hamilton, who is also a member of Groen LLC, is the sole member. The building is currently vacant. However, it's undergone major improvements, including electrical, plumbing, and HVAC for a tenant that has breached their lease. There are no substantive changes to the streetscape and the street facade of the building as we propose. Actually, once operational, there will be nothing to indicate that the building is housing a cannabis grower, processor, or infuser. There will be no conspicuous signage, nor lighting to bring any attention to the activities that will be within the building. With approval of the special use as sought today, the building will find a new life based on its floor plans. At this point, I'd like to have Steve kind of walk you through the floor plans and how the operations will actually occur.
Thank you, everyone. So within the 12,000 square foot building, we're going to have about 5,000 square foot of canopy. And each room is a different grow room and it has a different purpose. So think of each room as similar to a walk-in cooler. This way we can certainly mitigate smell, and we can have temperature and humidity controlled in each room. So there are about 5 grow rooms. We also have extraction room, infusion room, a drying room, as well as a trimming and packaging room. Within the building, we have 100% surveillance that goes directly to the state police. In terms of odor mitigation, we're using state-of-the-art activated carbon filters, which remove about 99% of the smell.
Let me jump in from there. So if you look at our floor plan, the plan is actually designed operationally. If you look at our bedroom, so there's a bedroom which is on the far, that would be to the far right in the picture that's being presented. So from the bedroom, the flowers, as they continue to grow and develop, they move from room to room to room, where they end up in the last room, which is flower room number 3. From there, they then go into drying, and from drying, they then get processed. So the processing will be one of 2 things. After drying, they either get packaged, trimmed, they get trimmed first, and they will either then be packaged, or they will go to extraction. The extraction room, which is one of the which is one of the special uses, the extraction room has a room within itself. And the extraction process, once that product is extracted and becomes liquid, it is then used in the infusing room for tinctures, for edibles, as well as creams. So the process then moves to that room. The other thing that we have on site, we will have a vault. So all product will end up in the vault. We will not be housing cash on premises. As Steve said before, the property itself will be completely surveilled. There will be surveillance cameras throughout the entire property, as well as above and outside on both the street side, as well as the interior of the rear of our property. That surveillance is also connected per state statute with the Illinois State Police, and it's required to have battery backup as well as to have cloud storage at all times, so that all cannabis related products and anyone that comes in contact with any product will be surveilled and recorded through our system that we'll be implementing. Let's see. Again, there will be no changes to the streetscape as it currently stands. As far as windows are concerned, there is a requirement that by the state that no cannabis or cannabis products can be visible from the street. I believe there's a picture that shows our streetscape. Those windows on our street side will be that one, if you could go back, thank you. So where you see paper currently, that's approximately 10 feet from ground level. To that area, those windows will then be filmed with a 3M security film that will also be opaque. It'll allow light in, but it will not allow people to actually view within the facility itself, because the extraction room and the infusion room are the 2 rooms that you'll see directly behind that tree. Again, our site will not be open to the public in any way, shape, and form. The state requires that any visitors to the site are registered through the state itself. Hours of operation will be typical of those within the surrounding warehouse district. We're looking at from 7 to 11 if there are possibly 2 shifts, but in general, there would be 1 shift, which would go from 7 until 3 as normal business hours. Grown anticipates approximately 30 to 40 jobs will be created during the construction or the rehabilitation of the property, as well as 10 to 20 permanent jobs when fully operational. As far as transportation is concerned, we have a dock which is enclosed, and all transportation and transfer of products will occur behind that closed and surveilled secured loading dock door. All transporters are state licensed companies, and they will be driving in conspicuous vehicles. All product will be transported in state-approved containers, and all movement of product will be monitored internally as well as by the state using a state-of-the-art logistical system. Systems are being developed within our plans to control air handling, odor, air purification, including our carbon filtering, as well as water recapturing and purification on site. The goal of Grown is to be a leader in the cannabis craft growing arena by utilizing state-of-the-art processes for techniques of growing, as well as products and production. Next, as far as operations are concerned, the state of Illinois grants a single license for a craft grower. That license then allows the craft grower to operate all three activities, which we're here for our special use. So all three activities include the growing, the processing, and infusing, and all of those are under that state license. And again, all three of those activities will occur outside of public view. The 20 employees that we're looking at employing, 10 to 13 of those employees will be working in the craft growing arena. Between 2 and 4 will be in the processing, and between 2 and 4 will be in the infusing activities area. Grown's goal is to have a diverse workforce that's reflective of its ownership. We're focused on creating jobs, not just jobs, but careers in this new and growing industry. We're also focusing on employing those that have been impacted by the war on drugs, especially those in disproportionately impacted areas, especially people of color, women, veterans, and our growing population of those over 45. We've met with and will continue to meet and work with Chicago State University and Olive Harvey College in developing and implementing curriculum in conjunction with their certificate programs, which currently are only focused on dispensaries. Our average salary will start at a minimum of $16 an hour with full benefits for all employees that are full-time. Mrs. Montez, if you'd like to speak a little bit on our diversity plan.
Our diversity, hello?
We can hear you.
Can you hear us?
Hello?
Yes,
hello?
We can hear you. Go ahead and proceed.
Oh, you can hear me. Yes, in terms of our diversity plan, we feel that it is very important, definitely for us to be able to reflect the underserved people within the city of Chicago. Definitely we're talking about the underserved minorities, underserved women, underserved those who are over 45 years old, definitely the seniors. So we definitely will be projecting that we will have a very, very diverse workforce.
I'd like to move to our land planner, Kareem Musawir.
Yes.
Can you state your occupation? I believe you've been before this board before, but can you state your name, address?
Kareem Musawir, land planner, 221 North LaSalle Street in Chicago.
Thank you. And have you prepared a report and an affidavit in conjunction with your testimony today?
I did, yes, sir.
Excellent. And if you were to further testify, would the information you give today be accurate and reflect that information that's within your prepared statement?
Yes, it would.
Okay. Do you want to ask you a few questions about the surrounding areas? Have you had the opportunity to visit the site?
I have.
And can you tell us about the site and the immediate uses within the surrounding area?
Yes, the site is in PMD. It's in a PMD, And there are manufacturing uses on all sides of it. There's a glove company across the street. There's a plant distribution company down the street. The existing building is, as proposed, will not be added to it in any manner outside of what's going on inside of it. And the facade will remain the same except for the treatment of the windows that you described. The use is mostly small and 2 and 3 story, 1, 2, and 3 story buildings in the area. Parking doesn't seem to be an issue. And the operation in the area amongst friends, you know, when visiting different businesses over there, they seem to know what's going on, and they appreciative of the improvement that's going on in this building.
Excellent. Are there any residential uses in the surrounding area or within the next 1,000 to 1,500 feet?
There are no residential uses within 1,500 feet of the site.
And is the operation that's being proposed similar to that of an urban farm?
It is, as a matter of fact. If it was on the ground, it would look just like a farm with various rows of development.
And let's go through the standards. I'm sorry, sir. First, does the proposed special use of a craft grower, processor, and infuser comply with all applicable standards of the zoning ordinance?
It does, yes.
And are the proposed special uses, all three, in the interest of the public convenience and will have no significant adverse impact on the general welfare of the neighborhood or community?
Yes, well, this product hit the market, and there were a number of occasions where there was a shortage of product. So making the product available to the public is a public convenience. And the operation of it as proposed will not have any negative or deleterious effect on surrounding property values.
Are the proposed special uses compatible with the character of the surrounding area in terms of site planning and business scale and the project design?
Yes, again, this structure will not be added to in any way, so it's going to remain a one-story building. The uses in the area are all manufacturing uses. Most people come and go about the same time of day and night. Some of them, although, are 24-hour operations. So there is very good compatibility here.
Excellent. Are the proposed special uses compatible, again, with the characteristics of the surrounding area in terms of operating characteristics? I believe you just answered that question, or if you wish to expound additionally.
Right. Again, the area has, although there are a number of things going on east of this, the area immediately around the proposed site is a manufacturing area, and that's what's going on. And a smaller manufacturer, so people are coming and going during the course of the day and evening for those businesses that are open for 2 and 3 shifts.
Excellent. Are the proposed special uses designed to promote pedestrian safety and comfort?
They are. There's no entering and exiting except through the existing garage, and that is a controlled operation where only state licensed vehicles are entering into the facility, and nothing happens until that door is closed, and then the operation of moving those products from that state licensed vehicle is done in a controlled environment with state-sponsored or state regulated containers. So it's very well controlled.
Will the proposed special use have a negative impact on existing manufacturing activities, including the potential for land use conflicts or nuisance complaints?
We see no negative impact on the existing manufacturing activities, or once this operation is in, once this proposal is in operation, because again, it's just a manufacturing building and it's a manufacturing process. The facility is large enough to contain an entire operation within its enclosed walls, and we expect that there will be no issues there.
And will the proposed special use have any effect on the efforts to market other properties within the planned manufacturing district for industrial uses?
No, again, this is it's a very attractive building, and the manner that it is being redeveloped is nothing less than attractive to people who come in the area looking for properties and seeing this as one of the adjacent properties. I think they would look at it as a positive rather than a negative.
Excellent. And if you were to further testify, would your testimony be consistent with that of your report and the affidavit that have been prepared and submitted to the board?
It would.
At this time, I'd like to return back to Steve Hamilton. Did you prepare an affidavit that's been presented to the board?
I did.
And if you were to further testify, would your testimony be consistent with that?
It would.
Thank you. And Peggy Montez? We prepared an affidavit. You prepared an affidavit that's been presented to the board. If you were to continue to testify, would your testimony be consistent with that was presented in your affidavit? Did you hear the question?
Ms. Montez, can you hear?
Hello?
Hi.
Hello? Can you hear me now?
Yes, that's much better. So we prepared an affidavit that's been submitted to the board. And if you were to further testify with the information in your affidavit or testimony, be consistent with that of the affidavit that's been presented.
Yes.
Thank you. No further questions. We have questions from the board. We love to address them.
I have one just administrative matter, and then I have a couple questions for you. So there is a affidavit that we need from you with respect, I believe, to your state application that Mr. Risa is going to send to you. So I want you to acknowledge it, that I need that back from you before we start our deliberations today.
And it's emailed, Mr. Chairman. It's been sent.
Okay. So then I do have just a couple questions. Can you, if I understand correctly, this is a first time in this particular business for all of the partners, is that correct?
That's correct.
Can you talk through a little bit about how you know what it is that you're doing in this? Are you having some kind of a contractor or somebody else who's on consulting or whatnot that just talk us through a little bit about that.
Okay, so our background, again, if you notice, our background is business background. All of us have been in business. Mr. Hamilton's had a business that he's operated for how many years?
Since 1991 in the West Loop.
And I myself have been a contractor. I'm an attorney as well. So I have quite a bit of business experience. And Mrs. Montez has been involved in multiple organizations as well. However, the actual information, the growing part of this business, we have contracts with individuals that are in the industry that have had track records for more than 20 years, primarily from Colorado, where the industry has been in existence for almost 19 years now. Our number one, our head grower is from a company, actually it's Bickle and Associates, who's actually done multiple large-scale grows even here in Illinois and on the medical side. Our extraction consultant or partner, is not a partner, but he's a consultant, has been in the extraction area for almost 15 years and actually has developed very specific techniques and has worked on developing equipment for extraction. So our team, our actual team, is very well versed and has actually been in the industry for more than 15 years. It's just us as owners, and we will now shift into the roles of active owners in managing and operating this business going forward. Hopefully that addresses your question.
When we decided to, both families decided to go into this business, what we did as business owners was we wanted to decide who was doing the best work in the country. And because of the recreational aspect of the cannabis industry in Illinois is so new, there really aren't many people we can go to in Illinois that we could rely on. So we decided to go with a group outside of Denver who's been in this business for a long time and who can give us a lot of direction. And we've engaged them as our consultants. And they're really who are driving this in terms of how the layout is set up and how the grow rooms are done. And basically what happens is within this process, we'll have a new harvest every 3 weeks, and it helps us with providing product to the dispensaries on a regular basis.
So, right, and additionally, their expertise is also in the medical space. So our facility will be similar to a medical facility. If you notice on our plans, there are two different areas. For an employee to actually walk into an area that deals with production, you actually go through airlocks. So our goal is to be able to provide consistent quality product all the way through. So once we complete our first growth cycle, every 3 weeks we'll have an additional harvest that we'll be able to move forward with to bring to market, as there's such a large demand at this point in time. But our process and the reason why we've done this, especially because this is a business and we are looking at making sure that we have best practices in moving forward and making sure that our product is best product on market as well, and consistent and quality.
And can you talk a little bit about, in terms of your sales, that's to dispensaries?
So
Do you
our
have partners on that front?
Right, our sales are only to dispensaries. At this point in time, the dispensary licenses have not been issued by the state. However, there will be 75 initial licenses across the state. Hopefully, I believe there'll be approximately 40 within the greater Chicagoland area. All of those dispensaries are going to have to vie to be able to have product. Their product will either come from the smaller craft growers, that's the reason why they were created, or they'll come from the large growers that are actually doing medical as well as cannabis, because they're first to market, they currently control the market. And even right now, the smaller dispensaries are having a difficult time in actually being able to procure product to be able to sell to the public. So our niche will be able to supply product directly to those dispensaries once they come online.
And there are 40 craft grow licenses in the state of Illinois. So I think it's going to be very important that each grow facility that's brought on is able to maximize their grow. And with our plan, I think we're maximizing the amount of product we can bring to the market.
Got it. And are they picking up from you, or you are delivering to your?
As we mentioned earlier, there are transporters that do transportation, and those transporters are licensed by the state of Illinois. We do not transport product. We are not going into the transportation business, but only a licensed transporter can transport product to and from dispensaries, as well as infusers and processors and growers throughout the state. So that becomes state regulated, and we as growers will not be in that business.
Got it. Any questions from the board?
Yeah, I've got some questions. So I know you mentioned, Steve, that you guys have contracted with a Denver-based consultant. Are they consulting on issues of safety, both in regards to security, but also fires in your model?
Yeah, they are very well versed in the whole craft grow industry, and there hasn't been a detail left unturned. So, we have, in terms of, smell mitigation and safety, and, there are plenty of exits where we're following everything in terms of the city and state guidelines. So it's a highly regulated business. So we have to be on point on everything we do in terms of grow, in terms of security, in terms of safety, in terms of diversity for our employees and safety for our employees.
I think if I'm correct, there was submitted a plan that showed security cameras. And that plan, if you look at that plan closely, you'll see that it's fully surveilled. And that was developed with our consultants as well. And that's a plan that's similar to what's used in other plants across the country. And I think you also had a question in regard to, did you mention fire?
Yeah, no, I mentioned fire. So basically, it was the Department of Buildings and Fire in Chicago have suggested that, grow facilities have a higher risk of starting fires. So than, your regular building. So I just want to be clear that when it comes to these broad issues of safety, including fires, you guys are getting advice from people who have done this before.
Definitely. And just for an aside, if you look at what we have in the middle where we have our vegetation rooms and our flower rooms, those rooms are actually contained environments. So if you could think of the room as being it's almost like a walk-in cooler in its construction. So their walls, there'll be panels on those walls, there'll be and then within that, each one of those rooms is its own controlled environment. So precautions are being made for air exchange, things like that. That's already been taken into account as well as fire ratings for the walls themselves, because the coolers then become, I call them coolers because that's probably the best analogy, but they become self-contained boxes in which operations happen. So if that's helpful.
Yeah, that's helpful.
I'm sorry.
Any other questions from the board? Okay, thank you. We'll take it under consideration.
Thank you very much.
Thank you. Appreciate it.
We are going to jump back to 19520Z. This is 19520Z at 4630 North Malden. And Counselor, when you're ready, go ahead. You are on mute, though.
All right, unmuted. Introducing my two witnesses for this case are Mr. Steve Seguris on behalf of Meldon Development LLC, the applicant, and then Zisong Feng, our project architect.
And before we kick that off, were we able to resolve the objection?
We were, and I actually sent an email confirming that to Victor for the zoning board's file.
And Mr. Schaffner, we're on the same page? They resolved your objection? Mr.
Yes,
Schaffner?
I believe so.
Okay, so then Mr.
Break up a little bit here, so it's hard to hear.
No worries. Mr. Seguris, do you swear to tell the truth in this proceeding? I think we're actually missing Mr. Seguris.
Let me reach out. Hold on.
I also don't see Mr. Fang.
Mr. Feng is not here, and
Are you there?
Mr. Steve.
Mr. Seguris?
Yes,
do you,
can you hear me?
yeah, we can. Do you swear to tell the truth in this proceeding?
Yes, I do.
And so we're missing Mr. Fang?
That earlier, and I just sent an email. If it's okay, I could start with Mr. Seguris.
Yeah.
And just go through the overview.
Let's do it.
Okay. Chairman, again, I'm here on behalf of the applicant, Meldon Development LLC, the property owner at 4630 North Malden. It's a 50-foot by 154-foot wide lot that's currently vacant. It's located in Special District number 23, which is the Sheridan Park overlay. The issue is that the overlay imposes a 30-foot building setback for new construction buildings in that district. So what that does is it naturally pushes our building further back on the lot. And in turn, we're asking for a variation to reduce the rear yard open space requirement from the technical requirement of 520 square feet to 0. And what that does is it allows us to incorporate a drive aisle to 2 surface parking spaces that'll be located at the rear. So although the space won't be improved, it doesn't meet the technical definition of open space per the code, and therefore the requirement or the variation is being sought. We did have a chance to speak with one of our neighbors, and I believe there's no longer an objection based on this revised scope. And if I can proceed with questions to Mr. Seguros.
Please do.
Steve, can you again state your name and address for the record?
Yes, my name is Steve Seguros, address 221 Sawgrass Lane, Palos Heights.
And you are the you're the manager of the applicant Malden Development LLC?
That is correct.
And that entity owns the subject property again at 4630 North Malden, right?
Yes,
And you're proposing to develop the currently vacant lot with a new 3-story, 7-unit building?
yes, that's correct.
And you're seeking a variation to permit the project because of the additional front setback requirements imposed by the special district. Is that right?
That's correct, yes.
And it's your understanding that my office filed witness statements on your behalf in this case?
Yes,
And it's also, if you were to continue to testify, would that testimony be consistent with the statements we provided?
yes.
Is Mr. Fang back on, Chair?
I don't think we have him. But he's the.
Okay, I'm here, guys.
There you go.
Earlier, I was here all the time.
All along. Do you swear to tell the truth in this proceeding?
Yes, I do.
Okay.
Z, can you state your name and address for the record?
I'm Zisong Fang. I'm the architect for this job.
And you are a licensed architect in the state of Illinois?
Yes, correct.
And just for the record, can you state your office address, please?
Office is 651 West Washington, Suite 301, Chicago, Illinois, 60661.
Designed the program for the proposed 3-story, 7-unit building at the subject property, is that right?
That's correct.
And is it your position that the additional setback requirement in the special district is really the cause for the variation in this case, is that right?
That's correct.
And that's because the 30-foot setback is nearly double the technical requirement, and it pushes the building further back on the lot, is that right?
That's correct.
And so we're clear, the space that between the building and the garage will be used as a open drive aisle for 2 surface parking spaces, is that right?
That's correct.
And those 2 parking spaces are required parking for the total 7-unit building, is that right?
That's right.
And there are other examples of surface parking as serving as off-street parking for some of our neighboring residential buildings, is that right?
That's right too.
And Z, is it your understanding that my office filed a witness statement in this case?
I apologize. This is the court reporter. Mr. Fatikas, you cut out a second.
I'm sorry. Z, is it your understanding that my office filed a witness statement on your behalf in this case?
Yes.
And if you were to continue to testify, would that testimony be consistent with the statements we provided?
Correct. Yes.
Chairman, before I conclude, I'd like to point out that we did coordinate review during COVID with the Malden Magnolia Neighborhood Association. They've provided a letter, an email of non-objection. We also secured a letter of support from Alderman James Kappelman. We'd be happy to answer any questions the board might have about the project.
Can you clarify for me? Did you say you changed the scope of the project as a result of the conversation with the objector?
No. Initially, we had made an application. This is going back probably 6 months, maybe even longer, where there was an attached garage. It triggered additional zoning relief. We revised the plan, and the plan that's pending before the board today, the only requested relief is for the rear yard setback reduction. And I think that may have played into the confusion with our neighbor to the north as to why there was a concern. That's it. We revised our plan. We actually filed an amended application with the board, and we're only pursuing, again, the plan before you today and the relief as identified or memorialized in the agenda.
Got it. And Mr. Schaffner, will you just confirm for me that you've withdrawn your objection then?
That is correct. I have withdrawn it based on the understanding that the variance is restricted just to the rear lot and will not affect the front or the north side of the building.
Okay. Any questions from the board? Okay, thank you. We will take it under consideration.
Great. Thank you again.
Thank you.
Thank you. We are going to take a 20-minute break. So we are going to recess until 1:50. Commissioner Toya seconds Commissioner Saul.
Yes.
Commissioner Knudsen.
Aye.
Commissioner Toya.
Yes.
Chair votes aye. So we will be in recess until 1:50 p.m. and then we will return with 20820Z.
Mariah, were you sticking around for the vote?
I was.
Okay. Yeah, I don't know how longer it's going to be, but that's fine.
I've got,
That's fine.
I can just hang out in the background. You can demote me back to a viewer.
Yeah, you're still as an attendee. I just didn't know if you were sticking around for the vote or not.
Yeah, I am. I'm just keeping it out in the background.
Okay, sounds good.
Thanks.
Thank you. Mark, you had a question? Mark,
Tom
you had
Money,
your hand, raised. Mark, you have a question?
I do. Can you hear me?
Yeah.
Good. On our two cases on Grand Avenue, I did speak with the next door neighbor who had signed in against the case, explained the plan. She was concerned. She thought our garage had a rooftop deck. Fortunately, the garage in question does not. So she seems satisfied with that answer, and we sent her a copy of the plan. So I believe
Okay.
we've answered. I believe it's she's satisfied, and we're okay to recall that case. We'd like to go forward.
Okay. I'll let the chairman know.
And do we have a lot of cases left in the afternoon?
Yeah.
Okay. When
I'll let him know that she withdrew her objection.
She says she's satisfied that my explanation satisfied her concern. So
Okay. I'll let him know.
Coming back on. So we're restarting what time? When we coming back? 2 o'clock?
I think he said like 1:50.
1:50? Okay.
Yeah.
Sounds good. Thank you, Victor.
I'll let him know that you're ready though.
Thank you. Bye.
Okay. Bye. Hey, Mariah, this is just to give you another option. You know, this is being live streamed as well.
I can hop off and live stream.
No, if you want, it's completely up to you. I just didn't know if you knew it was being live streamed or not.
I hadn't taken the time to figure that out. So
You're more than welcome to stay here. I just wanted to give you an option.
All right. Thanks.
Okay.
All right.
Okay.
Thank you.
Okay.
Bye.
Kamal, we need a few extra minutes. The chairman had to reboot.
Okay, sounds good.
Katie, are you ready to go?
Yes, sir.
Perfect. I move that we reconvene this meeting of the Zoning Board of Appeals. Commissioner Toya seconds. Commissioner Saul?
Yes.
Commissioner Toya? Commissioner Toya unmutes. Commissioner Knudsen?
Yes.
Commissioner Toya?
Yes. Yes.
With I, we are reconvened. We are going to start with 20820Z at 1765 West Rose Hill. And then after that, we are going to just jump backwards to 203 and 204. So for now, 20820Z. Council, set up and ready. Why don't you identify your witnesses?
You're all in, Chairman.
Perfect. Council, you can unmute yourself whenever you're ready to go.
Yeah, am I,
We can hear you.
oh, thank you. Wait a minute, I guess I'm supposed to start my. I don't know. Anyway, I'm Tom Moore, and this is a request for a rear yard variance on a 13 unit building that went through a community process in the 40th Ward. It was a type 1 zoning change. The community had a lot of changes to the building, which were incorporated into the plan that you have before you. And the hardship is that it's a jagged shaped lot that on the west side is 94 feet deep. And then at another point, it's 157 feet deep. And at the longest point, it's 195 feet deep. The residential part of the building is 88 feet away from the furthest point back. But because zoning determines the rear yard from the nearest point, we need the variance. My witnesses are Armin Candia, who is the manager of the LLC that owns the property and that went through the process, and Chris Bremer, who is our architect. If there's no questions, I'll proceed with the witnesses.
Sure, let me just swear them in. Mr. Candia, do you swear to tell the truth in this proceeding?
Yes, I do.
And Mr. Bramer, you swear to tell the truth in this proceeding?
I do.
Okay, Counselor, go ahead.
So, Armand, you went through a long community process on this, is that right?
Yes, it is.
And you made significant changes based on the feedback you got and the comments you got. And when you're all done, the community supported your 13-unit building, is that right?
Yes, they did.
And your architect, who will speak in a minute, had to be very creative in order to accommodate the jagged, odd-shaped lot, is that right?
Yes.
Okay. And you and I worked out a affidavit whereby you went through each of the criteria necessary for this board to grant the rear yard variance requested. And if you were to continue to testify, you'd testify consistently with it. Is that right?
Yes.
Chris Bremer, are you there?
I am.
You're a licensed architect, is that right?
I am.
And you've testified in front of this board many times, is that right?
I have.
And will you just briefly tell the board what the challenges or what the practical difficulties were in designing this building at this location?
Absolutely. We're dealing with an irregular lot, as Tom earlier pointed out. The Department of Planning and Development measures their rear yard setbacks from the frontmost portion of any rear yard. In our case, that would result in a buildable area of only 60 feet deep on a lot that is nearly 200 feet deep, thus leaving much of the lot useless. So we are seeking to really get a variance to reduce that rear yard setback as they have defined it.
And you attended the community meeting and took notes, is that right?
Correct.
And then you made significant changes based on the comments and the suggestions that were made in the community, is that right?
We did. We initially had the front of our building, even at the 4th floor, all the way to the front property line on Rose Hill. After receiving comments from the neighborhood group, we recessed the entire 4th floor, set it back from both Rose Hill and from the west property line, as the immediate neighbor to the west was one of the few voices that raised a complaint about the previous design.
And you and I went through, we did an affidavit whereby you addressed all of the criteria necessary for this board to grant the variance requested, is that right?
Correct.
And other than the variance we're asking for, this, your plan otherwise complies with all codes and ordinances of the city, is that right?
Correct.
And if you were to continue to testify, you testify consistently with the affidavit that you signed, is that right?
Correct.
I think that's all we have, except for any questions the board might have.
Any questions from the board? Okay, we will take it under consideration. Thank you.
Thank you very
Thank
much.
you.
We're going to jump backwards now to 20320Z and 20420Z. This is for 1453 West Grand Avenue. And then I'll just note as well, after this one, we're going to jump ahead to 160 and then to 222. So right now we are at 203 and 204. Counselor, I understand you connected with the objector.
Yes, Mr. Chairman, I did. And for the record, my name is Mark Kupiec. I'm an attorney with offices 77 West Washington. I represent the applicant in this case. And Mr. Chairman, yes, thank you. In the interim, I did speak with the next door neighbor, Rebecca, and I would like to clarify my comments earlier because Rebecca did in fact respond to my email suggesting we talk on Friday, but also returned my phone call, and I was in a meeting and I couldn't take the call. So I think our failure to connect was just a short time period that we had this week.
And your understanding that you've resolved the objection?
I'll explain. We talked, and the short answer is we have two garages at the south end of the property, as shown on the plans. And this is an irregular parcel, and one of those two garages is to be located directly behind her property, and it's that garage that we're looking for the variation for to reduce the setback from 2 to 0. She did not have a question about the relief we're asking for. Her question is whether or not we intended to have a rooftop deck on that garage. And fortunately, we do not. The plan in front of you clearly shows no rooftop deck, no human occupancy. So there's no request there to build a rooftop deck on that garage on the eastern half of the property. And Mr. Hanna is on the call here. He will be happy to confirm that. And he also added this property is before you only after a zoning change, was a type 1 zoning change. So actually the plan attached to the zoning change also shows no rooftop deck on the smaller garage on the eastern portion of the property. And she says with that explanation, she was okay. Her concern was whether there'd be a rooftop deck and that might have some adverse effect. Not the relief we're asking for, but just as a practical matter.
Okay. And it looks like, let me just ask if Ms. Fitz is still here and would like to add anything or confirm. Looks like she is not here any longer. Okay, then Counselor, why don't you proceed then? Will you identify your witnesses and I'll swear everybody in?
Sure, absolutely. Mr. Chairman, with me today, Mark Kupiec, attorney for the applicant. I also have my associate Agnes Pleka on the call, and the witnesses on behalf of the applicant, Jimmy Banis, project architect John Hanna of Hanna Architects, and I do also have Joe Ryan as an expert witness in this case.
Mr. Banis, do you swear to tell the truth in this proceeding?
Uh-oh.
Actually, don't see Mr. Banis on our list right now.
I'll have to trim the bushes because it's so wet. Next week it's supposed to rain the whole time.
Well, Mr. Chairman, I guess, can we?
I think he may have just joined. Is this Mr. Banis under Felix Bahina? You have to unmute yourself.
Oh, no, I'm Felix Bahina. I'm for 5200 South Mobile, not with this one.
Got it. Okay. So we are missing Mr. Banis, it looks like.
Yeah. Mr. Chairman, can we pass this momentarily until we locate him and get him back on?
Sure.
I think he might have been confused by the recess, et cetera.
Okay, so Mr. Hannah, you swear to tell the truth in this proceeding? You're on mute, sir.
I do.
And Mr. Ryan, you swear to tell the truth on this proceeding?
I do.
And we continue to recognize your expertise. Counselor, why don't you proceed while we attempt to get Mr. Banis on the line?
All right, sounds good. And Mr. Chairman, number one, a procedural matter. While we've been waiting for this, after waiting for the hearing to come about, our architect continued looking at the plan, and he did make one small change on the plan, and it was regarding the stairs accessing the rooftop deck on the garage on the western portion of the property to make that stairway in compliance. So we filed that revised plan with your staff. We would ask to be able to proceed on the revised plan. And if we could proceed on the revised plan, then we would drop our request for a variation on the rear setback because it's not necessary.
Okay, yeah, let's do that. Please proceed.
All right, good. And then we have two cases. Then the first case is the case for the setback variation. And again, it's a setback on the east side setback from 2 feet to 0. And that setback applies to the garage only. The principal building itself meets all the setback requirements. The second case is a setback on the minimum lot area. Our minimum lot area, we have 94% of the minimum lot area needed for 5 dwelling units. So we're asking for a variation for that remaining 6%.
And Counselor, just to make sure I'm following you clearly, you're withdrawing 20320 under the amended plan?
Well, no, we're amending it. We still need the variation for this 2-foot side setback. So there's actually 2 variations in that case. We're withdrawing the request for relief on the rear setback because the revised plan complies with the rear setback.
Got it.
And as long as we're on the subject, I've got Mr. Hannah on the call. John, would you identify yourself for the record?
John Hannah, president of Hannah Architects Inc., 180 West Washington, Chicago, Illinois.
And John, was my explanation correct as far as the revised plan?
It was.
Okay, good. So we'd like to proceed on the revised plan then.
Great.
Okay. And then, as I said, that first case, we're still proceeding on the first case, the variation only for a side setback. And the request is from the 2-foot required to 0. The second one is the MLA as I described it. And this property's on the south side of Grand Avenue. You've got Otis School to the north across the street, and you've got PMD number 4 to the south of the subject property. Property is about 700 feet from Ashland, so it is a transit served location. Although we are not asking for any parking reduction, I mention it solely for the fact that it's within the city's plan to put more density near these transit served locations. We've got some unique features here that I'll just briefly highlight. This particular parcel fronts on 2 streets, fronts on Grand Avenue on the north and Ferdinand on the south, which is a little different. This is a business zoning district. If it was a residential district, they would describe it as a through lot. In addition, the parcel is irregular. It's L-shaped. The frontage on Grand Avenue is 25 feet. Frontage on Ferdinand is 43 feet. And that explains a little bit why we have a little different arrangement on the garages because of the irregular shape of the property. In addition, this block on Grand has a variety of zoning districts. The older buildings still zone M, manufacturing. Some of the newer buildings zone residential because these are all residential buildings. And the more recent constructed buildings under the new code generally zone B2 like ours, B2-2. So over some different interpretations with respect to some of these setbacks depending on what zoning district you are in. Ordinarily in the B2, there is no side setback requirement. However, the exception is if you abut a residential zoning district. And because we have the irregular lot, we actually abut 2 separate neighbors on the east side. We abut Rebecca at 1451, who was on the call earlier. Her property fronts on Grand Avenue, but because of our irregular L-shaped lot, we also abut a second property with an address of 1445 Grand Avenue. And this is an 8-unit condominium, residential condominium building. But the zoning of that property happens to be R5, a little bit older project. And because we abut the R district, the side setback requirement kicks in. So that's how we come before you for the side setback relief. With that, let's call Jen. And of course, the other point was the minimum lot area reduction. You know, this is because it's transit served location, a good area for the extra unit. And actually, because of this L-shaped portion, we have a little bit bigger lot than some of the other lots on the block. So for a first witness, we call John Hanna. John, would you state your name and your address?
John Hanna, President of Hanna Architects Inc., 180 West Washington, Chicago, Illinois. Licensed architect in the state of Illinois.
John, is it correct this property fronts both on Grand Avenue on the north and Ferdinand on the south?
That is correct.
And that's not a common arrangement in this zoning district? Not
correct.
Also irregular L-shaped parcel?
You're breaking up a little, Mark. Sorry, I can't hear you.
I'm sorry. Can you hear me now?
Yes.
Okay, good. John, also true this is a irregular L-shaped parcel?
It is.
Frontage 25 feet on Grand Avenue?
Correct.
And 43 feet on Ferdinand?
Correct.
Also true, as I represented, we've got some different zoning districts on Grand Avenue.
We do.
And our property is a B2-2.
Correct.
Which ordinarily has no side setback requirement.
Correct.
But true that the southern part of our property does abut the property of 1455 West Grand.
That's correct, yes.
That property is zoned R5, and that triggers our side setback requirement.
Correct.
And this arrangement to have two abutting property owners on the east side, also not a common situation.
It's very unusual.
Good. And to be clear, the principal building with the residential units complies with all the setback requirements.
That's correct.
All right. So the 2-foot side setback relief we're asking for applies only to this garage on the eastern portion of the property.
That is correct.
And John, is it correct as I described that this is a 1-story garage?
Yes.
And it has a garage rooftop deck?
Correct.
And that's clearly shown on your plans?
Clearly.
Good. And with respect to that garage and that relief, is it true that this adjacent property at 1445, the 8-unit residential building, has some of its parking at a lower level below grade?
It does.
And that this building at 1445 has a ramp coming from the alley down to the parking at the lower level?
That's correct.
And their ramp to their parking is along their western side lot line?
Correct.
And that is the lot line that we share with them?
That is correct also.
So because of this ramp there adjacent to us, John, is it true that no purpose would be served by us setting our garage back 2 feet on that lot line?
Correct. Absolutely.
And also true conversely, that if the board grants this relief and reduces that side setback to 0, it would actually cause no harm to that adjoining property owner?
None at all.
Because they've got the ramp adjacent to this proposed garage?
Correct.
Okay. John, were you part of the community process on this one?
I was.
It involved a zoning change?
Correct.
And the alderman asked you to meet with the Eckerd Park the council on this?
That's correct.
And you met with them perhaps 3 different times to discuss this plan?
We did.
And fair to say Eckerd Park was concerned about having garages to house the parking, and your plan does have garages?
That's correct.
Ecker Park is concerned about a trash container on site, and your plan has the trash container on site.
It was mandatory by them.
Good. And John, also true that they were concerned about garbage cans in the alley, garbage pickup, and garbage can related issues.
They were very concerned.
And they required that you show adequate access to that garage, strike that garbage container, and adequate access for the garbage container to Ferdinand Street where the garbage would be picked up.
Correct.
And to address their concerns, you designed this two garage arrangement.
That's correct.
And this garage arrangement does have adequate access to that trash container.
It does.
Okay. And with this particular plan, Eckerd Park supported this plan for the zoning change.
They did.
And they were aware that we would have to also come to the zoning board for the zoning board relief that we are requesting.
That is correct.
And the property was rezoned at the Alderman's request as a type 1 application.
Yes,
And this is the plan that was attached to the zoning change.
it was.
Okay. John, in addition to that, we had filed, you had signed an affidavit in connection with your testimony here today.
I did.
And if I were to continue to quiz you, would your testimony be consistent with what was contained in that affidavit?
It would.
Mr. Chairman, I think that's all I have, Mr. Hanna, unless you had further questions.
I don't, and I think we may have, Mr. Banis may have joined.
All right, that'd be excellent.
So
Jim,
you'll
Jim-
unmute yourself. If you'll unmute yourself, I just want to swear you in.
Mr. Chairman, this is Agnes Pleka, attorney with Law Office of Mark Kupiec. I've been on the phone with the applicant, and he says that somehow he cannot unmute himself. I'm not sure if he's promoted to a panelist.
He is now, so if you're still on the line with him, maybe if you can have him try.
Yes, let me check.
And while they're doing that, are there any questions so far from the board? Great.
Mr. Chairman, can you hear him now?
No.
Somehow he cannot unmute himself for whatever reason. It's
I hear
he
a
can
voice.
hear everybody, but is not able to speak.
I hear a voice, Agnes, but it's very, very low. Is he speaking directly into his microphone?
I think that might be from the, is he still on the phone with you?
I think he might be, yes.
Why don't you just,
Can you put-
why don't we try
Yeah,
it?
I'll disconnect with him.
Why don't we try just putting the phone up near our, up
Can
near
you put your phone on speaker, Ag?
Victor, can you check the attendees list? If he's there, just listed under a different case number.
Put that on. Let's try if this works.
I don't have him listed. The only other Jim I have is Jim Banks listed.
He signed in at jbox1771@gmail.com. That's his email.
Did he name himself?
He said Jimmy Banis.
I don't think we have him. Agnes, can you just put the phone up If he's on the line with you on the phone, will you just put that up to your microphone and we'll see if that works?
Yeah, let me get him back on the line.
You may have joined a wrong Zoom meeting.
Jamie?
Yes.
Can you hear him now, Mr. Chairman?
Yes. Yes, I can hear you.
Jimmy, do you swear to tell the truth in this proceeding?
Yes, I will.
Okay, let's try it this way then. Counselor, go ahead.
Mr. Chairman, in an effort to simplify things, we did, as I will ask Jimmy in a minute, we did file, he signed an affidavit, we filed the affidavit. And just for ease of presentation, I would mention, in addition to other items, Jimmy in the affidavit discloses himself as the manager member of the LLC. He attaches a profit and loss statement stating that with the 4 units that are permitted as of right, he would only have about a 5% return on his investment. If the relief is granted and he's allowed 5 units, the rate of return would be 16%, which would be adequate for his bank. The 4 units with 5% would not be sufficient for his bank. So he needs a variation for a reasonable return on his investment with the affidavit filed. He also went on to say he proposes this to be a condo project. In the current climate, the buyers are looking for a garage with a condo unit. So of course he needs the garages as designed. And he further stated in the affidavit that this is an irregular parcel and he bought the property in the same shape and size. And he has not done anything to alter or change the shape of the parcel. This is how he bought it. So all that with more is in the affidavit. So Jimmy, can you hear me now?
Yes, I can hear you.
Good. And Jimmy, did everything I just say, did that sound correct to you? Sound right?
Yes.
Good. Jimmy, and is it true you did sign an affidavit for this case, correct?
Yes, I did.
And we filed that affidavit with the board on your behalf. And if I were to ask you each individual question, would you answer today the same as was stated in your affidavit?
Yes.
Good. Mr. Chairman, since we don't have the objector, I'd be happy to stand on that affidavit. And if the board had specific questions, we could pose them.
Any questions from the board? Okay, thank you. We'll take it under consideration.
Mr. Chairman, I also, because we had the potential for the objector, I also brought Joe Ryan as an expert witness.
Yep.
And I'd just like to get his, Joe, state your name and address.
Joseph M. Ryan, MAI, President, LaSalle Appraisal Group, with offices at 9455 South Horn Avenue in Chicago.
You prepared a report for this case?
I did.
We've submitted that report, Mr. Chairman. Joe, is it true you're familiar with the subject property and surrounding neighborhood?
I am.
And you're aware of the proposed use?
Yes.
Joe, fair to say that the variations, if granted, will not alter the essential character of the neighborhood?
No, not at all.
Joe, also fair to say that the variations, if granted, will not substantially diminish or impair property values within the neighborhood?
Now, none whatsoever, no.
And Joe, does your report have the information and the facts to support those conclusions?
It does.
Mr. Chairman, with that, we'd rest on his report unless you have questions.
No, we will take it under consideration.
Thank you. Thank you.
We're going to jump ahead to 16020S. And then from there to 22220S. Good afternoon. Can you identify yourself for us?
Hi, my name is Tyben Hernandez of 4360 North Milwaukee Avenue.
Do you swear to tell the truth in this proceeding?
I do.
Great. I believe last time we had a couple objectors who had signed up on this matter. Did you wind up discussing that with them? I don't see anybody else signed up.
Yes. So it was only one. She brought in her attorney, but I was hoping that I would be able to speak with her prior to the last meeting, but with COVID, her salon was closed. We settled already, so she withdraw her objection. So there's no more objection.
Got it. Okay. And then just for the record, is there a Cindy Bitbabo or an Arthur Sipta on this line? I believe actually no one signed up for this round, although we gave them notice. So hearing none. Okay. Then why don't you go ahead and tell us a little about what you're trying to do?
So I am trying to open up a beauty school. It's called One Stop Beauty School. I currently own One Stop Salon in Humboldt Park. So I am applying for special use today due to my denial in the zoning department with the building permit. I received my business license for the location as One Stop Beauty School. But when I went to apply for the building permit, because it provides personal services and there is a salon next door, they required that I go through special use to for them to grant the building permit. So that's why I'm here.
And can you talk a little about the hours of operation you're anticipating for the business?
I'm anticipating to have it open and available for students 7 days a week, 9 a.m. to 6 p.m.
Got it. And will you confirm for me just on your application, are you the owner of the property?
I am part owner. My family owns the property. I own the business.
Got it.
So I'm part owner of the property, yes.
Got it. Okay. Okay. And any questions from the board? Ms. Velasquez, I think, are you reading this one?
I do have a question.
Go ahead, Commissioner.
Chairman. Ms. Hernandez, I'm just looking at this. You have partners with you, right, in the business?
I am sole owner.
Okay, I noticed all these other people under owner.
Okay,
Like,
so they own the property.
William
so the
Dew?
deed, yes, the deed.
Richard Dew?
They are the their names are on the deed of the property, but One Stop Beauty Salon Inc. I'm sorry, can you hear me?
Yeah, I can hear you. Can you hear me?
Yeah, it was echoing. So Dong Nugent is my father. William
Don't you say it
Dew-
Nguyen? Don't you say it Nguyen?
Yeah, I say Nguyen.
Okay, I just was wondering. That's how you usually say it, isn't it? Am I right?
Yeah, Nguyen.
Go on.
So Dong is my father, William Doe is my uncle, and Richard Doe is William's son, and he's my cousin. So our family owns the property. We purchased it 3 years ago. One Stop Beauty Salon Inc. is my business, and I'm going in as a leaser of the property.
I got it. I just got a little confused with all the list of the owners. I got it now. I got it.
Yeah.
I got it. Thank you.
No problem.
Okay, Ms. Velasquez on the department's recommendation.
Yes, good afternoon. My name is Jeanette Velasquez. I will be reading the department's recommendation. The Department of Planning and Development recommends approval of the proposed nail and aesthetic school. The department finds that this proposal complies with all the applicable standards of the zoning ordinance, is in the interest of the public convenience, and will not have a significant adverse impact on the general welfare of the neighborhood. The department also finds the nail and aesthetic school will be compatible with the character of the surrounding area in terms of operating characteristics. And lastly, the proposed nail and aesthetic school is designed to promote pedestrian safety and comfort.
Okay, any other questions from the board? Thank you. We will take it under consideration.
Great, thank you so much.
Okay, we're going to jump right now to 22220S. 222, this is at 3358 West Bryn Mawr. And I'm going to read the department's recommendation. The Department of Planning and Development recommends approval of the proposed barber shop. Short and sweet.
Unmute my mic.
Is it Mr. Sugro?
Yes, here we are. Yes, I'm here in the remote office of law offices John Shagru with the owner, Manal Jaju.
Perfect. Mr. Jaju, do you swear to tell the truth in this proceeding?
Yes.
Perfect.
Joe Ryan should also be on there somewhere.
Yeah, we see him. Mr. Ryan, you are still under
I'm
oath,
here.
and we continue to recognize your expertise. Counselor, on this one, it looks like we're moving a barber shop from the same business, same building.
From the same business in the same building. Right now he has a Kimball address, but he's going to have a Bryn Mawr address, but it is the same building. And
hours are 10 a.m. to 9 p.m. Monday through Friday, and 10 to 5 on Saturday.
That's correct. Yes. That is correct.
And can we just get your witness on the record that he would testify consistent with his affidavit?
So Manal, would you affirm that any testimony you give today would be consistent with your affidavit submitted to the board? Yes. Yes. And I would pose the same question to Mr. Ryan. Would you affirm that any testimony you give today would be consistent with the report that you had submitted to the board?
Yes, it would be.
Great. Are there any questions from the board? Okay, thank you. We'll take it under consideration.
Thank you very much.
Thank you. We are going to go back to regular order. I believe we're at 209 and 210. So this is for 5200 South Mobile Avenue and 5204. 209 and 210.
Good afternoon, John Pekarsky for the petitioner.
Good afternoon. Can you identify your witnesses? Let me swear them in, and then I'll let you proceed.
Yes, sir. The petitioner is Felix Bahana, and our architect is Brian Griffin.
And Mr. Bahena, can you can hear me? It looks like. Do you swear to tell the truth in this proceeding?
Yes.
Okay, Mr. Griffin, you swear to tell the truth in this proceeding?
Yes.
Okay, go ahead, Counselor. Counselor, you still with us?
Yes, for some reason I was, it was muted. The property in question is at the southeast corner of 52nd and Mobile. The property has a 69 frontage feet on Mobile by a depth of approximately 125 feet. The corner lot, which is 5200, is improved with what was a substandard single-family dwelling. The property at 5204 is going to be improved with Felix's own single-family home. The property at 5200 is improved and has not been changed whatsoever, except being improved with a building permit. For that lot, which is 5200, we are seeking a front yard variation from the required 20 feet to 4.62 feet. Again, it's an existing building. And a north yard variation from the required 2.28 feet to 0.04 feet. Again, it's an existing condition. This unit has been there for time immemorial. As to 5204, the lot will be 41 feet by 125, and excuse me, it will be the site of Mr. Bahana's home. Mr. Bahana is a teacher at Eli Whitney School in Little Village and seeks to improve the now vacant lot with a single family dwelling. The only variation that we will need there is for combined side yards of 7 feet instead of the required 8.2 feet. As the board knows, 7 feet of combined side yards is clearly unusual in size. And unfortunately, because it was subdivided into a 41-foot lot, we needed 8.2 feet. I would call as my first witness Felix Bahana. Felix, please state your name, address, and occupation.
You're on mute.
Apologize. Felix Bahina, 5200 South Mobile Avenue, Chicago. I'm a CPS teacher at Eli Whitney Elementary in Little Village.
And you purchased the property located at the southeast corner of 52nd and Mobile, is that correct?
Yes.
And the building that was at the southeast corner, called 5200, was improved with a substandard single-family dwelling, is that correct?
Yes.
And you improved that building, making it now habitable in first-class condition, is that correct?
Yes.
And you live in that building, is that correct?
Yes.
But you are seeking to build your own single-family home at 5204, is that correct?
Yes.
And in order to obtain a building permit for 5204, we are going to need a variation for the combined side yards, is that correct?
Yes.
And this is not for profit, it's built for your own living space, is that correct?
Yeah, that's correct. I don't have a family yet, so I've been wanting to build my house so I could start.
And at your request and at the board's recommendation, we have filed an affidavit, is that correct?
Yes.
And if I asked you the same questions that appeared in the affidavit, would your answers be the same or substantially similar?
Yes.
I have no further questions of Mr. Bahena.
Let's keep going.
Okay. The next witness would be our architect, Brian Griffin. Brian, please state your name, address, and occupation.
Brian Griffin, architect with IJM Group, 608 Hillgrove Avenue, Western Springs. I was the one working on this project manager on this project with Felix.
And as such, sir, I have prepared at your request an affidavit. Is that correct?
That is correct.
And that affidavit states all of the criteria necessary to obtain the variations that we're seeking for both 5200 and 5204. Is that correct?
Yes.
And if I asked you the same questions that appear in the affidavit, would your answers be the same or substantially similar?
They'd be the same.
I have no further questions.
Any
Mr.
questions
Chairman?
from the board?
I have a question for the owner. Are you planning to retain ownership of both properties?
No, I'm still don't know what I'm gonna do with the corner property. If it's if I keep it for myself and rent it, or I might sell it. I'm not sure what I'm gonna do with it yet.
Okay, thank you.
Any other questions from the board? Okay, thank you. We'll take it under consideration.
Thank you.
Thank you.
We're gonna move ahead to 21120Z next. This is at 4200 North Kildare.
Again, John Pekarsky. I'm the attorney for Leonard DiCristofano. I have with me Mr. DiCristofano and our architect, Peter Sterniak. The property is located at the northeast corner of Kildare and Berthoud. This is truly an unusual site. It is at the end of a dead-end street, which dead ends, and our rear yard is the John F. Kennedy Expressway. The site was the former home of a 6-unit crack house, which was removed by the city. My client has purchased the property in question and wishes to build a 2-dwelling unit building on the site. It is also unusual because of the fact that it is only 101 feet in depth. I would call as my first witness, Mr. Leonard DiCristofano. Len, are you there?
Yes, I'm here, John.
Before we proceed, let me just swear Mr. Cristofano in. Do you swear to tell, DiCristofano, do you swear to tell the truth in this proceeding?
Yes.
Go ahead, Counselor.
Now, Len, when you purchased this property, it was the scene of a 6-flat crack house, wasn't it?
Correct.
And it was taken down, condemned and taken down by the city, is that correct?
Yes.
And you'd like to improve the neighborhood and improve your lot with a 2-dwelling unit building, is that correct?
Yes.
And the building is that you've planned is consistent in architecture with the neighborhood?
Yes, it is.
You've indicated to me that the cost of construction is about $400,000. Is that correct?
Yes.
Maybe a little bit more than that. And that that the purchase price of the land is about $200,000.
Plus other costs, yes.
Yeah. Now, if you were able to sell these properties, what do you think they would sell for?
Hoping for $350 each.
Okay. And that would garner for you a reasonable rate of return?
Yes.
Fine. I have no further questions of Leonard. I would call as my next witness, Mr. Peter Sterniak. Peter, are you there?
Yes, I'm here.
Okay. Now, Pete.
Counselor, before you continue, Mr. Sterniak, do you swear to tell the truth in this proceeding?
Yeah, one sec. I think the video. Yeah, I'm here. I hear you.
Do you swear to tell the truth in this proceeding?
Yes, I do. Peter Sterniak.
Go ahead, Counselor.
Okay, Peter, you're an architect.
Yes, I do.
Licensed to practice architecture in the state of Illinois?
Yes, I am.
And you've designed the proposed 2-unit building, is that correct?
That's correct.
And I have, on your behalf, prepared an affidavit listing all of the criteria necessary for the front yard variation that we are seeking.
Correct.
And that front yard we are seeking is dictated by the fact that this is a very short lot. And in calculating the required front yard, the property to the east has a huge front yard. Is that correct?
That's correct. Actually, it's the property to the north.
Or to the
two more
north.
properties that are set back further, being on a deeper lot than us, and it causes our calculated setback to be huge.
So if at the request of Leonard D. Cristofano, I have prepared an affidavit on your behalf. Is that correct?
That's correct.
And that affidavit lists the criteria necessary for you to for Leonard to obtain a variation for the front yard. Is that correct?
That's correct.
And if I ask you the same questions that appear in that affidavit, would your answers be the same or substantially the same?
That's correct.
Okay. I have no further questions of Mr. Sterniak.
Thank you.
Any questions from the board?
So when you showed the depiction of the neighborhood, it looked like the neighboring homes, at least to the north, is what we could see, had setbacks that were 30 feet or more. So I'm wondering, in this neighborhood, are these bigger setbacks normal? And my reasoning for the question is, if we grant your variance, it might affect the character of the neighborhood.
Well, the Kennedy Expressway is at an angle at the north of these lots, so that some of the lots are gargantuan as the expressway works its way through them. It's only our lot that is 101 feet long or in depth. So that's the reason for the front yard variation.
Okay, I see. Yeah, the photo that's up shows it pretty well. Okay, thank you.
I have no further questions.
Any other questions from the board? Okay, thank you. We will take it under consideration.
Thank you.
We're going to move on to 212, 20Z, 213, 20Z, and 214, 20Z. This is all for 2902 West Pershing.
Okay. Again, my name is John Pekarsky. I represent Yo Lin. That's YAOLIN, who is the owner of the property in question. And our architect is CM Land, LAN. The property in question has been rezoned for the purposes of allowing us to subdivide the lot in question, which was a 70-foot lot. The property at 2902, which is the subject of our variation, is improved and has been improved with a 2-dwelling unit building. That building has been improved and brought up to current day standards by our client so that it is a 2-dwelling unit building compatible with surrounding properties as far as quality, etc. However, as you can see, that building is located at the rear of the lot. So we are, and it's been there for, again, time immemorial. We are seeking a west side yard of 0.66 feet instead of the required 2 feet. Again, it's an existing building. We are providing no open rear yard open space instead of the required 214 feet. We are providing no rear yard setback instead of the required 37.62 feet. And we are seeking a reduction of 1 parking space. As you can see, it's impossible to provide rear yard open space or a rear yard at all. However, as you can also see by the drawings, there is a 70-foot front yard, actually 70 foot 4 inches. The property in question was purchased by my client with the purposes of improving the 2 dwelling unit building and then building a single family home at the 2900 West Pershing. The proposed use of 2902 is totally compatible with surrounding uses. It's been there well in excess of 4 decades. And the new building, of course, will add needed vitality to the local neighborhood. With that, I would call my client and architect, who I believe are together. Mr. Lin and Mr. Lan, are you there?
Yes, we're here.
Gentlemen?
Counselor, let me interrupt you for a moment. Mr. Lin, do you swear to tell the truth in these proceedings?
Yes. Yes.
Mr. Lan, you swear to tell the truth in this proceeding?
Yes, I do. Yes.
Okay, go ahead, Counselor.
Okay. Now, Mr. Lin, you have purchased the property in question?
Yes.
Okay. And you purchased it for about $155,000, is that correct?
Yes. Yes.
And you've put about $120,000 into the rehab of the property at 2902 West Pershing, is that correct?
Yes. Yes.
And you hope to lease the 2 units at between $1,000 and $1,100 per month, is that correct?
Yeah, correct.
And this will garner for you, in your estimation, a reasonable rate of return, is that correct?
Yes. Yes.
And you would, if the variations that are sought are granted, you will then be able to build a single family home at 2900 Pershing, correct?
Yes.
And that home will have no variations sought, is that correct?
Yeah, correct.
Okay, I have no further questions of Mr. Lin. I would call our architect, Mr. Lan.
Please do.
Okay, please state your name, sir.
Oh yeah, my name is Chairman C.M. Lan. Actually, I'm not a licensed architect. I'm the associate of the project architect, Edward M. Young. I just want to make clear of that. And also, I'm an expediter. Yeah.
Yes. Okay. And I have prepared an affidavit on behalf of the architect. Is that correct?
That's correct.
And if I asked you the same questions that appear in that affidavit, would your answers be the same or substantially similar?
Yes, of course.
I have no further questions. And with that, I would rest.
Can you clarify for me a couple issues? One, so at the end of the day, you're going to have 3 parking spots. But one of the parking spots for the 2-unit building is going to be on the now separated property. Is that correct?
Well, the deed will run and be, that parking space will be deeded to the property at 2902. And the 2 westernmost parking spaces will be deeded to 2900.
Okay, so that the property with 2 dwelling units will have its own owned 2 parking spots. It's not like
Yes, sir. Yes, sir.
Okay, and then can you just talk through, since you went through a zoning process for this property, will you speak to why you haven't created your own hardship? Why you didn't essentially zone it in a way to make the variations unneeded?
Well, it was impossible to create a zoning district that would, I'm using the term legalize, end quote, a back of the yards home. There's no district that would allow a building, the 2 flat at 2902 to have a 0 rear yard and to provide no open space. As you can see, there's a 70+ foot front yard, but the building at 2902 is an existing condition.
Got it. Any other questions from the board? Okay, thank you. We'll take it under consideration.
Thank you very much. Have a good evening.
You too. We're going to go ahead to 21520S for 3800 to 3830 West 42nd Street and 3809 to 13 West 41st Street. And while we're getting everybody set up, I will read the department's letter. For 21520S, the Department of Planning and Development recommends approval of the proposed non-accessory parking lot with 205 parking spaces that will serve as non-required off-site accessory parking for the existing building at 4127 to 41 South Pulaski Road, provided the special use is issued solely to the applicant, Focal Point LLC, and the development is consistent with the design and layout of the landscape plan and planting details dated June 24th, 2020, prepared by Site Design Group Limited and Weaver Consultants Group. Counselor, when you're ready, if you would identify your witnesses, I'll swear them in and we'll go from there.
Thank you, Mr. Chair. My name is Mike Noonan. I'm with the law firm of Foley & Lardner, located at 321 North Clark Street in Chicago. And I, along with my colleague Donna Pugh, represent the applicant, Focal Point LLC, who's seeking a special use to allow an off-site, non-required accessory parking lot with 205 parking spaces in an M33 district located at 3800 West 42nd Street. With me today is Andrew Offenbacher, Vice President of Engineering and Operations for Focal Point LLC. John Talbot, Project Director, Civil Engineering and Manager at Weaver Consultants Group. And George Kissel, AICP, Certified Planner and Principal at Okrent Kissel Associates, who has appeared before you many times.
Mr. Offenbacher, do you swear to tell the truth in this proceeding?
I do.
Mr. Talbot, do you swear to tell the truth in this proceeding? You're on mute. If you could unmute yourself.
I do.
And Mr. Kissel, you swear to tell the truth in this proceeding? Mr. Kissel, do you swear to tell the truth in this proceeding? We cannot hear you, Mr. Kissel.
Mr. Kissel, your computer you have unmuted, but maybe this hard mic has an on-off button.
Let's see. How's that?
That's better. Do you swear to tell the truth in this proceeding?
I do.
And we recognize your expertise. Counselor, let's do the quick version on this one. Let's just get it on the record.
Absolutely. I'll be brief. The applicant is seeking a special use for the subject property, which is currently improved with a paved parking lot. In terms of community and neighbor outreach, Focal Point has letters of support from their neighbor to the south, Pete's Fresh Market, as well as Back of the Yards Neighborhood Council, who are both in support of this project, as it allows Focal Point to continue to create jobs that will benefit the community. Members of our team have also had conversations with Paul Perkel, president of Mid-America Paper Recycling Company, Focal Point's neighbor to the north, who has no objection to the project. And we additionally have a letter of information from Alderman Ed Burke, who has no objection to the project and has worked with this large local employer for many years. I will call, copies of these three letters should have been provided to you with our findings of fact.
We have them.
I will now call our witnesses. First, I would like to call Andrew Offenbacher with the applicant.
I'm here. Can you hear me?
All right. Mr. Offenbacher, please state your name, title, and business address.
Andrew Offenbacher, Vice President of Engineering and Operations for Focal Point LLC. We are at 3800 West 42nd Street in Chicago.
Is it correct that the applicant, Focal Point LLC, is the property owner for the subject property?
Yes.
Is it also correct that as Vice President of Engineering and Operations for Focal Point LLC, you have specific knowledge of the subject property?
Yes.
Is it correct that you provided a signed witness affidavit in connection with this matter?
Yes, I did.
Mr. Chair, I've provided this affidavit to the board along with the applicant's proposed findings of fact. Mr. Offenbacher, if you were to continue to testify today, would your testimony be consistent with the statements in your affidavit?
Yes, it would.
And has Focal Point reached out to neighbors in the community regarding this project?
Yes, we have. Members of our team spoke with adjacent neighbors, also the Back of the Yards Neighborhood Association and the Alderman's office. All of them provided letters of support or otherwise did not object to the project, and we've received no negative responses.
Thank you, Mr. Offenbacher. I'd like to call my second witness, John Talbot. Mr. Talbot, please state your name, title, and business address.
Yes, my name is John Talbot. I'm Project Director and Civil Engineering Manager at Weaver Consultants Group at 35 East Wacker Drive, Chicago, Illinois.
Thank you, Mr. Talbot. Is it correct that Weaver Consultants Group has been retained by the applicant to provide engineering services related to the subject parking lot?
That is correct.
Is it also correct that as project director on this project and civil engineering manager, you have specific knowledge of the subject property?
That is true.
Is it correct that you provided a signed witness affidavit in connection with this matter?
Yes, I have.
Mr. Chair, I've provided this affidavit to the board along with applicant's proposed findings of fact. Mr. Talbot, if you were to continue to testify today, would your testimony be consistent with those proposed in your findings of your proposed statements in the findings of fact in your affidavit?
Yes, it would be.
Thank you, Mr. Talbot. And I would like to call my final witness, George Kissel. Mr. Kissel, please state your name, address, and title.
Certainly. My name is George Kissel, president of Grant Kissel Associates, offices at 122 South Michigan in Chicago. I'm a licensed architect and certified planner, more than 35 years of experience.
Mr. Kissel, is it correct that you've appeared before the Zoning Board of Appeals in the past?
I have.
Thank you. Mr. Kissel, is it correct that you were retained by the applicant to conduct an urban planning analysis of the proposed special use to establish off-site non-required accessory parking lot in an M33 heavy industry district at the subject property?
That is correct.
Is it also correct that you prepared a report detailing your findings and conclusions and analysis? And is that report contained in the materials submitted to the board, admitted into evidence?
I have, and it is.
Thank you. Mr. Kissel, is it correct that if you were called to testify further, your testimony would be consistent with the findings and conclusions contained in your report, specifically that the proposed development is consistent with the general criteria for approval of special uses and will have minimal impact on the surrounding area?
Yes, it would.
Thank you, Mr. Kissel. At this time, we welcome any questions that the board might have regarding this matter.
Any questions from the board? Okay, thank you. We'll take it under consideration.
Thank you. Thank you very much.
Moving on now to 21620S and 21720Z for 942 West Randolph Street. And while we're getting that set up, I will read the department's recommendation on 21620S. The Department of Planning and Development recommends approval of the proposed outdoor rooftop patio to serve a proposed restaurant, provided 1, the special use is issued solely to the applicant 312 Spirited Ventures LLC, 2, the associated variation application 21720Z to reduce the required on-site parking from 12 to 0 spaces is approved, and 3, the development is consistent with the design and layout of the plans and drawings dated April 23rd, 2019, prepared by CBD Architects. Counselor, when you're ready, if you will identify your witnesses.
Sure. I'm Thomas Raines with the law office, Thomas R. Raines, attorney at law LLC, located at 20 North Wacker Drive. I have 3 witnesses today. The first one is one of the members of the applicant, 312 Spirited Ventures LLC, Mike Bisbee. He's also the operating partner of that venture. Their architect from CBD, Jeremiah Johnson, and Timothy Barton, who's a planner and also housed in this office.
Perfect. Mr. Bisbee, do you swear to tell the truth in this proceeding?
Got on mute, Mike.
There we go. Do you swear to tell the truth in this proceeding?
Yes.
Mr. Johnson, do you swear to tell the truth in this proceeding?
Yes.
Mr. Barton, you swear to tell the truth in this proceeding?
I do.
We recognize Mr. Barton's expertise. Go ahead, Counselor.
If it would please the board, I'll just do both. We have a special use and a variation to reduce the 12 on-site parking spaces.
Yeah,
so the applicant is before the board on 2 applications, one for a special use to allow an above grade outdoor patio. On the picture you're seeing there, it would be on the right portion of that building, kind of where the crane is hanging. That that will be a first floor restaurant with an enclosed second floor to the western portion of that building. The eastern portion and toward the street side of Randolph will be an outdoor patio, 1,850 feet. That's the request in terms of the special use. With respect to the variation, the applicant is seeking to reduce the required on-site parking from 12 to 0. This would qualify in the TOD. It is approximately 300 feet from the Morgan station. But since we were coming in for the special use, the department asked us to put both in the application. Would you like me to go to my witnesses at this point? Or we're trying to move it along.
Yep.
Mr. Bisbee, could you state your name and your address and your role with the applicant, please?
Michael Bisbee. Address is 169 West Huron Street, and I am a managing member of 312 Spirit Adventures.
Do you remember preparing and signing an affidavit in conjunction with my office that we filed with the board for this matter?
Yes.
If asked to testify today, would you testify consistent with that affidavit?
Yes.
Thank you. Nothing further from Mr. Bisbee. Mr. Johnson, could you state your name and address, please, for the board?
Jeremiah Johnson. My office address is 770 North LaSalle, Suite 801, Chicago 60654.
And are you the architect for this project?
Yes, I am.
And did you contribute to an affidavit and sign that affidavit that's been submitted to the board in these matters?
Yes, I did.
If asked to testify today, would you testify consistent with that affidavit?
Yes.
Thank you. Mr. Barton, could you state your name and your address, please?
Timothy Barton, 20 North Wacker Drive, Chicago.
And did you prepare a report that was filed with the board for this matter, for the special use?
Yes, I did.
And asked to testify today, would you testify consistent with that report?
Yes, I would.
Thank you. I have nothing further at this point. I welcome any questions from the board.
Any questions from the board? Okay, thank you. We'll take it under consideration.
Thank you.
Thanks.
We'll move on to 21820Z. This is at 2616 West Fullerton. And Counselor, I think you've got your one witness listed here. So when you're ready.
I think Tim was doing this. Tim, are you on? You want to come in here? I'm sorry. Tim was going to handle this.
I'm bringing Tim back.
You swap me out for Tim. Can you bring him back on?
He's in. He's a panelist.
Okay.
Tim.
And is Susie Rue on?
Yes.
She is?
Yep.
Okay. Good afternoon. My name is Timothy Barton. I'm the attorney with the office of Thomas Rains. I'm also the attorney for the applicant, Susie Rue. The owner here is seeking a variation to reduce the number of required parking spaces for a daycare business that she is putting in and at this address. The subject property is in a 14-unit mixed-use building, 14 dwelling unit mixed-use building. There are 15 parking spaces on the site, 14 of which are dedicated for the residential use. The applicant owns the one additional spot, the 15th spot. In the course of getting the building permit for, or seeking the building permit for the build out of the business, she was required to get a parking determination letter from the Department of Planning and Development, which she did. That parking requirement is for 2 spaces. She only has one available at the site, which is the reason now that she's asking for a reduction of one of the spaces. The one will be dedicated to her business. However, she cannot provide any more on site and does not have access to any other spaces in the neighborhood that could serve for off-site parking. So with that, I'd just like to introduce the witness or the applicant, Susie Rue. And if
Hi,
you're
my
there.
name is
Hi.
I'm Susie Rue. I own Willow Tree Childcare.
Let me
And
interrupt for 2 seconds. Do you swear to tell the truth in this proceeding?
yes, I do.
Okay, go ahead.
Great. And Susie, will you state your name and address for
Yes.
the record?
My name is Susie Rue. We're regarding 2616 West Fullerton Avenue, Chicago 60647.
And did you sign an affidavit relating to this case, which we then submitted to the board with our findings of fact?
Yes.
And that contained statements that if I were to continue questioning you today, would your answers be consistent with those statements?
Yes.
Mr. Chairman, the hardship here that we're addressing is the fact that basically the business cannot open unless this variation is granted for the one space.
Can you, for our applicant, can you talk a little bit about how you're going to operate with the one space? I mean, where employees going to park, et cetera. How are you doing? Because I think that's a drop-off space, right? You have two separate drop-off spaces.
Yes, we do. So we do have two drop-off spaces. I currently own Willow Tree Childcare on Western Avenue as well, and it's only a 2-minute drive away. So even with that, a lot of my staff members, because even over there, we don't really have an issue with parking as well, because there's free parking on the street. And a lot of my staff members take buses or the train, and the train station isn't actually too far off. I think we missed it by a few, few feet, Tim, for the CTA, the blue line.
Right.
So that was the reasoning why we didn't get approved for that either. But we walked it, and staff member said it's the same amount of distance just to walk from the blue line to the Fullerton location.
Got it. So the assumption is most of the employees are coming by CTA. Okay. Mr. Barton, anything else on your end?
We do have a letter from the West Bucktown Neighborhood Association supporting Ms. Rue's application. There's also a supporting letter from the Alderman's office that I believe were already submitted to your, or sent to the board office directly.
We do. We have that one as well. Any questions from the board? Okay, thank you. We'll take it under consideration.
Thank you.
Thank you.
We're gonna go to 21920Z for 2116 West 18th Place. Mr. Rains, is this one you again, or Mr. Barton?
This one's me.
Okay.
Tim again.
When you are ready, you've got Mr. Galilee and Mr. Das.
Great. Okay, thank you. Again, good afternoon. My name is Timothy Barton. I'm an attorney with the Office of Thomas Rains. I'm the attorney for the applicant here, Vladimir Galilee, sorry. We're seeking a variation for the required minimum lot area for three units on this site. I have two administrative matters at the outset here. One is the address of the property. It's listed on the board's docket as 2116 West 18th Place. We have a house number certificate that was issued subsequently for 2120 118 West 18th Place. The property has been listed on a number of city and county sites as 2116. However, there's now a house certificate that was issued by the Department of Transportation for 2118. And that's based on where the door will be. So the door is going to be on the west side of the property. So therefore it's now known as 2118.
Okay.
We have a second item, which is to modify the names, the name of the applicant on the EDSs, the economic disclosure statements. They were initially prepared for Vladimir Loglin. However, the applicant has subsequently changed his name and it's recorded on a naturalization certificate issued by the U.S. District Court. So we have sent those, I sent those this morning to the staff and would ask that they be, the record be modified accordingly.
And it's obviously the same person who changed his, it was listed as an individual. He changed his name through court proceeding.
That's right.
Okay. And you've already submitted.
Just one question, Mr. Chair. So the applicant is still Ashler LLC, but just the name of the.
On the EDS.
Okay. That's right.
All right. Thank you.
With him as the manager and the individual on the EDSs. Right.
Okay. Thank you.
Okay.
And Mr. Counselor, can you just clarify what it is that you submitted already? Was it the naturalization documentation or?
Submitted revised economic disclosure statements and a copy of the naturalization certificate.
That reflects the old and new name or just the new?
Well, it just has the new name.
Got it.
Okay.
Okay. I think we might want some kind of documentation if you have it that has both names.
Okay. Let me talk with the applicant further about that. Okay.
Okay, keep going.
The subject property, as you saw, was an empty lot. It's in an RT4 district. The lot is slightly substandard in size as opposed to a 25 by 125 foot lot. It measures 24 by 124. The difference is that with the current lot, it measures 2,976 feet. And in this particular case, in an RT4 district, a lot is required to have 1,000 square feet for every dwelling unit that you want to put on it. So in this case, the owner is looking to put 3 dwelling units on the site instead of the two that are allowed as of right. The code allows up to a 10% variation in the amount of land. Our request is something on the order of an 8% change in the minimum lot area. So we would need 3,000 square feet, but we only have 2,976. So today we have 2 witnesses. There's the owner, Vladimir Galilei. He's the applicant and the sole member of the LLC, Ashker LLC, which owns the property. And we also have Christopher Dassey, who is the project architect.
And Councilor, let me just confirm with you. So Mr. Galilei is the individual who changed his name.
That's right.
Perfect. I think then what we'll do, instead of dealing with more documentation, we'll just have him on the record confirm that he had changed his name and give us the old and new, so we don't have to deal with more paperwork.
Okay, that's good. Thank you. Vlad, are you there?
You're on mute.
Oh, Vlad, are you there? Can you unmute yourself?
Here we go.
I'm here now.
Perfect.
Okay.
Do you swear to tell the truth in this proceeding?
Yes.
Okay, go ahead, Counselor.
Vlad, for the record, can you state your name and address?
Vladimir Galilei, president of Esher LLC, AD 28 North Milwaukee Avenue, Niles, Illinois.
Thank you. Vlad, there's a question about the name, your name change. You had your name changed in a naturalization certificate with the U.S. court. Is that true?
Yes.
And you changed it from Vladimir Logan to Vladimir Galilei?
Correct.
Okay, thank you. We prepared an affidavit for your signature, which, did you review that?
Yes.
And sign such? We submitted that to the board along with the findings of fact. Let me ask you, if I were to continue questioning you today, consistent with those statements, would your answers be consistent?
Yes.
Thank you. Let me turn to Chris. Are you there?
Yes.
Hi. Can I take you through the same questions?
All right, Counselor, give me 2 seconds.
Sure.
Mr. Massey, do you swear to tell the truth in this proceeding?
I do.
Okay, go ahead, Counselor.
Chris, please state your name and address.
Christopher M. Dassey, 5930 Holman Avenue, Hammond, Indiana.
Thank you. Did you sign an affidavit relating to this case?
Yes, I did.
We submitted to the board. Let me ask you, if I were to continue questioning you today, would your answers be consistent with the statements in your affidavit?
Yes, they would be.
The hardship here, Mr. Chairman, is that the property was purchased for $150,000. The applicant has stated that the soft and hard cost to build 2 units here would be the land cost plus the cost of construction would be $910,000. An estimated sales price for 2 units would be $875,000, and therefore there'd be a loss of $35,000. If in fact he were able to build 3 units, he would be able to obtain a net profit of $95,000 for a 9.5% return.
Any questions? Okay, Council, unless you got anything else to add?
That's all.
Okay, we will take it under consideration. Thank you very much.
Thank
you.
We're gonna go to 220 and 221. This is for 1811 North Halsted.
Chairman, they're on.
Okay, Counselor, why don't you go through everything on this one just because of some of the filings that are taking place outside of this hearing?
Sure. Thank you very much, Mr. Chairman. I think before I proceed, I have a little bit of a curveball because those aren't my witnesses. It should be Nicole Rogic and David Genk. They were in my witness lists.
We have Nicole here.
I'm sorry, all I see, okay. Okay, fair enough.
I think we're just missing Mr. Genk. Why don't you start it?
Mr. Genk is in also. I think he dropped off earlier.
There he is. I think we just got him on.
We good?
Yeah. Why don't you
Okay. Okay, thank you very much. Again, thank you, Mr. Chairman. And again, in light of your comments, I know it's been a long day for everybody, but I would like to take these cases individually, so it's going to be slightly repetitive, but we'll try to get through things quickly.
Let's do it.
My name is Andrew Scott. I'm with the law offices of Dykema Gossett. I'm here on the behalf of the applicant, Nicole Rajic. That's R-A-J-I-C for the benefit of the court reporter. Also with me is David Genk with Hearst MPG Architects, and they're the project architects. The subject property is 1811 North Halsted Street. It is an approximately 28 by 131 foot lot. It is currently vacant and unimproved. And what you'll hear and what we'll talk about in terms of the elements of the hardship is that this is in a very densely populated part of the city, and more importantly, one of the really unique aspects of not only this property but also the block is that there's no rear alley access to the property, and it's such that the built environment doesn't allow any access to the rear of the property. There's nowhere to get an easement or any other means of ingress and egress. The project that we're proposing today is a single family home. One thing that you'll notice or that you may see in terms of the site plan, and you'll hear from Ms. Rajic, is that they actually own the home immediately in the far of that picture. They are 1810 North Burling, and they have purchased this lot, and their plan is to build a 4,600 square foot, 2-story single family home. And really what this is going to be is an extension of their home. It's going to be office space. It's going to be additional sleeping space for them and their children, guest space, and also additional parking. And because of the lack of alley that I had referenced, the access in order to be able to have a garage for the home must necessarily come off of Halsted Street. And I should also note, this is for the benefit of one of our neighbors, but in terms of the project, nothing that we're doing here, nothing that we're proposing is intended to affect any of the utilities that serve any of the properties in the surrounding area. I'd like to talk about, and if I could go into the relief for the driveway first, that's case number 221-20-Z. And the relief that we're seeking here is to have a driveway off of North Halsted Street. And the reason that the relief is required is that Halsted is a pedestrian street at this particular location. And you're under other circumstances are not permitted to have a driveway on a pedestrian street. So that's the basis of this particular request. Again, the hardship that we had presented is that there's no rear alley access and no other means because of the built environment to get access to the rear. So it necessarily has to come off of North Halsted Street. I should also point out, and I mentioned it earlier, this is not being developed for spec purposes. This is going to be for the Rajic and their family. They're not building this with an eye towards selling it anytime soon. It's going to be for the use of their families, friends, guests, and folks of that nature. We have met with our immediate neighbors, and I believe they should be in the record. A letter from the neighbor to the south at 1801 North Halsted, a letter of support. We'll talk a little bit about the concessions that we made in order to get his support. Our neighbor to the north at 1815 has also expressed their support. We met with the Lincoln Community Association, LCA, had a lot of back and forth with them, and ultimately they are supportive that that letter should be in your package as well. And finally, while I realize it may be a little bit beyond the 3-day notice requirement, there was a letter that was submitted to staff earlier today from Alderman Smith expressing her support for the project. With that, I would like to call my witnesses, unless there are any immediate questions from the members.
No, go ahead.
Okay, thank you. First witness I'd like to call is Nicole Rajic. Nicole, are you there?
You're on mute. And
I'm here.
Before we go further, do you swear to tell the truth in this proceeding?
Yes.
Okay, go ahead, Counselor.
Nicole, could you state your name for the record, please?
I'm Nicole Reich.
Okay, and your address is?
My address is 1810 North Burling, Chicago 60614.
Thank you. And I prepared an affidavit of testimony for you, and you've reviewed that affidavit of testimony and you executed it as being accurate and complete. Is that also correct?
Yes.
And if you were called upon to testify today, would you testify substantially in accordance with your affidavit?
Yes.
Thank you very much. I'd like to call David Gang. David, you on?
Yes,
Do you swear to tell the truth in this proceeding?
I do.
Go ahead, Counselor.
Thank you. David, you're the project architect for this. Is that correct?
I am.
And you're licensed in Illinois?
I am.
And I'm sorry, could you just state your name for the record and your business address?
Yes, my name is David Gentz of Hirsch MPG, and our business address is 225 West Hubbard Street, Chicago, Illinois.
Thank you. And you're familiar with the plans for the project and the property and its condition?
I am.
And I prepared an affidavit of testimony on your behalf. You've reviewed it for accuracy and completeness, and you signed it. Is that correct?
Yes, it is.
Okay. And if I were to call upon for you to testify today, would you testify substantially in accordance with the substance of the affidavit that I prepared and that you executed?
I would.
Thank you very much. Mr. Chairman, we have nothing more with respect to 221-20-Z. If there are any questions, we're available to answer them.
Any questions from the board on 221? Okay, let's keep going.
Thank you. Turning to case number 220-20-Z, as I mentioned, with me today is Nicole Roderick, the applicant, and David Gang from Hirsch MPG Project Architects. My name is Andrew Scott with the law offices of Dykema Gossett. The subject property here is 1811 North Halsted. It's a 28 by 131 lot. It's vacant. Again, this is a very densely developed part of the city, and that's one sort of semi-unique character. There's not a whole lot of open space in the area, and the other consideration here, as I mentioned in the earlier case, is that there is no rear alley that allows access to a garage, which necessarily means that the garage needs to be located towards the front of the property. What we're proposing to do today is develop a single family home, which would be an extension of the primary home of the applicant, which is located immediately to the east. It would provide guest space, office space, recreational space, guest space. And again, as I mentioned, it's just an extension of their primary home. It'd be approximately 4,600 square feet, 2 stories. And as I mentioned, the garage is located towards the front of the property because there is no rear alley access. The relief that we're seeking in this particular case is a north side yard variation of 1.17 feet instead of 2.24 feet, which is required, and a combined side yard of 3.41 feet instead of 5.6 feet. I want to confirm, Mr. Chairman, before we go on, I did submit a letter. I submitted it on a timely basis to your attention on June 16th, in which we withdrew our request for the south yard relief, and I want to make sure that that's incorporated into the record.
Yes, we have it.
Okay, thank you.
Request for the north side setback and the rear yard setback, right? Is all that you have.
That is correct. Yes, that is correct. In addition to the side yard setback, we're also seeking rear yard relief to be allowed to have a rear yard of 32 feet 9 inches instead of the required 37 feet 2 inches. And the purpose of that is to accommodate a second floor balcony. Just want to talk about both of the relief that we're seeking. In terms of the north side yard, I think largely the reason it was acceptable to the neighbor to the north is because he is already set back 3 feet 1 inch from his property line. So there's already a good space between the north side of this proposed home and the existing building, which exists to the north. And then in terms of the rear yard relief, the only reason that we're seeking relief right now is because they have done wing walls on the north and south sides of the balcony. And I don't know if it's possible to do the rear elevation, but if we had left this rear balcony open, we wouldn't need relief. It would be a permitted encroachment. There we go. So you've got the solid wing walls on either side, and really the purpose of those was to afford privacy not only for the applicant and their family, but also to give some privacy to the neighbors to the north and the south. So again, if we had left them open, it would be a permitted encroachment. We wouldn't be seeking relief, but it was only because, as I had mentioned before, It's a pretty dense part of the city, people living very close to each other, and privacy, actually it comes at a premium. Again, and I apologize to repeat, but our neighbor to the north at 1805 and 1815 have both expressed their support. The local community organization, LCA, has expressed their support. Alderman Smith, a little bit not timely, has advocated.
I apologize. This is the court. But are you cut out a little bit, sir? You said Alderman.
I'm sorry, Alderman Smith,
Thank you.
Ward 43, has sent a letter of support to the Zoning Board of Appeals staff. So we've really worked with the community and our immediate neighbors to try to get to a project that everybody's comfortable with. And I should point out that we were able to secure the support of our neighbor to the south because we had originally sought the south side yard relief. But in order to accommodate concerns that were raised by that neighbor, we ended up sort of redesigning the building just a little bit to be able to get to the 2.24 required setback. So again, just sort of evidence of working with the community and concessions in order to be able to put together a project that everybody's comfortable with. Again, this home is going to be for the applicant and their family, their invitees and guests. It's not being sold with an eye towards resale or flipping or specking or anything like that. It's going to be for their personal use. In terms of returns, when it's for your own use, really what we're talking about here is it's not a return on investment. It's not trying to get the dollars back, but this is really a lifestyle return and a utility return. And the reason that we're seeking the side yard relief is that in order to be able to accommodate a reasonably sized garage in the front that's going to be able to handle vehicles and a little bit of storage, particularly vehicles of the size today that that they have for their family, and also to have a regularly sized main entrance off of the west side of the property in order to be able to access. We needed that just a little bit of extra space in order to accommodate both of those elements in the front. And again, that was having the garage up front was driven because there is no alley access to the rear. If there are not any questions, I'd like to call both of my witnesses.
Sorry, Councilor, I do need you to clarify. You lost me a little bit on the actual hardship and what was the bit about the ring wall? Like, will you just try and crystallize a little more clearly what the hardship is and what is the connection between the hardship and the gym?
Sure. Okay. Can we go to the site plan, please, Jeanette? Perfect. So again, as I had mentioned, the main hardship that we're confronted with here is that there is there's no rear alley, no rear means of access. So we necessarily have to put the garage towards the front of the building. Okay. And so in order to be able to accommodate two vehicles that can, safely and efficiently move in and out, we needed relief on the north side yard in order to be able to accommodate a reasonably sized garage and also a nice accommodating front yard or front entrance to the building. So that's the driver, that's the hardship, and also the driver as to why we need the relief. Does that make sense? There is no connection at all. We're not seeking any relief with respect to the indoor gymnasium and basketball court. That has to do with, there's no connection. I mean, the fact of the matter is that on the second floor here, they do have a gymnasium and a basketball court. They've got young children, and this is an opportunity for them to have recreational space. And they just happen to be able to accommodate it on the second floor as part of this single family home.
Okay.
All right.
Same issue with the alley is what's driving the both, I guess, the rear and the north. The north side is, I guess, for turning or something, and then the rear yard setback is because you have...
the only issue with the rear yard setback is because we have the wing wall, the privacy wing walls on the balcony, which makes it, if it's enclosed on two sides, that makes it a non-permitted encroachment in the rear yard. If we had just simply left it open, if it was simply a balcony that had three open 4-foot high fence, we wouldn't be talking about rear yard relief. So the real reason for the rear yard relief are the wing walls, and the wing walls are there because, again, neighbors living on top of each other. And so the hardship there is just trying to introduce another element of privacy into city living.
And so those ring walls are the attachment that's surrounding the second floor balcony only.
That's correct. Yes.
Okay.
Yep.
Got it. Okay.
It's a little bit hard to see again, if we were to go to the elevation, see if there's a better shot. Yeah. So you could see, I'm sorry, to your left and your right, the gray poles going up and down, those are solid. That door, yeah, right, exactly, right there, that's a solid wall. And on the other side, it's a solid wall as well.
Got it.
And in between, it's open. So if we hadn't done the solid wall, if we had left those two sides open and, you know, our neighbors could see us outside, they could, we could see them, we wouldn't be asking for relief.
Got it.
Okay.
And the basketball court is entirely enclosed in the second floor, or is that a
That is
roof
correct. Yep.
part of the second floor? Okay. Okay. Any questions from the board so far? Okay, why don't we continue with your witnesses?
Okay, thank you very much. Nicole, if you could again state your name for the record and your address.
Nicole Reich, 1810 North Berlin, Chicago, Illinois, 60614.
Thank you. And you are the applicant in this case, is that correct?
Yes.
And you're familiar with the property?
Yes.
And I prepared an affidavit of testimony on your behalf. You've reviewed it and to confirm that it's accurate and complete, and you've signed it, is that correct?
Yes.
And if you were called upon to testify today, would you testify substantially in accordance with your affidavit?
Yes.
Thank you. David, if you could state your name, business, and address for the record, please.
Yes, my name is David Gens of Hirsch MPG, the architect of the project, and our business address is 225 West Hubbard, Chicago, Illinois.
Thank you. And you're a licensed architect in the state of Illinois?
Yes, I am.
And you're familiar with the plans for the subject property and the property itself?
I am. Yes.
Okay, thank you. And I also prepared an affidavit of testimony on your behalf. You've reviewed it for accuracy and completeness, and you've signed it. Is that correct?
Yes.
And if I were to call upon you to testify today, would you testify substantially in accordance with your affidavit?
I would, yes.
Thank you very much. Mr. Chairman, we don't have anything further. If we're happy to answer any questions.
Can you just clarify for me, going back to the rear setback and the what you refer to as the ring walls, is the hardship argument on that is privacy, or is it still related to the lack of alley access in some way?
It is, well, we've got a number of elements going on because we have we've got a very busy front, North Halsted Street, and we've got neighbors that line both north and south. So, and the proximity of those neighbors is also a driver in terms of why, why we are enclosing the walls, and simply the deck itself is, it's an additional element of privacy in the area. If you were to look at the city's open space impact fee ordinance, it's already designated Lincoln Park as an area that's deficient in terms of open space. So anything that can be done to provide for additional open space is certainly helpful to individuals and take stress off of other public resources. So again, the lack of open space in the area is, in part, one of the hardship drivers as to why we've got a deck here.
Okay, and Joanna, I noticed Joanna from Alderman's office is on the line. Did you have anything you wanted to add?
I do, Chairman. Thank you. This is Joanna Zaiden, Alderman Smith, Director of Zoning and Urban Development.
Sorry, before you go, do you swear to tell the truth in this proceeding?
Yes, I do.
Perfect. Go ahead.
So the reason why I wanted to speak here is that we submitted our letter for the record, but a little past the deadline. So the Alderman asked me to join the meeting to read our letter into the record and explain the reasons for our support, and maybe Andrew could explain a little bit longer on, express further information on what the negotiations were, both with our office and Lincoln Central Association. So I'll be brief. I'll just read this pretty fairly. Dear Chairman Perrin, my office has worked with representatives of Nicole Rage and property owner of 1811 North Halsted and the applicant for the following variations before the Zoning Board of Appeals. I will not repeat the variations.
I apologize. This is the court reporter. Can you just please slow down for me?
Okay, I'm sorry. I have reviewed the plans for the proposed project, as has Lincoln Central Association and the adjacent property owners. Through this review process, the applicant has made changes to the original plans to address concerns related to the impact of the proposed project would cause on the adjacent properties to the south and their ability to perform maintenance works due to reduced distance between the structures. On the revised project presented to the community on June 9th of 2020, the south side setback will meet the minimum side of 2.24 feet required by code. And I'm interjecting here on my own letter that I wanted to double check with Andrew because he was cutting off a little bit. And I wanted to double check that the plans that were submitted to ZBA today do reflect this change. But I'll continue here and I'll let him get to this later on. Furthermore, the applicant has agreed to sign a restrictive covenant prohibiting the use of the property for short-term rentals. This is one of the concerns from Alderman Smith. There is a lot of concerns from neighbors that this being used as a recreational space could be rented out for, small parties and things like that as a short-term rental. So we wanted to make sure that they agreed to that. Andrew spoke with his client and they agreed to sign it off. The document is not ready yet, but I wanted to make sure we have on record that both, maybe his client could speak to that as well and make that reassurance to us. So as a result of the revisions, Lincoln Central Association, as well as two of the property owners adjacent to this project have expressed their support to this project and the zoning reliefs. I appreciate the applicant's willingness to work with the community and my office to address the concerns raised and efforts made to reach a suitable compromise. I support these variations applications before the Zoning Board of Appeals, conditioned to the signature of the aforementioned restrictive covenant. Thank you.
Counselor, did you want to respond on one of those questions?
Sure, I think she actually raised 2 points. First, yes, Joanna, the plans that were submitted for consideration by the board reflect the 2.24 south side yard setback. So that's been addressed. And yes, I can confirm that the applicant is willing and will sign a restrictive covenant prohibiting the use of the property as for any kind of short-term rent, for any kind of shared housing unit for so long as they own the property.
Thank you. That's all. Chairman, thank you for allowing me to speak.
Any other questions from the board? Okay, thank you. We will take it under consideration.
Thank you very much. Have a good weekend, everyone.
You too.
Thank you.
Next up is 22320S. While we're getting set, I'll read the department's recommendation. The Department of Planning and Development recommends approval of the proposed liquor store, provided the special use is issued solely to the applicant Garfield Beverage Warehouse LIN LLC, and the development is consistent with the design and layout of the plans and drawings dated June 26, 2020, prepared by ATS Companies.
Hello, this is Rich Toth. Hopefully I can be heard.
You can. Go ahead, Councilor.
Thank you. Good afternoon, Mr. Chairman and members of the board. My name is Richard Toth. I'm an attorney at the law offices of Daly and Georges, with offices at 20 South Clark Street in Chicago. Not long ago, I was the first one on the agenda, so I knew at some point I'd be the other bookend here. So I'm bringing up the rear today. In doing so, I'm appearing on behalf of the applicant Garfield Beverage Warehouse LIN LLC. The application is for the property at 3200 North Lincoln Avenue for a special use for a Garfield's Beverage Retail Liquor Store. The property is in a B3-3 community shopping district at the intersection of Lincoln Avenue, Belmont Avenue, and Ashland Avenue. The business will occupy the ground floor of an existing building. There'll be no significant or no exterior changes to the building, just interior renovations. The ground floor space is approximately 2,700 square feet. And we understand that that space has over time been dedicated to commercial uses. The applicant's principals are experienced liquor retail store operators whose multi-generational family-owned and operated business has been operating since 1951. They currently have 6 successful locations, including sites in Norridge, Palatine, Barrington, Crystal Lake, and 2 locations in Chicago's Wicker Park neighborhood. Their businesses focus on craft beers, specialty wines, and small batch spirits. For a bit more background, in 2019, Garfield's Beverage was recognized by an industry association as one of the top 100 beverage alcohol retailers in America. 2018, it was recognized as a retailer of the year. The applicant presented its proposed business to the Lakeview Chamber of Commerce. We received that group's letter of support that was included with our findings of fact. The applicant also presented to the West Lakeview Neighbors Group, which indicated that it was supportive of the project to the alderman. Alderman Martin also provided a letter indicating he's got no objection to our proposal. I know that letter was sent directly to the board by him, by his office. So present with me this afternoon is an applicant owner, David Garfield, also the company's, the LLC's manager, Adam Silverstein, and our expert witness, appraiser Terry O'Brien, who has prepared a report on the special use criteria that's also included in our findings of fact. If permitted, or if you want to swear the witnesses first, I'm going to start with David Garfield.
Yeah, let me just swear everybody in. Mr. Garfield, do you swear to tell the truth in this proceeding?
Yes.
Mr. Silverstein, you swear to tell the truth in this proceeding?
Yes.
Mr. O'Brien, you swear to tell the truth in this proceeding? Mr. O'Brien, are you with us? You're on mute. Mr. O'Brien, you got to unmute yourself. You swear to tell the truth in this proceeding? Okay, while Mr. O'Brien figures that out, why don't we keep going, Counselor?
Very well, thank you. Mr. Garfield, can you please state your name and your business address?
David Garfield, 4601 North Harlem, Ridge, Illinois.
You're an owner of the proposed business that we're talking about today, is that right?
Yes.
And you're familiar, of course, with the subject property and the surrounding area, also with the proposed operations and uses for the subject property, is that correct?
Yes.
I just provided a description of the property. Was that description accurate?
Yes.
The site will be internally renovated and operated in conformance with submitted plans, is that right?
Correct.
I also provided a description of the proposed business and the proposed uses of the subject property. Was that all correct?
Yes.
I'd ask just in a sentence or two, can you provide a very short background of your families and your experience and history in this business?
Sure. My grandfather started in 1951. My uncle was involved till about 2000. When I got involved, we bought him out, and he runs a co-op. And it's my father and I now. And yeah, we have 6 stores and we're expanding, and that's a short summary for you.
Okay, perfect, thank you. You've got 6 successful locations, is that correct?
Yes.
I'll just mention as an aside, during the sort of recent protests and unrest, you had some unfortunate impacts on your 2 Wicker Park stores, is that correct?
That's correct.
In a few words, what happened there?
Actually, well, 2 of them got broken into on Saturday night, and Sunday night one was looted. Really bad, actually. We were closed the whole week, and 5 broken windows, coolers, lost quite a bit of product, and yeah, it was pretty devastating.
Okay,
But we've managed to, we got a great crew, got everything back together and back up and running now.
So you're dedicated to Chicago, and certainly that's not discouraging you from pursuing
Absolutely.
this. And of course, normally you've got calm, customer-focused, and neighborhood-friendly operations. Is that right?
Absolutely.
And this business will be operated in a similar manner to your stores. Is that correct?
Correct.
Okay. You'll have all licenses and meet all regulatory requirements subject to the special use. Is that correct?
Absolutely.
You were able to review our proposed findings of fact submitted in this case, Mr. Silverstein's affidavit and the expert witness report. You found them all to be true and accurate. Is that right?
Yes.
And if called upon to testify further, would you testify in accordance with all those materials?
Yes.
Okay, unless there's further questions, I'll proceed to our next witness, Mr. Adam Silverstein.
Let's keep going.
Adam, could you just please state your name and your business address?
Adam Silverstein, 4601 North Harlem Avenue, Norridge, Illinois, 60706.
Okay, you're the manager of the operations that we're talking about today, is that right?
Correct.
Everything we've said and that Mr. Garfield has said is that correct?
Correct.
You were kind enough to submit an affidavit in support of this application. That affidavit is correct. Is that true?
Yes.
You also reviewed our proposed findings of fact submitted in this case and the witness report and found them to be true and accurate. Is that correct?
Correct.
And if called upon to testify further, would you testify in accordance with the affidavit, findings of fact, and expert witness report?
Yes.
Okay. Unless there are any questions, I can proceed to our last witness, Mr. O'Brien, who's hopefully on the scene.
I hope, can I be heard?
Yeah, Mr. Bryan, do you swear to tell the truth in this proceeding?
Yes, I do.
And we recognize your expertise. Go ahead, Counselor.
Thank you.
Okay, thank you for that, Chairman. Mr. Chairman, Mr. O'Brien, can you please state and spell your last name and your business address?
Terrence O'Brien, O''B''R''I''E''N. Maintain offices at 7383 North Lincoln Avenue in Lincolnwood, Illinois.
Your submitted resume is accurate. You're familiar with the property, the surrounding neighborhood, and the application in this case. Is that correct?
That is correct.
You were helpful in that you prepared a written report on the property and the proposed uses. Does it accurately present your professional opinions?
Yes, sir.
Your report analyzes the approval criteria for special uses and concludes, I think, that the proposed operations will meet those criteria. Is that correct?
That is correct, yes.
And if called upon to testify further, would you testify in accordance with that report?
Yes, I definitely would.
Okay, and then just very succinctly, could you just affirm that it is going to meet the criteria?
Yes, more specifically, I did address all the criterias in the ordinance for special use located on pages 3 and 4 of my report. I did address those various criterias, and then on the last page of my report, I spoke about the conclusions and benefits that the proposed special use would have if it was granted. It'll provide employment opportunities, fulfill a need, provide the additional sales tax revenue to the various taxing bodies. And in my opinion, it is harmonious and compatible with other land uses in the area, will have no adverse impact upon surrounding property values.
Thank you, Mr. O'Brien. That concludes our witness testimony. Of course, we're happy to answer any questions, but if there's none, we'll ask that you grant approval of the special use, and we thank you for your time.
Any questions from the board?
Yeah, so quick question. I know you said that you had expressed or support expressed from the alderman, the neighborhood association, and the Chamber of Commerce. Did any of them write a letter? Am I just missing it in my materials, or was that all verbally? Or
No, I'm happy to say it's not, of course. In our findings of fact, there is a copy of the letter of support from the Chamber of Commerce.
Okay, so Chamber of Commerce.
There was also the community group responded directly to the alderman. That's their procedure and his procedure. So they responded again in a supportive way. And the alderman did provide a letter indicating he's got no issues or objections and was very complimentary to the client about their participation in the community process. That letter was sent directly from the alderman's office to Victor Reza and his team at the Zoning Board of Appeals.
Okay, got it.
Any other questions from the board? Okay, thank you. We'll take it under consideration.
Thank you.
Thank you.
Thank you.
I move that we convene in the closed session pursuant to Section 2C4 of the Open Meetings Act for the purpose of considering the evidence and testimony presented in open session. For those viewing by live stream, we will return from our closed session, and the live stream will continue at that point. Commissioner Toya seconds. Commissioner Saul?
Yes.
Commissioner Knudsen?
Aye.
Commissioner Toya?
Yes.
Chair votes aye. We will recess into closed session.
Okay, Chairman? Oh, he already said, that's okay. That's okay.
Yep, I'm still here.
Oh, no, just, like, probably like 10 minutes, right, or something?
Yeah.
Okay, great, thank you.
I'll wait for you.
I'm here.
Great. I move we return to open session. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yep.
Commissioner Toya.
Yes.
Chair votes aye. We are back in open session. We will now vote. Note that any motion to approve a special use will be tied to the recommendations of the department and any additional conditions read by me. I move to affirm the decision of the zoning administrator on board calendar 12120A. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is affirmed. I move to approve board calendar 18120Z, 18220Z, and 18320Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. Those matters are approved. I move to approve 18420Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 18520Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 18620Z, 18720Z, 18820Z, and 18920Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. Those matters are approved. I move to approve 19020Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 19120S. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 19520Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yep.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 19620Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 220S and 20120S. Commissioner Toya seconds. Commissioner Saul.
Yes. Yes. Sorry.
Commissioner Knudsen. Commissioner Knudsen.
Yes. Yes.
Commissioner Toya.
Yes.
Chair votes aye. That those matters are approved. I move to approve 20220Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 20320Z and 20420Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
I vote aye. Those matters are approved. I move to approve 20520S, 20620S, and 20720S. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. Those matters are approved. I move to approve 20820Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 20920Z and 21020Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. Those matters are approved. I move to approve 21120Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 21220Z, 21320Z, and 21420Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. Those matters are approved. I move to approve 21520S. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 21620S and 21720Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. Those matters are approved. I move to approve 21820Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 21920Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 22020Z. Commissioner Toya seconds. Commissioner Saul.
No.
Commissioner Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 22120Z. Commissioner Toya seconds. Commissioner Saul.
Yes.
Knudsen.
Yes.
Commissioner Toya.
Yes.
Chair votes aye. That matter is approved. I move to approve 22220S. Commissioner Toya seconds. Commissioner Saul.
Yes.
Commissioner Knudsen,
Yes.
Commissioner Toya.
Yes.
Chair votes aye, that matter is approved. I move to approve 22320S. Commissioner Toya seconds, Commissioner Saul.
Yes.
Commissioner Knudsen,
Yes.
Commissioner Toya.
Yes.
I move to approve chair votes aye on 22320S. That matter is approved. I move to approve 22420Z, 22520Z, and 22620Z. Commissioner Toya seconds, Commissioner Saul.
No.
Commissioner Knudsen,
Yes.
Commissioner Toya.
Yes.
Chair votes aye, those matters are approved. I move to approve 16020S. Commissioner Toya seconds, Commissioner Saul.
Yes.
Commissioner Knudsen,
Yes.
Commissioner Toya.
Yes.
Chair votes aye, that matter is approved. I move to approve the written resolutions containing findings of fact consistent with the votes of the board for the board's May 15th, 2020 regular meeting, which meeting was the rescheduled meeting of the board's March 20th, 2020 regular meeting. Commissioner Toya seconds, Commissioner Saul.
Yes.
Commissioner Knudsen,
Yes.
Commissioner Toya.
Yes.
Chair votes aye, that motion carries. I move to approve the written resolutions containing findings of fact consistent with the votes of the board for the board's June 5th, 2020 special meeting, with the exception of board calendar number 5520Z. Commissioner Toya seconds, Commissioner Saul.
Yes.
Commissioner Knudsen,
Yes.
Commissioner Toya.
Yes.
Chair votes aye, that motion carries. The proposed amendments to the rules of procedure of the board that I previously discussed have been distributed. If there are no corrections to the proposed amendments to the rules of procedure of the board, I move that we approve the proposed amendments and reissue the rules of procedure of the board as distributed. Commissioner Toya seconds, Commissioner Saul.
Yes.
Commissioner Knudsen,
Yes.
Commissioner Toya.
Yes.
Chair votes aye, that motion carries. The proposed supplemental rule for cannabis business establishments governing the conduct of cannabis business establishment community meetings during the COVID-19 public health emergency that I previously discussed has been distributed. If there are no corrections to the proposed supplemental rule, I move that we approve the issuance of the supplemental rule as distributed. Commissioner Toya seconds, Commissioner Saul.
Yes.
Commissioner Knudsen,
Yes.
Commissioner Toya.
Yes.
I vote aye, that matter is approved. Now that both have been approved, please, for everybody, sign both, and with respect to the rules of procedure, date and then send to our counsel Francis so she can compile all the signatures for posting on the city's website. I move that we adjourn the meeting. Commissioner Toya seconds, Commissioner Saul.
Yes.
Commissioner Knudsen,
Yep. Agreed.
Commissioner Toya.
Yes.
Chair votes aye. We are adjourned. Thank you very much, ladies and gentlemen.
Thank you.
Thank you.
Thanks, guys. Thank you.